the lordship. There are three commercial suits and two non-commercial suits between the same party. The lordship kindly sees the order passed by your lordship in the commercial suit. It is lordship. The lordship kindly sees the order passed by your lordship.
Where is the full order? Where is the second sheet of the order?
Oh, my lord, I am extremely sorry, my lord. I am extremely sorry. It is in the lordship. I am extremely sorry, my lord. Second page is here.
Yes.
My lord, what I was wanting, since the other side is not here,
Yes.
my lord, I've given notice. There are two non-commercial suits. It has been, my lord, pursuant to the order passed by your lordship, these three commercial matters have been assigned before Justice Arindam Mukherjee as direct, as from your lordship. Now, what I was wanting, let the two other non-commercial suits appear in the list next Wednesday or Thursday, subject to your lordship's approval. Let them be released, because that also has been heard a number of times. Orders are here.
Give the number.
My lord, may I give a copy of the notice?
Give the not notice. Give the number of the cases.
Yes,
It will be listed on Wednesday as to be mentioned. Then
very
you inform the other side also.
My lord,
Yes.
my lord, kind leave me lord to mention it's a listed matter, item number 19. My lord, I find my lord, there is my lord, huge number of fixed matter today. My lord, I intend to move this application ex parte because it's a part 19 new motion. My lord, it's a huge, my lord, I find my lord, there are 12 p.m. onwards, my lord, there are fixed matters, my lord. My lord, I am intend to move it ex parte because my lord, it's a suit, my lord, seeking partition, and my lord, I'll be seeking an order of status in a partition suit. Now, my lord, if my lord, it is reached, my lord, before 12, my lord, nothing like it. But in case it is not reached, my lord, kindly give me 5 minutes at 2 p.m. my lord, when my matter is fixed. My lord, I request Mr. Drolia to give me 5 minutes so that I can move at 2 p.m. or my lord, we can done with it. Because otherwise, if it's keep pending in the list, my lord, my endeavor will be made infructuous.
See, we'll reach it. So okay.
Yes. Otherwise, I'll request Mr. Drolia to give us 5 minutes out of the time.
Yeah.
My lord, I render unqualified apology for again bothering my lord.
No, yes, sir.
My lord, what is there, my lord? Yesterday, my lord, that matter was supposed to appear today, but it was my misunderstanding, my lord. My lord, we are just wanting that until and unless the plaintiff is presented, it is honest in the eyes of law. So, my lord, let me, my lord, satisfy my lord on any day, whichever, so that, my lord, even if we are undertaking until unless the plaintiff is born, my lord knows, my lord, I cannot do anything. No, nothing can be done. And, my lord, as far as the admission of plaintiff is concerned under clause 12, my lord, for that, my lord, I have to satisfy, my lord, under Oro 5 rule 1 and other. So, my lord, any day, 5 minutes, my lord, if my lord gets his list for presentation of plaint, my lord, next week, any day, my lord, because, my lord, I am unable to present my plaint. If I am unable to present my plaint, my lord,
No, you can present, but with regard to the addition of party, that's
my lord, in my respect,
have you prepared an
Yes.
application?
my lord, I have got, my lord, I have prepared myself both ways, my lord. First, on the issue that until unless my plaint is presented, it is non-est. So even if my client is so advised to carry out any amendment or if so advised, then also if the plaint is not presented, it is not admitted.
If it is that's why.
And, my lord, I cannot
That's
even
why-
file an application because, my lord, until unless, even if my client is so advised, my lord, even if the plaint is, till the time the plaint is not presented, my lord, in my injunction application is also non-est. Any other application is also non-est because, my lord, will first have to satisfy my lord about clause 12. When clause 12, I satisfy my lord, and regarding presentation of plaint, what is imbibed in the CPC as well as the latest patent, my lord. If I satisfy on that point, my lord, then, my lord, then the other point comes, my lord, that is order 1 rule 9, non-joinder or misjoinder.
Monday, Tuesday, the commercial.
My lord, whatever, my lord,
Now, if you want that,
My lord, whatever my lord, whichever day my lord deems fit and proper, my lord.
Then it will be my Wednesday.
I'm grateful, my lord. My lord, I'm handing over the slip to my lord.
Wednesday.
I'm in debt. I apologize, my lord.
No
bothering my
problem.
lord.
May I have your lordship's kind leave to mention item number 59 to 64 of today's list, my lord. It is likely to be taken up. Your lordship, my lord, takes this in the second half. It's an adjourned motion, my lord.
59
To 64. My lord, it's likely to be taken up. I am in some personal difficulty, my lord. I've take my son for his college admission outside Calcutta, my lord. My lord, if your lordship permits it to be
Yeah.
taken up on, my lord, Gujarat, my lord.
Yes.
Yes.
59 to 62.
64, my lord. If
Who
you,
is for the other side?
my lord, I shall inform him, my lord, that Mr. Shuddha Shatto Banerjee was appearing. I'll inform him.
Okay, you
And
inform
Mr. Thakkar is there. I shall tell Mr. Thakkar. And my lord, tomorrow 2 p.m. fixed matter is also mine, my lord. Mr. Bhattacharya is on the other side.
59 to 64.
Yes, my lord.
Yes.
Meet appear on Tuesday, my lord. That's the next day, my lord. Wednesday, my lord. That's the next day. And my lord, tomorrow 2 p.m. my lord is also, my lord. We shall ask for an adjournment tomorrow, my lord, when it
Which
comes
one?
up. It's a 2 p.m. fixed matter. Meera Dhanuka. It's not in the list. My lord, Mr. Bhattacharya is on the other side. I shall inform him. He will not object. In fact, both
What
of
is
us.
this hearing?
Yes, my lord. Both of us went to college together.
Okay.
So, my lord, there is no difficulty.
Your Lordship, may I have your kind leave to mention suit 126 of 2023, non-commercial, Your Lordship. It was appearing yesterday as item number 40, Your Lordship. However, it seen, Your Lordship, it is not listed today, Your Lordship, for some reason.
Huh?
Yes, Your Lordship. Ramji Lal Agarwal versus Saurav Agarwal. As per Your Lordship, last order, it was supposed to be listed yesterday, it was.
Why? Why it is going out of this? Why? Who is there in the CI system? How it is happening? With the list, the court has not
Your
told
Lordship.
how they are taking out the matter from the list. And then global system, close down the global system, go with the manual system. I am not on that. Call the person how this has been listed.
Lordship, if I
properly.
may indicate one more thing, Your Lordship. On the last occasion, my
If
senior.
it is then, and then let them do the manual. From my list, no matter should be deleted without the order of the court. I will not spare anybody.
Subject to your convenience of Your Lordship.
What is the matter?
Your Lordship, this is with regard to a suit for specific performance of a negative covenant, Your Lordship. On the last occasion, Your Lordship, this matter was heard by Honorable Justice Arindam Mukherjee. We had filed a GA1 application for injunction, and they have filed a demurrer application for the rejection of plaint. Both the application was extensively heard. However, Your Lordship, due to change in determination, Your Lordship, this
For
court.
the other side.
Your Lordship, I'm up here.
Yes.
Your Lordship. Your Lordship, there's also Supreme Court direction in the matter. So if the matter may be
It is a commercial matter.
Non-commercial, Your Lordship.
Commercial. It is a hearing. What is the application for?
GA1 application is my application for injunction, which I'm already enjoying one order in that, Your Lordship, wherein they are every month they are supposed to submit their accounts, which they are already till the disposal of the suit, Your Lordship. Now they have filed their affidavit in opposition, Your Lordship, along with one demurrer application, which is GA number 2, Your Lordship.
They filed demurrer.
Yes, Your Lordship. I'm being led by Mr. Sub.
Pleading completed.
Yes, Your Lordship. Pleadings have been completed.
Give the number.
Yes, Your
This
Lordship.
Tuesday, Wednesday.
Much obliged, Your Lordship.
Lordship,
Yes.
may I be permitted to mention item number 72 of your Lordship's list for
70?
upgrade. 72.
Yes.
Your Lordship, for upgradation, the pleadings are complete. It's an injunction application.
Hmm.
Lordship, the pleadings are complete any day convenient to your lordship, maybe it may be fixed because the respondents, your lordship, my instructions are the respondents are taking steps to dispose of their assets.
Hmm.
Pleadings are complete in the matter,
Hmm.
any day convenient to your
Push
lordship.
for the other side.
Lordship, my learned friend is.
It is not, allegation is not correct anyway, whatever my line of friend. If it's not.
No, I am not
Fix
upgrading.
it 18th if it is convenient to your lordship.
Let it be in the list. We'll see how far the court can go. Then we'll see to that. Yes.
Lordship,
Next.
grateful, your lordship.
And
My lord, may I mention, my lord?
Yes.
Item number 11, my lord. On the last occasion, your lordship directed me to serve copy upon the respondents upon whom the service has returned back.
Hmm.
My lord, again, we have made the fresh service on those two respondents,
Hmm.
but again, it has been returned back.
Hmm.
So, my lord, kindly adjourn it for a week. I shall find out
Which
alternative
matter?
address.
It is not
Item
listed.
11.
Let the matter call. We'll see to that.
And my lord, there's another matter specially fixed. Sanjay Junjunwala. My lord, before 2 I can do, my lord. After 2, I have got a fixed matter before my lord Justice Sampa Sarkar, my lord. I'm on legs.
Whether it is fixed matter.
No, it is appearing under the head specially fixed matter 38. That, my lord, person Milapchand Chorodi appearing in person, my lord.
Especially fixed that. But 2 p.m. matter is there. 2 or 3 p.m. matter though it will.
Because, my lord, I will continue to argue there for 2 hours.
Let's see how far the court can go.
Very well.
Yes. Call.
Original said non-commercial list for judgment item number 1.
All applications will be decided in one order. These applications are allowed subject to payment of cost of rupees 5,000 each, except the defendant number 6, 9, and 12, who have filed the application prior to 120 days. Other defendants are filed after the 120 days. That's why cost has been imposed of 5,000 each. Within a week, the return statement is to be filed after serving the copy.
I'm grateful, my lord.
I had one small prayer. My lord, the written statements are voluminous. There are 7 volumes. My lord, I was just praying for 2 weeks time to file the written statement.
But this court has allowed only on affidavit that your affidavit has been affirmed. It is your chance. You have made an averment and given the chart. Your affidavit is affirmed prior to 120th day. If it is affirmed, why further 2 weeks? That's
I'm grateful, my lord.
yes. Next.
Item number 2.
My lord, this is my this is my application. Honorable, recall there was an issue with regarding to re-verification and reaffirmation since one of the substituted heirs were in judicial custody. Now, my lord, apropos to what my lord had directed, we have traced a power of attorney. We will try to file the plaint on the basis of the power of attorney. My lord,
So,
my lord, this issue has been resolved, my lord. Kindly let us permit us to file it on the basis of the power of attorney.
so now what you want?
Nothing, my lord. My lord, let it go out of the list, my lord. We will file, and if
Why to be mentioned?
but on the last occasion, we did not have a power of attorney, and we were seeking directions from my lord on how to get it reaffirmed and re-verified since he was in judicial custody. Now we have a power of attorney. We will try to get the plaint re-verified and reaffirmed on that basis.
Okay.
On the last occasion, they have affirmed the application for substitution from my lord the judicial custody, the certificate from the officer.
No, this power of attorney, my lord, has been in January this year when he was out on payroll. It's stamped and it's notarized, my lord. If my lord, it's just,
So what do you want now?
my lord, kindly grant me leave to file the plaint on the basis of the power of attorney.
The matter is listed as to be mentioned. Full stop. Counsel for the plaintiff submit that. The plaintiff has got the power of attorney. Plaintiff.
Substituted plaintiff number 1, Shanti Kumar Swarana.
Substituted plaintiff number 1 has got the power of attorney from the judicial custody of the plaintiff number.
Has granted a power of attorney to plaintiff number 2.
Who has granted the power of attorney?
Plaintiff number 1 has granted power of attorney to plaintiff
Plaintiff
number 2.
1 is custody.
Yes, my lord.
Where is the substituted applicant? Where is the substituted? Shanti Surani is in custody.
Yes, my lord.
Submit that. The plaintiff number 1. Substituted plaintiff is the substituted plaintiff.
Yes,
Shanti Surana.
Yes.
Substituted plaintiff number 1.
Yes.
Is in judicial custody. Is in not judicial custody. Is in correctional home. And The plaintiff number 2. Plaintiff number 2 got the power of attorney.
Yes, my lord. Shubham Zorana.
Number 2 has got the power of attorney from the plaintiff number 1, and as such, the plaintiff will take appropriate step for present the plaint in terms of the power of attorney.
Grateful, my lord.
In view of the submission made by the counsel for the plaintiff, let the matter go out of the list for the present liberty to mention.
My lord, 2, 3, 4, same matter.
Yes, 2,
Great.
3, 4 or same. Huh?
Great.
Item number 5.
Item number 5, my lord, I am for the petitioner, my lord.
For the defendant, my lord.
My lord, it was to be mentioned, my lord, the defendant was supposed to take instruction regarding settlement, my lord, about the rent, my lord. My lord.
Yeah.
My lord, I have talked with my client. The difficulty is my client's wife is suffering from femur bone fracture injury. So I begged some time. Kindly fix it at the end of this month. If your lordship desires, kindly keep it at last chance. Whatever your lordship desires.
Maybe
At the end of this month, my
will be, my
humble
lord,
son.
too long, my lord. Let it be listed next week, my lord. If nothing happens, then
Next week is hobby na.
my lord.
Unnecessarily.
Come on, 24th.
Anna,
As per the prayer made
My
by
lord,
the
my lord,
my lord,
another.
last occasion, my lord, they were supposed to hand over the key to my client, my lord. That has not been done
Yes,
yet.
my client's son is bringing the key. He will hand over it today, my lord, to that.
I am not
father.
recording. You give
No.
so and suffering for the plaintiff, so and suffering for the defendant. Full stop. As per the prayer made by the counsel for the defendant, the case is adjourned. Let the matter appear on 24th of July under the same heading.
Grateful, my lord.
Presentation of claims. Item number 6.
आया पुराना फाइल आया
My lord, I am appearing for the plaintiff in this matter.
Yes.
My lord, both the shoots are again not appearing in the list. Is placed on record. আর নতুনটা দাও। But the earlier suit has been filed against a dead person, same pan, during when it was appearing, it fell from them that he has passed away. So subsequently, it was filed against a tenant, a suit for eviction against a tenant. We are willing to withdraw the suit, the earlier suit CS 226 of 2022, and we are filing this fresh suit against a trespasser.
Yes. So you want to withdraw?
My lord,
226 of
226 I
2022.
want to withdraw.
In terms of the order dated 26 June 2024, the office has placed the record of CS number 226 of 2022. This court has perused the plaint. Counsel for the plaintiff submitted. Is the dead person?
Is a dead person.
When prior to filing of the suit?
Prior to filing of the suit.
Counsel for the plaintiff submitted. The plaintiff had filed CS number 226 of 2022 against one MIN PAYNE. But subsequent to filing of the suit, the plaintiff came to know that he said defendant MIN had expired prior to filing of the case, and accordingly, the plaintiff pressed for withdrawal of the suit, withdrawal of CS number 226 of 2022. In view of the submission made by the counsel for the plaintiff, CS number 226 of 2022 is dismissed as withdrawn. Now the plaintiff has filed the present suit, being CS 114 of 2024 against one Cassandra CASSANDRA, Cassandra Pine Pine for eviction and recovery of mean profit. Full stop. In view of the full stop, this court find that the plaintiff has not prayed for any leave from this court. Accordingly, record of CS number 14 of 2024 be placed before the Complainant Master for taking for passing appropriate order.
Much.
Number 7.
Item number 7, my lord, I am for the defendant.
Yes.
My lord, I am for the plaintiff. Last day, Mr. Banerjee had, my lord, placed
I'll
or
let him
argued
start
on the,
next.
my lord, section 5 and 8 application. My lord, this pertain to a, my lord, allotment of a, my lord, apartment in respect of a project that was floated by, my lord, the defendant here. My lord, if your lordship kindly takes GA3 once, we are opposing this application principally on 3 grounds, and Mr. Shuman Datta, my lord, is leading me. He had indicated the points broadly.
GA1?
GA3, my lord.
Yes.
My lord, the first point on which we would address your lordship is, my lord, that it is not, the arbitration agreement is not specifically incorporated in the document in which they say is the arbitration, the existence of arbitration agreement. That is one. Second, my lord, our contention would be that the agreement itself otherwise is void because, my lord, it's contrary to statutes. The statute being, my lord, the Real Estate Regulation and Development Act 2016. So if it is void, my lord, the third limb is that the concept of separability of arbitration agreement, my lord, if it is void ab initio, then, my lord, that concept will not come in aid of the, my lord, defendant, and lordship can, my lord, even while hearing a 5-8 application, decide whether lordship would, my lord, exercise discretion and refer the parties for arbitration. So these are the, my lord, 3 broad points. My lord, kindly takes GA3 once. Straight away, my lord, comes to the document which the defendant is relying upon. Page 16, my lord, the application form. In fact, page 14, lordship comes. This is the provisional allotment.
Yes.
There is a subject, lordship will find provisional allotment of unit number so and so at Uttalika. My lord has found? Yes. Then kindly marks, my lord, the just above point 1. In response to your application, we are happy to provisionally allot to you the above unit subject to the general terms and conditions. So it is subject to the general terms and conditions and the following. My lord, then 3 says your executing necessary document as per format of the company as and when required. So at least this document does not have an arbitration clause.
Yes.
Now, my lord, kindly comes to the application form, which is at page 16.
Yes.
My lord, the application form starts at page 16. The relevant portion would be at page 21. The declaration.
Yes.
I'll just place this declaration, my lord.
Yes.
Because this is signed by my clients, the plaintiffs.
Yes.
We hereby solemnly declare that all the foregoing facts are true to the best of our knowledge and nothing relevant has been concealed or suppressed. We also undertake to inform SC Builders and Realtors Limited, that is the defendant, of any future changes related to the information and details shown in this application form. Then 2, we hereby also declare that we have read and understood the terms and conditions of sale. My lord, I am pausing here for a moment. My lord, the understanding or the reading is the terms and conditions of sale and all other information conditions stated in the accompanying general terms and conditions, including statement of area, number of units offered, consideration of the units and price and payment schedule, etc. I pause here again, my lord. So this understanding is only with regard to the terms and conditions of sale, as in what would be the area, what would be the payment consideration, so and so. And other information. Now, my lord, the question would be, this other information, if there is no specific reference, usually what it should have been according to us is this, including, it should have said, including the arbitration agreement contained in the general terms and conditions. Information is not, my lord, this arbitration agreement. That cannot bind me to the arbitration agreement.
So as per your submission, in terms of this declaration, the arbitration has not been
incorporated.
in the declaration.
Yes, my
So
lord.
that's why the arbitration cannot be said to be agreed by the parties.
Yes, because my lord, the basis of this declaration, which has been signed by my clients, is not to enter into an arbitration agreement. It is to enter into an agreement for sale, and the terms and conditions pertaining to that sale is, my lord, written in this declaration or reproduced in this declaration. So if it was, my lord, additionally, if it would have said that we also agree to the arbitration agreement which is there in the general terms and conditions, possibly what my learned friends on the other side are saying is correct.
That's why their simple case is that in terms of this allotment declaration, and in the declaration both the parties have signed, agreed with the terms and condition. In terms and conditions, if you go to the GTC, it is an arbitration clause. So
that is, yes, that is their simple, my lord, argument, my lord.
What they have
Yes.
made out in the application.
So, my lord, the first limb of now, if I just complete this declaration, my lord kindly permits me to read 3 and 4. We further agree to sign and execute necessary documents as deemed necessary and as and when required by the company. So, my lord, if there was any other deed executed post this allotment,
yes,
and if that deed contained an arbitration clause signed by both parties,
yes,
based on that, my lord, a 5-8 could have been maintained in this suit.
yes.
Then, my lord, I read 4. We unconditionally agree to pay the allotment money due in case we are allotted any unit in terms of this application within 45 days of the date of allotment, failing which allotment made against my application would stand cancelled as per the terms of accompanying general terms and conditions. Then, my lord's consent to become member 5 is not relevant. 6, we have signed this application form after having read and understood what is written herein above. My lord, the law, the application form has been signed. Let's go. So, my lord, it has been signed by us. What has been signed is the application form. What is not mentioned in this document, in this declaration, is that I am agreeing to the arbitration clause, which is there. I'm not specifically agreeing to the arbitration clause, which is there in the accompanying general terms and conditions. Lordship had the occasion very recently to deal with a matter. Lordship was considering MR engineers, had considered MR engineers. The argument, our argument is, my lord, in line of MR engineers, that if I am to be bound by the arbitration agreement, there has to be a specific reference of the arbitration clause so as to bind me. In this declaration, that is conspicuously absent.
But GTC is not signed by both the parties.
GTC is signed by both the parties. My lord, kindly now comes to the clause at page 39.
Yes.
The acceptance, my lord, this is clause 26.
26A, yeah.
Yes. The acceptance of provisional allotment letter by the allottee shall be subject to these terms and conditions and shall be binding on the allottee. Legal relationship between the allottee and the company shall be governed by the laws of India. Then, my lord, B, all disputes or differences relating or arising out of or in connection with the provisional allotment read with the terms and conditions contained herein shall be mutually discussed and settled between the parties. Disputes which cannot be settled amicably shall be finally decided and resolved by arbitration in accordance with the provisions of the Arbitration and Conciliation Act 96 and any subsequent amendments thereto. Matters requiring arbitration will be referred to a sole arbitrator to be appointed. This is the procedure or mechanism provided for arbitration.
So once you're signed, both the parties are signed. So how you can say, because if MR engineer,
MR engineers,
in that, if a subcontract has been given in subcontract, then arbitration clause has not been mentioned, then it can be said. But here you signed the arbitration, this clause, page 39, both the parties are signed.
My lord, the general terms and conditions cannot, my lord, independently exist. My lord, this is, my lord, a part of the provisional allotment letter. The declaration that I am bound by the terms and conditions is contained in, my lord, that application form which contains the declaration.
Okay.
Therefore, my lord, according to me, my lord, this per se would not bind me to the, my lord, arbitration agreement which is there, my lord, in clause 26.
Yes.
My lord, kindly gives, my lord, leave, my lord, Mr.
The cardinal issue before your lordship, my lord, would be, in my respectful submission, that when I go to buy a flat, I enter into an agreement with the developer for the purpose of deciding the terms and conditions.
Correct.
The declaration letter, which my learned friend has just now placed, my lord, your lordship will find it only says that I declare that the terms and conditions of sale. Now, terms and conditions of sale is one agreement. Entering into an arbitration agreement in the event there is a dispute in the terms and conditions is another agreement. Now, there is no dispute here. It's not my learned friend's case that there's an arbitration agreement in a separate contract signed by the parties. That's not his case. So he is also coming through section 7, subsection 5 to say that this contract, this declaration where I have signed, refers to the terms and conditions which contains an arbitration. So it's no, what is falling from your lordship is that if it's an arbitration agreement signed by the parties, then that's a contract. This is not that contract. It is referring to the terms. And mind your lordship.
So what is the meaning with the party signed, both the parties signed in this condition?
They agree to the terms. They agree to the terms. Now the question is, while agreeing to the terms of sale, if there is an arbitration agreement involved in it, did I agree to that also at the time of signing of the terms? Or did I say that no, I agreed to the terms in sub silentio the agreement of so therefore the intention, the consensus ad item has to be there.
Okay.
And I had not gone, nobody goes to an goes to buy a flat with an intention of entering into an arbitration agreement. That is, when I look at it from the intention of the parties. And the intention of the parties is what is being reflected from page 14 and 7
14, 16, 21.
Yes.
14, 16, 21, then 39.
Yes.
These are the
And
three documents.
most important is my learned friend is holding me to this declaration, which nowhere refers the word arbitration at all.
That I have taken note of.
So therefore, now if your lordship looks at section 7, subsection 5,
Yes.
well, in this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. In an arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement.
Correct.
Then an arbitration agreement is in writing if it is contained in the document signed by the parties, an exchange of letters, correspondence, such and such, exchange of the statement of claim, not exchange. Then, my lord, where is very important. The reference in a contract, this contract, my lord, would be the parent contract to a document, that is the terms and conditions, containing an arbitration clause constitutes an arbitration agreement. So therefore, this document, this contract will refer to a document which constitutes an arbitration clause, and it will bind the parties to an arbitration agreement if the contract is in writing and reference is such as to make that arbitration clause part of the contract.
That is your argument with regard to this.
Reference has to be such, and there is no reference in the declaration at all.
That's why.
Yes.
This is the case in the 3 declaration. A reference of the arbitration is not there. So section subsection 5 or section 7.
So therefore, strictly it doesn't come. And beyond this, my learned friend is not running his case at all. He's only running this case. Now, my lord, I am not relying upon MR because of the simple reason, my lord. I am relying upon the judgment passed by your lordship in Daskan Sour Commercial, which takes care of every MR and the subsequent judgments. Okay. না লাস্ট কোনটা রিপোর্টেড আমি কপি দিচ্ছি দাঁড়াও আমারটা খুঁজে বার করি আর লর্ডশিপ ইজ নো মোর খাতাগুলো আমার কাছে কপি আছে এটা ওকে দিয়ে দাও Melody has your lordship got this. Paragraph 12. এখান থেকে শেয়ার করুন আমার ব্রিফ Millard, there is another thing, Millard, which I need to say. Millard, all these judgments say that there is a standard terms and conditions. Now, standard terms and conditions means conditions, terms which are applicable to contracts known in that same profession, trade, or calling. So, by standard terms means that you have an usual terms fixed, like the government of West Bengal or any other government authority which is available on the website. And any party intending to enter into a contract has public knowledge of the fact that these are the standard terms and conditions. So standard terms and conditions would generally, in my respectful submission, mean that any term which is recognizable with the contract, trade, calling, or profession. That is what the Supreme Court has also said. So far as purchase and sale of flats is concerned, Millard, these terms may not be standard terms.
Why?
Because arbitration clauses in Millard on purchase and sale of
Commercial
flats are purely commercial. Some put in an arbitration clause, some do not put in an arbitration clause. And today the law is such that you cannot have an arbitration. That I'll come later. Because the thing is, Millard, in these arguments, in these contracts, what the contractors do, Millard, they are one-sided. These are all pre-printed forms, Millard. It's not that I have an occasion to say that I don't agree to this clause or I don't agree. Either you sign it or you don't sign it. So in these pre-printed formats, Millard, what happens is I am compelled to sign if I am agreeable to purchase a flat. Now, to cut away with these obligatory or these onerous clauses which the promoters put in, Millard, the Act has now come into force. And the Act itself provides a format which is mandatory and a statutory format. That you have to enter into an agreement in these lines. And these are the clauses which you need to put in that arbitration or in that agreement. That does not contain an arbitration clause because any dispute arising out of that agreement has to go to a tribunal. So arbitration has been completely wiped out. And there is a judgment of the Madras High Court which has compared this Act with the arbitration clause and has said that this Act, being a special Act, will supersede arbitration which is procedural. I'll come to that later. But what I meant to say and what I wanted to impress is this: these are not standard terms. These are terms of commercial nature.
Yes.
Millard, it's your lordship's judgment. What should I place, Millard?
Para 14.
Yes, that is what I wanted.
Yes.
So, Millard, I'm not wasting your lordship's time on this, but I'm relying on this, and I've given my learned friend. This is, Millard, one aspect of that. Now, Millard, the second aspect of the matter is, Millard, I'll trouble your lordship with the terms and conditions once. Here is a case, Millard. Let me just give your lordship, Millard, the background. I had agreed to purchase a flat. I had entered into these terms. I had paid approximately, the figure may be here and there, as 60-70 lakhs of rupees I have paid. The total consideration of the flat was probably 1 crore. After having paid a substantial sum of money, Millard, I could not I could not pay the further sum, and I was not interested because it was becoming high. Because these two are senior citizens. So what we did, my lord, we wrote to them saying that we are not interested to purchase the flat. Give us back our money. They agreed to give back the money, but they agreed on the condition that out of the 70 lakhs and odd, they will give us only 25 or 26 lakhs, and the balance amount they will forfeit. That is what has happened over here. Now, this right of forfeiture, my lord, is coming out, according to me, from the terms of this contract, which I say is very onerous. And that is what, my lord, and having said that, what my learned friends clients have done, they have not held on to the flat. They are not refunding the money. At the same time, due to the non-payment of the balance, they have sold the flat higher than the price with which I have agreed. So there is no question of any loss or damage my learned friends suffering.
That is a merit of.
I'm not saying that. What I'm trying to say is this, my lord. In this background, kindly see why I'm saying that these clauses are onerous. Well, let kindly come to page 24.
Yes.
If an allottee requests for cancellation of allotment before, Miller 8 at the bottom. If an allottee requests for cancellation of allotment before the company gives notice of possession, refer to clause 14 to the allottee, then allottee shall be left with no lien, right, title, interest, or any other claim whatsoever nature in the apartment and the car parking space. So I have to cancel it before that. If an allottee requests for cancellation of allotment after the company gives notice of possession to the allottee, the same shall not be accepted by the company under any circumstances. So you cannot cancel it. Then the company, if the cancellation is by the company, if the company cancels an allotment
Due to
delay or non-payment of dues or in case of breach of terms of the GTC by the allottee shall be left with no lien, right, title, interest, or any other claim whatsoever in the apartment and the parking spaces. In case of cancellation as in 8A and 8B above, the company shall refund the amounts paid by the allottee without any interest or compensation, after deducting an aggregate of 10%. So even if the company cancels, then also he will deduct 10% of the 10% of the consideration of the apartment and the parking space, applicable service tax and due interest, if any, on account of delay in making payment of interest, collectively referred to as the cancellation charge. So in either case, my lord, it is the person who has come. If he has committed a breach, he has to pay up 10%.
Yes.
The other clause is below page 27. Delay in payments. Page 27. But this would be part of clause 11.
Yes.
Allottees are liable to pay interest at the rate of 15% per annum on their dues payable in terms of provisional allotment letter from the date on which the amount falls due up to the date of payment, both days inclusive.
Yes.
Delay, then Miller, you can skip the paragraph and the next paragraph. Delay in payment of installments and other dues beyond 2 months from their respective due dates would make the allotment liable to be cancelled with 15 days written notice to the allottee. In case of such cancellation, the company shall deduct cancellation charges as per clause 8 herein above.
So 10%.
10%. So if I am to purchase a flat and if I don't make payment in time, then I have to pay 15% interest on that amount. And if I cancel, they will be liable to deduct 10%. But your lordship will find in vain that there is any clause in this document which speaks the reverse. That in the event the company fails, whether he is liable to pay interest or not. There is no such clause. Having said that, my lord, now my lord will kindly take what was the law as on that date. But it's no point in arguing before your lordship that the parties cannot contract beyond the statute. If they do so, it's void. Now, my lord, I will trouble your lordship. Will it kindly take the Real Estate Regulation and Development Act 2016? Lordship takes the preamble once.
Yes.
An act to establish the preamble.
Yes.
An act to establish the real estate regulatory for regulation and promotion of the real estate sector and to ensure sale of plot, apartment or building as the case may be, or sale of real estate project in an efficient, transparent manner, and to protect the interest of consumers in the real estate sector, and to establish an adjudicating mechanism for speedy dispute redressal, and also to establish the appellate tribunal to hear appeals from the decisions, directions or orders of real estate regulatory authority and the adjudicating officer and for matters connected thereto. Now, my lord, therefore, the purpose of the act is to save the consumer.
Yes.
Now, if that is so, my lord, now, my lord, I'll trouble your lordship with 2 or 3 sections from the definition clause. To be a advertisement. My lord, kindly come to C. 2C defines an agreement for sale. Means an agreement entered into with the promoter and the allottee, which is this one also. Then, my lord, your lordship will kindly come to, my lord, allottee. If your lordship sees the definition of allottee, your lordship will find. In relation to a real estate project means the person to whom a plot, apartment or building as the case may be has been allotted, sold or otherwise transferred by the promoter and includes the person who subsequently acquires the allotment through sale, transfer, and so. So, the plaintiff is an allottee.
Yes.
Then, my lord, your lordship will kindly come to, I think, my lord, building, carpet area, everything will fall, common areas. Then, kindly, my lord, come to another section. Black করেছি kindly come to 4. Or, my lord, before that, ZK. Before that, sorry, I missed it. Before that, ZK.
Yes. Interest.
Promoter.
ZA interest.
ZK.
K.
K for.
Yes. Promoter. Yes.
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 Promoter means a person who constructs or causes to be constructed an independent building or a building consisting of apartments and converts an existing building or a part thereof into apartments for the purpose of selling and also it develops land in the project whether or not person constructs structures in a plot of land for the purpose of selling or to the other persons all or some of the plots in the set plot whether with or without structures. So, my lord, I think, my lord, my learned friends clients will come under ZAI, promoter. So, this act squarely covers this transaction. Now, section 4. Kindly, my lord, see. Every promoter shall make an application to the authority for registration of real estate project in such form, manner, within such time and accompanied by such fee as may be prescribed. The promoter shall enclose following documents along with the application referred to in subsection 1, namely brief details of the such and such, brief details so and so, your lordship turns over all the requirement comes to G. pro forma of the allotment letter,
Yeah.
agreement for sale, and the conveyance deed proposed to be signed with the allottees. So, my lord, if I have to make an application before the authority, my lord, that authority gets an opportunity to see the allotment letter, the agreement for sale, and the conveyance, keeping in line the interest of the consumer so that it is protected, so that he is not exposed to unnecessary. Then, next of all, now, my lord, kindly come to 13.
So what you want to show?
What I want to show is this, my lord, that so far as these terms of conditions of the contract are concerned, they are actually militating against the terms of the statute. If they militate against the terms of the statute, then, my lord, under section 24, if they are not separable, then the entire contract goes void ab initio. If it is void ab initio,
So you mean to say the RERA is
of course,
applicable
and I'll show that has been held. In fact, my lord, RERA has, this Madras High Court has held that even if the arbitrator has all the jurisdictions,
to RERA.
RERA has a power to impose penalty. Where does the arbitrator get this power?
Contracted out of
So, what I'm trying to show is that, my lord, I'll be very quick, my lord, I'll just 30. And this is what I'm come. A promoter shall not accept a sum more than 10% of the cost of the apartment, plot, or building, as the case may be, as an advance payment or application fee. Say, or such person register the same for sale. Then, the agreement for sale referred to in subsection 1 shall be in such form as may be prescribed. So, this act prescribes an agreement and shall specify the particulars of the development of project, including the construction of buildings, apartments, along with specification, internal development works, external development, such and such, then payments towards cost of apartment, plot, or building, as the case may be, to the allottees, and the date on which possession of the apartment, plot, or building is to be handed over. The rates of interest payable by the promoter to the allottee and the allottees to the promoter in case of default, and such other particulars as may be prescribed. Now, kindly see the format. Format ta din. Din. Well, this format is
Annexure A.
Annexure A. Your Lordship has that in that book, yes. Your Lordship will find that so far as this format is concerned, this is not the format in which, my lord, the parties have been transacting under this agreement. And at the same time, these onerous clauses of paying 15% allotment in case of additional delay or deduction of 10% by the promoter in case I do not find place in this agreement.
Yes. Then
Just give some moment. Kindly, my lord, take the trouble of coming to clause 9
of the agreement.
No, of the format.
No, that's why.
Yes, agreement. Standard prescribed statutory. 9 2. What happened? What are we now? Yes. Well, 2. The allottee shall have the option of terminating the agreement, in which case the promoter shall be liable to refund the entire money paid by the allottee under any head whatsoever towards the purchased apartment, along with interest. So he is to pay me interest at the rate of 45%, receiving the termination notice. Provided does not intend to withdraw the project or he shall be paid the promoter interest at the rate of the rules in the rules for every month of delay in handling the project. So, Millard, there is no question. I'm not on the question of interest. I'm on the question of there is no provision for deduction.
So that is the merit of the matter.
Right. Now, the question is, if this is a prescribed format and you have asked me to sign a declaration which does not come within the format, then parties have agreed to terms and conditions, dehouse the statute.
That's why, as per your submission, the agreement which they are relying upon, that is not in terms of the RERA, and he is the promoter, he has to comply with it.
No, I'm not saying that. What I'm trying to say is that the agreement which the parties have entered into, which is at his option, is a contract which does not conform with the statutory requirement.
Correct.
So if there is a breach of statutory requirement in the agreement, then can the court enforce this agreement? Because here is the arbitration clause is not a separate agreement. It's a clause built in the arbitration. So if I can show that being contrary to statute and inseparable, then the entire agreement goes. If the entire agreement goes, in my submission, that arbitration clause will go, because it's not a section 11 stage that the parties will
go to this.
So 5 and 8 million, your lordship is now taking away my civil right to file a suit.
Yes.
Just a minute. There was another clause.
33. Dispute and resolution.
Yes, that is what I'm saying. Yes. Having said this, now will not kindly take the judgment of the Madras High Court. Madras High Court. Millard, I had cited it before in your lordship's copy. Is there a judgment 2021 SCC online Madras? Because all the copies were handed over to court.
Only F1 is there.
2021 SCC online Madras 16554.
2021 SCC Madras.
Yes.
Army Welfare Housing.
Yes, Army Welfare Housing. This petition is filed. Permit me to, I think, the previous bench has probably also marked certain portions of that judgment. I had cited it in great detail. So, Millard, I'll just very hurriedly take your lordship, Millard, or if you
4, 5, 11 marked. I don't.
4 is, yes. The 4 is, Millard, it's an application under section 8 before the adjudicating authority for referring the parties to arbitration. Then the submissions regarding Tamil Nadu Estate Regulatory Authority have been made. Thereafter, Millard, Inox and all the judgments under 5 and 8 have been considered. Paragraph 12 probably is also marked if your lordship finds.
Yes. Paragraph 11, bones are in.
Paragraph 12.
12, Roman 6.
As service fancy 16, one more addition is made with regard to the dispute in trust matters.
6. Eviction tenancy matter governed by.
Thereafter, the next paragraph.
Yeah, then Ayasami and Paryasami.
Yes. From these rulings, it is clear that if adjudication of any issue is covered by any special statute, that issue cannot be referred to arbitration. So, and thereafter, my lord, the Supreme Court judgment has been quoted, which is, my lord, your lordship will find there is probably some marking in paragraphs 19 and 20 of that, which starts with, it is clear from the observations that when issues governed by special statute, paragraph 19,
Yes.
well, it will be page 11.
Yes.
Clear that these observe that when issues governed by special statutes like the issues relating to labor, consumer, landlord or tenanted protest statute, trust matters, the matters of right in rem, criminal matters are not arbitrable. It was reiterated in Vidradolia, then Vidradolia's one of the grounds is there, and thereafter Vidradolia case was followed. Paragraph 21. As already stated, learned counsel for the respondent submitted at the real estate laboratory is a special statute to deal with the dispute arising out in the real estate sector. It is a complete act to deal with and contingency arises in real estate sector in the dispute between the parties. It is further submitted that the arbitration agreement relied by the petitioner is an one-sided agreement giving absolutely no option to the respondent in matter of appointment of arbitrator. It is a standard from contract annexed with the allotment order. Based on this one-sided arbitration, petitioners cannot seek to enforce the arbitration. Then, my lord, the rules, paragraph 23 onwards, my lord, 7.5 has been discussed. But I'm just very hurriedly, I don't want to waste my lord, your lordship's time. But I had placed the entirety of the judgment, this I realize. Then, my lord, 27 onwards. 27 onwards. It is already found that if a special statute creates a special right or liability and provides for determination of each right and liability for the specified court or public forum so constituted, and whether the remedies beyond the ordinary domain of civil courts are prescribed, and the answer is in the affirmative, the dispute is not arbitrable. Number one. It is the contention, then forget the statement and objects and reasons, paragraph 29. The statements of objects and reasons show that this act is enacted for establishing the estate regulatory authority for regulation and promotion of real estate sector and to ensure sale of plot, apartment or building as the case may be in an efficient and transparent manner, and to protect the interest of the consumers in the real estate sector and to establish a real estate appellate tribunal to hear the appeals or decisions. It is to ensure greater accountability towards consumers and would significantly reduce frauds and delays as the current high transaction cost. It attempts to balance the interest of the consumers and promoters by imparting certain responsibilities on both. Thus, this act has provisions of registration of real estate project, real estate agents, definitions and functions and duties of promoters, rights and duties of allottees, establishment of real estate regulatory authority and real estate appellate tribunal, defining their functions and powers, and importantly providing penalties for offences committed under the Act. Sections 59 to 69 of the Real Estate Act deals with offences, penalties and adjudication. Section 70 deals with compounding of offence. Certainly, arbitrators cannot impose penalty and interest. So, Miller, this would be curtailing of my rights, which the Arbitration Act does not provide.
Yes.
And therefore, Miller, the section 5 and 8 was dismissed.
Arbitrary.
Miller, give some 2021 SCC Online Madras 16554.
Thank you.
So, Miller, this is my second limb of argument.
Yes.
Now, Miller, the third limb of argument is something I'm not very sure of, Miller. I'm not saying it with a lot of conviction, but I think it's something which your lordship can. Miller, if your lordship takes the section 24 of the contract. My duty is to assist, but here, my lord, I am seeking assistance from your lordship.
Yes.
If any part of a single consideration for one or more objects, or any one or any part of one of the several considerations for a single object is unlawful, the agreement is void.
Yes.
This void is void ab initio. Now, I have shown to your lordship, my lord, that this agreement contains provisions governing the payment, allotment, return, and interest. Question is whether it is separable. If I take these things out from the contract, can the contract be performed? My reading of the contract is that so far as these provisions are concerned, and if your lordship leaves the terms and conditions, if your lordship takes out these from the terms and conditions, then the entire delay clause goes, the consideration clause goes.
Then void.
Then the question is, can the balance contract be acted upon? If it cannot, if your lordship feels that the general terms and conditions, by taking out, separating these two clauses, it does not become an agreement capable of enforcement, then the agreement goes in its entirety. If the agreement goes in entirety and the arbitration is a clause built in that agreement,
that gone.
That goes. It's not voidable.
Unlawful in part. Object unlawful if any part of the single consideration from one or more object or any one of the part several considerations.
Now, this entire agreement, including the arbitration clause, is militating against the statute. So, if the arbitration clause is also militating against the statute, and therefore the statute gets a precedence, then is the agreement void? If the agreement is void, my lord, then the arbitration clause, which also militates against the statute, goes.
So that's why you have referred this. As per your case, with regard to the RERA.
That's the reason. That's the reason. That's the reason.
And the agreement goes.
Yes. So therefore, my lord, what I am trying to impress upon the court is that if the agreement is void, then, my lord, the consequence, if your lordship holds it, my lord, that the agreement is void and therefore being contrary to statute, then, my lord, there is no question of 8-5 at all.
Okay.
That's it. My senior has come, let me just concern. No arbitration, special
Anything further?
Well, two more judgments I had before I could lay hands on this Madras High Court, which is pat on the point. This is regarding Consumer Forum versus Arbitration Act. There also it says that.
Recent also it is.
Well, does your lordship have a copy of 2019 volume 12 SCC 751? 2019 volume 12 SCC 751.
Yes, yes. MFG.
Yes.
MRMG.
Okay. Well, this is vis-a-vis the Consumer Protection Act.
Even that, with regard to the consumer, recently Supreme Court has said.
I don't
that
know.
Is not arbitrable.
I think, Miller, this is what my crux of the submission is. And Miller, if your lordship wants, Miller, right now I don't have, but it's true that if parties contract beyond statute or it's contrary to the statute, then that agreement, if your lordship wants a judgment on that, Miller, I can. No quarrel with the proposition. Then there is no quarrel.
That's all?
That's all.
But I had, my lord, sought for a liberty from your lordship last day. My lord, if required, my lord will kindly allow me, my lord, to rely on two decisions. My lord, I did not, my lord, I wanted to cut the matter short.
But Miller, the length of argument, Miller, while opposing an application under Section 8 shows that Miller, this should be allowed. Miller, when so many things are required to be gone into Miller to see whether Miller there is a valid arbitration agreement or not. Possibly Miller, this comes under Miller the principle of competence. Miller, this is not a day dude which Miller needs to cut. Miller going by with the Drolia and Miller the last 10 in global judgment, nor Miller side branches. But Miller, before coming to that, Miller will kindly just have a look at the plaint. Miller, what is argued is Miller not in consonance Miller with what is pleaded in the plaint itself. The plaint proceeds on the basis of the GTC, Miller, the general terms and conditions. Kindly, Miller, just have a look at the plaint. If my Lord wants me, Miller, to come back on any other day, Miller, I can.
Yes, you go through the Madras judgment also.
Miller, we have. And Miller, that is no more, Miller, a good law. Miller, a division bench judgment of a different Miller, Honorable High Court has come.
Okay, no problem. Suffering for the defendant. The defendant has filed an application being GA1, GA3 of 2022 for referring the matter and referring the parties to the arbitration. Full stop. Counsel for the plaintiff has concluded his argument. Full stop. Counsel for the defendant prays for time to give reply to the argument made by the the case that let the matter Eleventh July.
Any date, Miller, that is convenient to your lordship, my learned senior friend, any date.
11 July. Under the same meeting as parted.
Great. Miller, with the only understanding that my lord will kindly allow me, Miller, to rely on two decisions. I'm sure, Miller.
Give the copy. Give the copy.
Yes, Miller, I will.
Give the copy so that they
Till
can
now
also
you are
come
saying
ready
you
on
won't.
that.
Till now you are saying you won't. Miller, is it your lordship desire that I should make a bullet points?
Bring. No problem.
Great.
Number 8. Quickly, oblige.
Eight, my lord, is my application, my lord, seeking setting aside of an expertise decree, my lord. Setting aside of an expertise decree, my lord. On the previous occasion, my lord, the plaintiff did not appear, and my lord was pleased to direct us to serve a notice upon them.
But I am appearing.
Original side you are appearing.
I am appearing in all sides, including criminal side.
Now, after my elevation, first time I see in
Yes,
the
yes. Previously, when I joined the profession, my senior was late Arun Prakash Chatterjee. He used to roam throughout the High Court in all jurisdictions, and that was also my habit. After I left his chamber, I used to carry out all these things. Now I am getting old. I don't accept all the briefs.
Yes.
No, my lord, before starting with the matter, my lord, this application comes for the first time, my lord. If my learned senior friends, my lord, wants to use an affidavit to this, my lord, my direction may be first, or my lord, it can be posted for hearing, my lord. I was led by Mr. Rohit Banerjee, who is presently not available.
Kindly gives 1 minute where my learned junior has gone. She was outside calling some person. 1 minute, আমি আসছি। কি ব্যাপার? তোমরা ফোন দেখো না? অদ্ভুত ব্যাপার। Yes. This is an app.
Will you file the affidavit?
If necessary, if your lordship so desires, I can. But now this application is Order 9 Rule 13. Specific provision is there. If he can satisfy the Honorable Court
That is the only thing.
that he is prevented from that, then and then only it can be admitted, it can proceeded on. And on that preliminary objection, I want to file an affidavit. Because this application is not maintainable. Your lordship can record it.
You file the affidavit.
Yes.
Suffering for the plaintiff, suffering for the defendant. Full stop. Counsel for the defendant raised preliminary objection with regard to maintainability of GA5 of 2024 and also prayed for time to file affidavit in opposition. Let affidavit in opposition file within 2 weeks, 3 weeks.
3 weeks.
Within 3 weeks, comma, her reply, if any, there to be filed within
2 weeks thereafter.
2 weeks thereafter. Full stop, 3 weeks, 2 weeks. 2, 3. Matter appear on 21st of August.
21st of August. It's
And
all
that's
right.
under the heading adjourn motion.
Grateful.
Fine.
Sir.
हाँ ठीक है
Today, we are assembling primarily because of that repair part.
Yes.
Now my learned friend is disputing that it is not in his floor and things like that, Your Lordship will find the engineer's report at page 67 onwards, I was just telling my learned friend that if you are disputing, do something. You make it water resistant. See that water does not flow into my house. You do it. That also is not ready.
Yes.
And it kindly takes page 67 onwards.
Yes.
And it kindly see that page. And at 68, at the bottom, it starts, Initially inspected the fourth floor of the said premises, which is occupied by such and such, made the following observations. Veranda of the fourth floor facing the public road is in a dilapidated and precarious condition, as the pillars that damage the walls of the veranda have developed cracks in them. The northern eastern wall of the veranda is dampened due to water percolation from the fifth floor, and the paint of the wall, which seems to have been recently done, has also been damaged. The rear portion of the fourth floor of the premises consists of the kitchen cum dining area, 2 rooms and a bathroom. The southeastern vertical wall, ceiling, and even the beam of the kitchen cum dining area and 1 room used as home gym of the rear portion of the fourth floor are considerably damaged. The ceiling of the kitchen cum dining space in the gym room on the rear portion of the fourth floor is continuously dripping all along the day. The damage to the said portion is aggravating day by day and requires emergent and immediate repairs. Appliances of such and such have been damaged due to continuous water seepage. And electrical bulbs have been removed in anticipation of short circuits. Now, what does he say at page 70? Thereafter, para 2, I, along with the learned special officer, proceeded for inspection of the fifth floor of the said premises, which is occupied by such and such. On inspection of the said floor of the premises, I made the following observation along with the aforesaid plumber who was assisting me. The fifth floor of the said premises consists of 4 rooms, 1 sitting cum dining, 2 bathrooms, kitchen and veranda facing the public road. On inspection, the following observations. Drainage pipes of the 5th floor of the said premises are silted and clogged. And as such, the water in the bathrooms, wash basin, washing machine duct, and the kitchen sink is not being properly drained. And as the water is getting stagnated in the kitchen sink, bathroom floors, and kitchen floor on the 5th floor of the said premises. The marble flooring of the entire 5th floor, including the bathrooms and kitchens, has wide gaps. And the water, which is either spilled or is stagnated due to poor drainage on the floor, is continuously leaking through the gaps on the marble floor of the entire 5th floor and is leaking, percolating, and seeping into the ceiling of the kitchen cum dining space and gym room situated on the rear portion of the 4th floor, as a result of which the wall ceilings of the 4th floor has been considerably damaged. Ceilings of the kitchen cum dining and gym room on the rear portion is continuously dripping all along the day, but that has already been found. But let's see, the water and drainage pipe of the 5th floor is damaged, and the leaking of the said pipelines have damaged the vertical wall situated in the southwest of the 4th and the 5th floor. And as such, all the external water and drainage pipeline of the vertical southwest wall of the said premises needs to be changed or replaced immediately.
Yes. Now,
my lord,
he is having objection with regard to the B and C of the clause 2.
Yes. So, my lord, let us do something, my lord, with humility. My lord, let us do the others first.
Yes.
In spite of that, if water percolates, my lord, into the seeps, my lord, then, my lord, that has to be done also.
Yes. I'll just indicate, I have no objection if the others are done. Only objection.
But the point is, we had already done that first. That's why he says that it's been newly again painted. It happened the same way. Now, if again he wants me to do it, I'll do it. And if it seems, let him pay for it. And after that, your lordship will allow us to go to the 5th floor. Because by doing this, we cannot be pushed back from carrying out the repairs. That is what I'm
No, I'm not standing in the way of that, my lord. Not for a moment. My lord, perhaps there is one more cause for, my lord, the seepage. I'll just indicate
one small thing. Okay. And kindly sees, my lord, page 72. He says the external water and drainage pipes, not internal, of the fifth floor of the said premises are required to be replaced by new pipes. As the water pipes of the fifth floor of the premises are leaking and the drainage pipes are set clogged, the drainage ducts are to be blocked by permanent filters. This also can be done externally. Then Malat kindly sees the marble floors of the two bathrooms and the kitchen situated on the fifth floor of the premises requires to be sealed by cement and chemical waterproof grouting. It's not taking away the marble. Grouting, Malat, I know, Malat, because I'm also undertaking some masonry work at my house. Malat, grouting is basically sealing the joints between two tiles. That is it. It won't come out. So that's what he's trying to do, that because you seal by cement and chemical waterproof grouting in order to stop seepage and leakage of the water of the fourth floor of the said premises. Malat, there are, Malat, you know, Lordship knows, two tiles, sometimes there are, obviously, Malat, there has to be some space between them. That is sealed by chemical putty or chemical, whatever, the cement. We generally use white cement.
White cement.
Malat, that is needed to be done only. And he's opposing to that. I'm not taking out the pipes. Pipes.
Pipes,
Marble
I don't
floor
have any
of two
objection.
bathrooms and kitchens situated fifth floor of the premise required to be sealed by cement and chemical waterproof.
Waterproof grouting, Malat, that is it.
Waterproof grouting in order to stop seepage of the leakage water on the fourth floor of this premise.
So he'll just cement it there. Water then will not seep through the tiles. That's it. He's not taking away the tiles.
But this, I'll just indicate, my lord, this perhaps is not the only reason why, Lord, why there is seepage. I'll indicate why. My lord, and yesterday, my lord, I submitted before your lordship. I will bring pictures and relying on the report. And if your lordship sees the report, page 70, my lord, 2A, my lord, I have no objection, my lord, with regards to, my lord, any pipes, external pipes being repaired. But if your lordship sees the report as a whole, it starts from, my lord, page 67. Thereafter, lordship comes to, my lord, page 69. In fact, page 68 from the last paragraph.
Yes.
Look, initially, I inspected the fourth floor of the premises, which is occupied.
Now come to two.
Yes. A, my lord,
Yes.
A, there is no problem, my lord. Okay. Only B, there is problem because there is actually no percolation from the fifth floor. And I'll indicate why and what the folly, my lord, is in the report is. Northeastern wall, my lord, is dampened due to water percolation from the fifth floor, and the paint of the wall, which seems to have been recently done, has also been damaged, my lord. Now, this, my lord, is perhaps not correct. Lordship turns over to the next page.
The next
B, you are having objection.
B, I am having objection, yes.
C,
yes.
C, there is no problem.
Yes, there is no problem, my lord. There is no problem. B is the main problem. 2A, my lord, there is no problem. Kindly reads once. 2A, I'm just placing before your lordship for a moment. The drainage pipes of the fifth floor of the premises are silted and clogged. As such, the water in the bathrooms, wash basin, washing machine duct, and the kitchen sink is not being properly drained. And as the water
where from your reading?
It's 70.
70, my lord. 2A.
2A.
Yes. So, my lord, if there is any clog, my lord, that can be repaired. There is no problem. I can do it at my instance, my lord. B, kindly, my lord.
No. A, drainage pipe of fifth floor of the premises silted and clogged, and such the water in the bathroom, wash basin, washing machine, duct, kitchen sink is not being properly drained. And such the water gets stagnated in the kitchen sink, both from the kitchen floor of the fifth floor. Yes. Then?
Yes, kindly takes B once. May I just read this out? Marble flooring of the entire fifth floor. Entire fifth floor, including the bathroom and kitchen. My lord, bathroom does not have marble. It has tiles, firstly. Has wide gaps. Kindly, my lord, pauses here for a moment. Has wide gaps. And the water, which is either spilled or is stagnated due to poor drainage on the floor, is continuously leaking through the gaps on the marble floor of the entire fifth floor. And is leaking, percolating, and seeping into the ceiling roof of the kitchen cum dining space and gym room situated in the rear portion of the fourth floor, as a result of which the wall's ceiling beam, my lord, has been considerably damaged, my lord. It goes on to say, my lord, there is continuous dripping. Now, my lord, I have both the pictures as I had, my lord, submitted yesterday.
Fourth floor.
At a fifth floor. There are no gaps. That's what I want to indicate, my lord. Kindly see. This is this.
No, I can see gaps, my lord. Let me see. I have a trained eye now.
Let me just place this before your lordship.
I have a house of 30 years old, my lord, which means
this is this. These and I'll indicate thereafter, my lord. করবে তুমি নিজে হ্যাঁ
তুমি পরে ছবি তুলে দাও আমার কি অসুবিধা
No, I just have instructions. If these gaps, my lord, these little gaps, although I don't think is sufficient, my lord, for considerable seepage, if it is required to be filled, my lord, I can undertake to do this.
My lord, kindly takes, my lord, I'll just point out, a second. But kindly take the second page of his photographs, my lord. But here your lordship will see between two lines, my lord, it's a white line, my lord. That is the grouting, which your lordship, my lord, just at the end, my lord, this is the cement grouting. Your lordship sees in the first page now. Your lordship will not find that. My lord, it generally, my lord, in old houses, my lord, it is not there. Between the two tiles, my lord, it needs to be sealed.
Tiles are marble.
Yes, he needs to be sealed only.
Page number 1.
Yes.
The tiles are marble.
No, my lord, tiles are not. These are just tiles. These are not. Yes.
My lord, then sees the third one. At the bottom of this page, the toilet, my lord, if it was, I'm sorry.
These things I can undertake. I can take pictures and I can satisfy your lordship. These have been completed. I'm saying this on Instagram. Now, will be completed. I'm sorry. I stand corrected. My lord, these I can undertake to do. But essentially, my lord, the primary cause of the seepage is something else, which my lord has not been inspected. In fact, I'll just place that before your lordship. I'll just read out the subsequent paragraph, my lord, after 2C. Thereafter, along with the special officer, proceeded for inspection of the terrace of the premises, which revealed that terrace floor is not leaking and the pipeline attached to overhead reservoirs are not damaged. And the entire problem is due to damaged water and drainage pipes of the fifth floor, and also due to gaps of the marble flooring of the fifth floor, leading to continuous water leakage, which has damaged the entire ceiling and vertical southwest wall of the fourth and fifth floor, thereby damaging electrical wiring, false ceiling of the rear portion of the fourth floor, which require emergent work. My lord, thereafter, my lord, he goes on to, my lord, give suggestions for what is to be done. Apart from suggestion C, my lord, I don't have any objection to this. Now, what has fallen from your lordship and what has been indicated by Mr. Ray, my lord, I can undertake to do those works to fill up those gaps. And I can satisfy your lordship that those have been done sufficiently. Now, my lord, the other thing, there is...
No, the problem is, there are two main problems. Main problem is 2B. 2B, leakage of marble, progress resulting ceiling, roof, kitchen, dining space, and gym room situated at so 2B.
Yes. Yes. 2B, my lord, whatever has been indicated that there are small gaps, those I undertake, my lord, to do whatever is required to stop the seepage. And I will satisfy your lordship with pictures. I can file an affidavit also thereafter to show that, to indicate that there is no further seepage from there. But the seepage may continue thereafter also, because the primary cause of the seepage, as I'm told on instructions, my lord, that there is, my lord, an external, on the external side of the structure, there is a plant, there's a tree which is there. And the roots of the plant has gone deep into the structure of the building. That, my lord, needs to be taken care of, my lord. That needs to be either uprooted and the external needs to be repaired.
If the roots of the tree has gone into that, then automatically there will be a cracks.
There are cracks. There are cracks. There are cracks. I can show from the report itself. There are cracks because of that tree. That also needs to be repaired. That needs to be uprooted, my lord. Let that also be done.
Let him do it. It's a partition property. Let him do it. I don't have a problem. That's what I'm asking for. But I had asked for the entire building to be maintained.
So if it is a big tree, it is a big tree.
No, fourth floor.
The roots going on.
Yes, into his premises also. Into his.
Gone in.
It has gone in. That is what I'm told, my lord.
But I
I'm
don't
saying
see
this on
any from any of the
instruction.
pictures, my lord. I don't see that.
I can hand over the pictures right away.
Then it is.
Let him consider it.
Let him do it. I don't have.
Let him consider it.
My lord, the initial application for maintenance of. My lord, that. My lord, I'm not him in person, my lord. But he'll take engineers or contractors to approve that, and then again that has to be sealed.
Let us do it according to our proportion of the property, the area that we own, my lord.
And at the front, at the beginning, I'm okay to do it, but obviously subject to whatever calculations come at the very end, because he has been taking the rent, he has been utilizing everything there.
All the occupiers shall.
Sorry, madam.
All occupiers.
Yes.
Shall take the give the shares.
Give the share at present, but we in our plain manner we have said that he has been taking it forever.
Yes.
So we'll be asking for accounts from him. Subject to final accounts, we'll do it.
Subject to
final accounts in the suit, yes. Obviously.
Because, my lord, in 2013-14, I had repaired the buildings. I repaired the building once. I had taken, my lord, I think some of the tenants had, my lord, contributed 2 lakh rupees out of a total sum of 28 lakhs rupees. That was, my lord, the final figure for repairing the building.
Now, my lord, they realize, my lord, it has come out now. How did he take it, my lord? That is my question.
No, that is
without
a separate, my lord.
That's for the
Well,
final
that is
release,
there.
my lord.
That is there.
Subject to final
Now
accounts.
at present.
Yes,
So
my lord, kindly takes, my lord, this.
At present, with regard to 2A, 1A.
2B, my lord.
No, 1A.
1A.
Page 69, 1A, there will be no problem.
No problem.
1B, then there will be no problem. 1B, you have some problem.
Some problem, but it can be worked out, my lord.
May I
If he's saying
interject
that,
here, my lord, only once, but kindly does not take me amiss, my lord. My lord, 1 and 2 has been looked into, and the contractor has given his requirements, what is to be done at page 72. Let him say, my lord, he's only saying he's not wanting to do C. That is it. My lord, I'm only humbly, I'm just trying to, my lord, cut short
my
that
lord,
thing.
I'm saying that I will do C, my lord.
He doesn't want me to do it.
Yes. Whatever is required, if there are only the gaps are to be filled, my lord, I have no problem. I can do it at my expense.
They're routing of money. The thin line of mortar in the spaces between. But with humility, my lord, 1, 2, my lord, they are the findings. This is the suggestion of the work required to be done.
A, B, C, D.
A, B, C, D.
Well, I am saying, my lord, even after this work, percolation, my lord, still may persist. Because let this also be, my lord, be taken care of. That's all I'm saying. This is the picture, my lord, that I've taken. Kindly takes the second and third page. No, fourth page. Your lordship will, my lord, see there is a tree growing on the pipes. May I just indicate, my lord, right over here? And there are other trees also. Yes, and there are other trees on the top, my lord, because the roots, my lord, are getting into the structure. So let
us go for a maintenance together of the entire building.
No, this, my lord, they have volunteered to repair the rest of it. This, my lord, extraction of the trees, my lord, can be undertaken by both of us. Because at the end of the day, he also needs his
extraction tree. That's why I'm asking. It is a big tree, then the report of the forest is required.
But it is not a big tree. But kindly see, my lord, the fourth page.
Fourth
page,
my lord.
Page.
Sixth
page, my lord. That is what is there in the fourth row. Now, these are shrubs, basically. Not subject to correction from your lordship, my lord. This is not a banyan tree or a big tree, my lord.
So these are the small.
This can be done away with.
This can be done, my lord.
And my lord, these don't have deep roots. These are.
No, my lord. Kindly takes the page thereafter, my lord. There are many other trees.
This is on the top. This is on the top. This is not on the fourth floor.
Let us, my lord, do this also, my lord, just to cover all angles, my lord.
I will do the fourth floor. Let him do that.
My lord, subject to the expenses being shared in accordance to our share in the property. For this work only, for the trees being removed. Whatever is there, my lord, all and sundry can be.
But You're not pointed out, otherwise this court could have been called for the report of that also.
He should have, my lord, inspected this also, because this is right on
I
the,
was required to only
not
internally.
him, the engineer. My lord, he should have inspected this, because this is also a cause for the seepage.
So why you not shown this to the engineer? At the time.
The externally, my lord, they should have. Actually, both the
But
parties should have.
I truly have my doubts about this, my lord, but that will be my personal knowledge. Because these trees, my lord, don't have deep roots, whatever he's showing. Or I'll not go into that, my lord. I will uproot them. My contract will do it, not a problem.
Kindly takes the last page also. Kindly sees this tree.
Which floor is that?
This is the roots have gone deep, my lord. In the this may be on the roof, my lord, but the roots of the tree, my lord, have gone deep from the 5th to the 4th floor. So this is also, my lord, a cause for the seepage.
This trees or the plant, whatever it may be,
These are
it is
offshoots.
in your land or of the other
This
person?
is a separate building. These two are separate buildings. They are conjoined. To the
How this
left
tree
is
has
my
come?
building.
How this trees has come?
Yes.
Who has planted?
No, no one has planted, my lord.
I'll
These are
point out, my lord.
offshoots.
These were in earlier days, my lord, with humidity, my lord. But at birds would fly and drop these seeds. Now, when they used to put on the mortar, my lord.
Now that you have to maintain this.
Yes, that's what I'm on, my lord. Let them maintain. I'm ready.
My lord, subject to, my lord, the cost being borne in equal not equal, my lord, according to our proportion in the property.
Whatever rent we are getting.
That-
No, we are entitled to rent. We don't get a single penny. He takes all the money, my lord.
That's if your lordship deems it appropriate, my lord, we can do it. I'm saying.
So this you are ready for this all four?
All four, my lord. The third one rather, that is
B.
something, yes. That is something I can undertake to do myself.
That is a C.
C.
Marble 4.
C.
The grouting part.
Grouting part.
Let him do the grouting part and show,
Yes.
file report, my lord, or file something.
File an affidavit, my lord, saying
Or
that.
let the Lanet special officer can go and check it. And the others I will do at my own cost. The 4th floor tree, I will do it at my own cost. 5th floor, my lord, if he wants to, he will do it, but subject to, my lord, the final result of the suit. Because I must humbly say, I and all my sisters do not get any money from the tenancy, my lord.
Okay. That will decide.
Lord,
That's what I'm saying. Subject to final result of the suit.
And what remuneration paid or not paid?
Has been paid by the plaintiff, my lord.
The
plaintiff
has given, my lord, the entire money.
That was the direction. Yes. अरे ऑर्डर का था आस्ते 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 रख
What is this?
3 to 9. I'm one.
The special officer has submitted the report after circulating the same.
4 weeks time.
All
this regular but eta na hole
advocates appearing for the parties. The report suggests as follows. Record page 70. The counsel for the defendant number 1. Counsel for the defendant number 1 has submit that he has no objection for making appropriate repairs in terms of the report as mentioned above, except clause C, and he submit that the defendant number 1
for that
of his own will make necessary arrangement for a repair in terms of clause C above, and in terms of clause C above. Considering the full stop, counsel for the defendant number 1 also submit that there are some trees which is also cause for cracks in the buildings, but neither the special officer nor the engineer has visited or noted the said trees, which is also to be cut down for the proper maintenance of the building. The defendant number 1 has filed photographs showing the trees which was just adjacent to the wall of the building, and it is submitted that the root of the said trees are going into the walls, which tax has been. Counsel for the plaintiff and the defendant number. We are for the plaintiff.
For the plaintiff.
For the counsel for the plaintiff and defendant number one submits that the plaintiff will take care and will take care with regard to take care and maintain with regard to cutting down the trees which is rooted in the wall of the fourth floor, and the defendant number one will take care for uprooting and cutting down the trees which are rooted in the wall of the
If there is any gap, I'll just show you.
in view of the above, the defendant number 5, defendant number 1 are directed to maintain either to uproot or to cut down the trees which were rooted in the wall of the fourth floor and the fourth floor and the fifth floor of their own cost for the purpose of smooth maintenance of the said building. As regard the repair in terms of the report appearing in pay as mentioned above, the defendant number 1 is directed to make appropriate report, appropriate repair in terms of the clause C as undertaken before this judge, and to submit the report before this court. With regard to the other portion of the repair, that is clause A, B, and D, the plaintiff is directed to make necessary repairs in presence of commissioner, or you will do?
Well, the commissioner can come at the very end and check it if he wants to. After we complete, let him come and just check it.
How much directed to make necessary repairs of their own cost? Within how much?
Gives me 4 weeks, man.
Within 4 weeks.
If the rains are here, so I'm not too sure about.
From date. Full stop. After completion of the repair work by the plaintiff and the defendant number 1, the same shall be informed to the advocate, the special officer appointed by this court, and the special officer shall be allowed to inspect the repair work carried out by the parties with respect of the 4th floor and the 5th floor, as well as the trees, as well as the maintenance of the trees of the 5th floor and the as regard uprooting or cutting down the trees available in the 5th floor and 4th floor and the 5th floor. And after inspection, the special officer is directed to file the report within a week thereafter. For both the repairs and the defendant number 5 shall bear the cost of the repair as clause C, as well as the trees for uprooting or cutting down the trees in the 5th floor, and the plaintiff shall bear the cost with regard to the repair of clause A, B, D, as well as uprooting or cutting down the trees which is available in the 4th floor of the premises.
But these payments are subject to the final outcome of the suit.
Yes.
The expenditures made by the parties for maintenance of the building shall be subject to the outcome of the result of the suit.
My lordship has given me 4 weeks also, my lord.
Yes, 4 weeks.
But the main matter, extension
I'll have to file my affidavit, my lord, to the main application. Kindly extends it by 2 weeks, my lord.
Yes.
Kindly extends the time to file my opposition by 2 weeks.
Opposition with regard to?
The main GA,
GA4.
What is the GA4?
GA4 is the application.
And the main application was injunction.
And defendant, all are filed now.
Oh, I'm only for one, my lord.
For 2, 4, 6 and 8. You have filed. Somebody has filed. With regard to full stop, counsel for the defendants wait for extension of time to file affidavit in opposition in connection with GA4 of 2024. Let affidavit in opposition be filed within 3 weeks. Reply, if any, there to be filed within 2 weeks thereafter.
Can you indicate?
List the matter before. List the matter on 3 weeks, 2 weeks, 5 weeks. List the matter on 14th of August.
Very good.
By consent.
Yes, call. Fixed match.
12, so item number 40 and item number 41 of the non-commercial.
Non-commercial. Yes.
Well, I won't summarize what I had not argued yesterday because not we have limited time. Not, I had taken your lordship through the order of the division bench, clarifying Justice Munshi's order, making it clear that the personal disqualification, to the extent not it's there, will relate only to the shares belonging to the estate. Now, not the next thing, not which happened in point of time, not are those letters which I've showed your lordship flowing from APL and the meetings. But not the next order which comes, not there are 2 orders which I intend to show your lordship today, 2 judgments, not passed in that matter itself, not both of which will have a bearing on this matter. But the first is the order filed in the contempt. Now, a contempt was filed, not saying that on the basis of Justice Munshi's order, as clarified by the division bench, Mr. Lodha was not entitled to sit at the board meetings or to chair any meetings or to do any business. He could have only come for the purpose of submitting his resignation. This is not the complaint which was made. And the others, because they were aiding and abetting him, were also guilty of contempt. In other words, not all the board members. So, my lord, that contempt petition was heard and, my lord, disposed of. Lord, I intend to show your lordship that order.
GA4.
Lord, it's not annexed. Lord, my learned friend was right. He pointed out yesterday, is it annexed? And I thought it was, it wasn't. Me. Actually, I told you I needed at the beginning. I have it out. What? The other side is Jono the other. I'll just give you a copy.
That's the date, whether it's 22nd April 2020.
Yes, yes. That's the one.
Second.
Yes,
I wanna ask
22nd. No, it is 20. That's the one. I won't trouble your lordship with the whole of it. Not if I could take your lordship straight away first, not to para 8, which is at page 7. Not CC 38 of 2020 is the heading. The summary of allegations are inter alia as follows. HVL continued to hold office as director, chairman in UCL, BCL, BCAB and VTL. 2. He participated in the meeting of the board of directors of the above companies on 5th November, 9th November and 10th November as director or chairman. Then 3. HUL failed to abide by the directions of the APL committee dated so and so, by which the APL committee decided not to support the reappointment of HUL, etc., and he failed to abide by the direction of the APL committee. So, my lord, this is a summary of the complaints. Now, my lord, if your lordship would then come straight away, lord, to page 12. Or my lord, 13, my lord, I'll keep it shorter.
Yes.
My lord, the fifth line from the top, my lord, sentence beginning with, it has been categorically stated. The lordship has got that. It has categorically been stated that the letters dated 6th October, November 3rd, November 5th, 2020, issued to the directors of the companies, depicted an incorrect interpretation of the order dated October 1st, 2020. HVL denied the allegation that he participated in the meetings of the board of directors of VTL and UCL held on 9th November, 10th November, and 5th November of the three companies, as its chairman and director/chairman on the strength of the shares referable to the estate. He contended that he abided by the decision of the APL committee. HVL reiterated that his office as director in the listed companies was not on the strength of the shares referable to the estate, and if the voting pattern in the resolution of reappointment were taken into account, figures would reveal that even on the strength of votes of public shareholders, he would have been reappointed. So, my lord, please see this. Everyone is proceeding on the basis that it has to be on the strength of shares that is disqualified. Now, a trust or a society does not have shares. So, my lord, no contempt as far as that is concerned. There was no disqualification with regard to the societies is recognized by everyone. Now, my lord, from here, my lord, if your lordship then, my lord, comes straight away, my lord, to page Lord, it's the longest judgment. I won't not trouble your lordship. But page 31. Oh, my lord, your lordship can come straight away to 32. 31 was to do with the issue of merger. Page 32, para 37. The sum and substance of the arguments made by the learned senior counsel appearing on behalf of the petitioner is that the deliberate and willful violation of the direction of this court contained in para 20 of the order dated October 1st struck at the very root of the rule of law, which was the foundation of a democratic society. Judiciary being an institution through which the rule of law was achieved, disobedience of HVL and directors of the company shook this very foundation, which would ultimately erode the faith and confidence reposed by the people. Now, they submitted that the order dated October 1st should have been complied with in letter and spirit. HVL, now, please mark this, should have stepped down from directorship. So, not that he had ceased. It required an independent act of stepping down. HVL should have stepped down from the directorship. HVL, by attending the board meetings on the relevant dates in the different companies as director chairman, and the other directors by allowing HVL to attend the meetings and put his signature on the resolutions, deliberately overreached the order of this court. This court, by invoking the extraordinary jurisdiction, should proceed against each of them and punish, etc. Then, according to them, the alleged contemners should not be allowed to reap the fruits of their contumacious acts. Now, please see this. They also submitted that it was not open to the contemners to provide a wrong interpretation of our order and justify their conduct on the basis of such incorrect interpretation. Now, if I may pause here for a minute. Your lordship has seen their interpretation that he had ceased by virtue of the order of Justice Munshi as clarified. This is the interpretation that they were giving. And they say that the other interpretation given, that there is the seizure is only on the basis of shareholdings of the estate, is incorrect. This is the stand that they took. That stand is also now gone by virtue of the later division bench order. Learned counsel further submitted that the directors of these companies who aided and abetted HVL in committing breach of the order of this court were equally liable for having contempt, etc., etc. Now, my lord, if your lordship then goes to 42.
Yes. Yes.
Now, my lord, I don't need to read para 42 apart from the quotation because I need to cover a lot of ground. If your lordship permits, I'll just summarize it. Not the APL committee had made a flow chart showing how there's a chain of cross holding. So this is what was discussed. Then, my lord, if your lordship, let's see from the 7th, my lord, I'll place that, not para. APL committee considered the flow chart entitled Tier-wise Broad Structure of Control of MP Birla Companies through key companies and the statement of shareholding of the promoter group in the 4 listed companies marked as Annex X to its decision came to the conclusion that the APL committee was not in a position to take a final decision regarding what formed a part of the estate of PDB. But so long as the controversy between the parties was alive and pending before the High Court, the APL committee would have to proceed on the basis of, please mark this possibility that the estate of PDB had majority share in MP Birla group of companies. Said flowchart and statement of shareholding referred to above were documents prepared and relied on by the defendants, which are next as Annex I to the minutes of the meeting. Para 26 of the decision of 19 July being relevant is quoted below. At the cost of repetition, the committee is not going to take any final decision regarding what forms part of the estate. But so long as the controversy between the parties is live and pending before the High Court, in suit number so-and-so, filed by so-and-so, against the trust, APL committee will have to proceed on the basis of the possibility of the estate that estate of late PD Birla has a majority share in MP Birla group of companies, including 3 and 4. So they proceed on the basis that they own everything, even if she has 0 shareholding on it. In the same decision, with regard to the role of the APL committee, it was observed as follows. At the time, the APL committee would hasten to add that the committee had not attempted to take over the management and control of any of the listed companies. So, while saying this, they say we are not taking control. But look at what they have done with regard to societies where there is no shareholding. And Lordship sees the underlying portion. It is the view of the APL committee. It's not possible for the APL committee to virtually take over charge or management of the listed companies, which was also the view of Justice Ravindran, erstwhile chairman of the APL committee. But it's after Justice Ravindran retired that this whole confusion came up with not them taking the stand. Now we control everything all the way down. But in fact, as far as this is concerned, that your lordship may make a note that page 262 of the division bench order not passed later, because that specifically considers it and says that this action of the APL committee was without power.
That is clarified.
So we placed it. But I am just giving your lordship the cross reference. Now, my lord, please comes to para 45. Finding.
Yes.
Allegations of contumacious acts enumerated in the application do not disclose that HVL violated any of the above mentioned directions. I've showed your lordship not the 4 allegations, including not complying with not APL directions. So these are held not to be violation.
Yes.
And bullshit. Now, my lord, please see the nature of the complaint made to the companies in this case. Not same as in the case of the society.
Yes.
Now, my lord, please see para 47. On the above issues, the decisions of the APL committee dated July 30th, 2019 are set out here under. Now, decision is this: APL committee having control of the majority shareholding in the companies in the MP Birla group of companies, including Vindhya Telelinks. Now, my lord, this is also held to be incorrect. They don't hold majority shareholding in these companies. Does not support the resolution for reappointment of Lodha as director. So, my lord, case is not that of automatic cessation. Please don't reappoint. Then, my lord, please see the para after that. However, the committee does not support payment of profit-based remuneration, etc. Then, my lord, please come to the item below Roman 2. Committee accordingly directs that a copy of this decision shall be sent by the secretary of the committee by email not later than so-and-so to all companies and their directors. This decision will also be sent by the secretary by email to at the earliest and not later than morning of so-and-so to the trustees and managing committee of the following trusts and societies which have shareholding in the companies of MP Birla for a long time as forming part of the promoter group for doing the needful. So, my lord, please see these societies all mentioned, including, my lord, Eastern India Educational Institution, which is item number 6. So, my lord, these notices went out to everyone saying you have to comply for doing the needful. And Lord 8, your lordship will find is South Point also. Then Lord 48. Although there are allegations against HVL for violation of para marked A of the above noted decision, but there are no allegation of violation of decisions marked B and C above. It's pertinent to mention that while disposing of SLP, Apex Court had made reappointment of HVL subject to the decision of the learned judge. Learned single judge refused to set aside the reappointment of HVL as a director, and aggrieved by such refusal, cross objections have been filed, which are pending hearing. Then, my lord, allegation of not abiding by decisions in para A above is taken up for consideration. Division bench of this court in GA so-and-so, which was heard analogously with other applications, recognized that the APL committee enjoyed the rights incidental to ownership of shares in stock held by deceased and would have to apply to the respective companies to obtain such benefit in case the company came out with rights issue or dividend shares, etc. Division bench also observed that it was not in dispute that the controlling block of shares, etc. All of that. Now, my lord, if your lordship then comes to, Lord, it goes on to explain at para 50, all that they could do is get their names recorded as shareholders. Lord, that's para 50. In a trust, my lord, of course, that's not possible. Then, my lord, para 53. Now, they go on to say, apart from the fact that there is no such violation, in any case, it's a possible view that he got re-elected on the strength of shares not belonging to the estate. That's para 53.
Yes.
With regard to allegation of violation of the order, second part of the order restricting HVL from holding any office in MP Birla on the strength of shares referable to the estate, we find that going by the voting pattern, it's a possible view that HPL could have been reappointed even on the strength of the shares not referable to the estate of PDB. I.e., now, see, it's fully not explained. What is her estate? Personal shares of PDB and shares referable to the promoter group and persons acting in concert. In all the AGMs, the shares which were in the name of PDB voted against reappointment of as director of these companies. The voting figures and statistics have been elaborately stated in the affidavit, etc. They have not been rebutted. And then, my lord, para 55. Although the defendants all along contended that the issue as to what comprised the estate of PDB had already been decided through different judicial orders of this court as well as Apex Court and should not be reopened to give a different interpretation, it's possible that the extent of estate with regard to controlling interest over MP Birla group of companies would include shareholding of promoter group and persons acting in concert with PDB. However, if HVL could have been reappointed even without the votes of the promoter groups and PSCs and only on the votes of public shareholders. In such event, it is also possible that HVL did not continue to hold office only on the strength of shares of PDB. HVL could also hold office excluding the shares referable to the estate of PDB. Thus, the contempt has not been proved beyond reasonable doubt. We hold so on the basis of the pleadings in the opposition filed, when HVL could have been reappointed on the shares of public shareholders, invitation to HVL to attend board meetings and participate in the same was as per procedure prescribed under Companies Act. If HVL could be reappointed as director on the strength of votes of public shareholding alone as per the voting figures, any deeper probe in the merits would not be proper. Then, just giving you the para. 55. Then, my lord, amendments in the opposition filed by the alleged contemners, including HVL, has raised a valid question with regard to HVL's continuation in office. The possibility of his reappointment only on the strength of shares of public shareholders can't be ruled out. No contrary figures are forthcoming in denial of such possibility. Then, my lord,
no, the possibility of the reappointment only on the strength of the shares of the public shareholder can be.
So not on the basis of shares of the estate. These are public company with not lakhs of shareholders. Direct shareholding in these companies is not 1260 shares, PDB shares in Birla Corporation, for example, 1260 shares, which is 0.001. So, my lord, even with all these shares not in which not which are recorded in their names, it won't have affected the resolutions. Not.
Okay.
Then, my lord, this was they tried to, my lord, say this is not the basis. Then, my lord, so your lordship comes to para 57.
Yes.
On the one hand, affidavit of assets and the inventory interim report of APL committee gave rise to a possible interpretation that the extent of the estate and the controlling interest of PDB can be to the extent admitted by the alleged contemners. On the other hand, the extent of estate can also be contended by the petitioners. Controlling interest is, however, yet to be conclusively defined and quantified. Now, my lord, all of this has now been done by the division bench. All these are decided beyond doubt. At that stage, my lord, the court was looking at, my lord, appeals against interim orders at the, my lord, and at interim stage, contempt file. Court said, look, everything is in flux possibly, but there is no violation of the order by his getting reappointment. And these are the questions which are left open. Those are now, my lord, finally closed against my learned friends. Controlling interest, however, is yet to be conclusively defined and quantified. I'll show you, lordship, that specifically dealt with. APL committee has not quantified the same. In this case, extent of control can also be influence PDB had over shareholders, promoter groups, or persons acting in concert. Not this is also decided that not on death, this vanishes. It's not a heritable asset, can't form a part of the estate. Then there's a possibility that the promoter groups and PSCs did not vote in concurrence with APL decision in the AGMs where HBL was reappointed. Moreover, there is also no allegation of dissipation or depletion of estate or transfer of shares in violation of the order of status quo, and thus the emphasis laid by Mr. Mukherjee on orders of status quo over shares, as also orders of CLB, are not relevant in contempt proceedings. There is also a decision of the division bench of the court where controlling interest of the estate of PDB was held to be primarily in the nature of shares, which has been mentioned in the affidavit of assets filed by the respective parties, as also the inventory filed by the APLC. Moreover, APL committee recorded its wish not to take over management and control of the company and recorded that no final decision is there. And then, Lord, in para 60, they say, looking into those issues that you're talking about will be beyond the scope of a contempt court. Lord, that's para 60. And then, my lord, para 66 and 67. In our view, the rival contentions involve an interpretation of orders passed in probate proceedings by the CLB and other documents filed in the course of the suit. We are not deciding in this contempt case whether the interpretation of estate of PDB as given by the respondents or the one given by the petitioners is correct or not. The question has to be decided in the pending appeals. Now, my lord, the appeals have now been decided and there is no stay. For the purpose of this proceeding, it's sufficient to say HVL's participation in board meetings cannot be termed as contumacious violation of the order of this court, as the willful disobedience has not been proved beyond reasonable doubt, and there's a possibility HVL could have continued to hold office on the strength of the votes of public shareholders to the exclusion of votes of the APL committee and the other groups. Contempt application is hence dismissed with regard to contempt against director of the company in view of the aforesaid finding of this court. HVL has not committed contempt by attending board meetings. The contempt proceeding against the director is also dismissed. Now, Millard, therefore, Millard, conclude on this. Millard, please remember this is in the context of companies alone.
Yes.
Now, three things follow from here. Number one, there was no violation as far as societies were concerned because their interpretation is if you do it on the strength of shares held by the state.
Yes.
That's number one.
Yes.
Not, that is number one. Now, number two, not, they proceed on the basis that even as far as companies is concerned, a act of resignation was necessary. Otherwise, he did not cease. There was a positive act required of having to step down. That is the submission made. I've showed your lordship the para. Number three, even as far as the companies are concerned, this was not a violation of the order by continuing. So for trust, my lord, by no stretch of imagination can it be said that there was a violation by continuing. In other words, to put it differently, there was no cessation as far as the trusts and societies are concerned, and that is the main takeaway from the arguments made over here by the rival sides and the finding of the court. So, this is what happened. If he was permitted to continue as a director, it's equally not true that he could continue as trustee. If anything, in fact, there was no disqualification at all, as no contempt was filed. So, this is the contempt. Now, after this, the appeal was finally heard. Now, it's a 300-page judgment, but I'll not trouble your lordship with 300 pages. The first 233 pages are submissions. I'll not even trouble your lordship with showing what the submissions are, because the findings are set out separately. So may I show your lordship the division bench judgment, which is at GA4 in CS 16. But starting at page 214. Start with para. Page 230. Your lordship will have to take volume 3 of GA4. I'm not taking your lordship through the first 230 pages. The lordship comes straight away to page 2, in page 231, which would be what a page though? Not page 444. But towards the end of that volume.
444.
444. Yes. One is again. But again, I want to just show this one.
Yes.
Your lordship kindly gives me a moment. But the findings actually start from inner page 226, which is para 103. And my lord, if your lordship would come to the bottom of 103, which is inner page 227. So my lord, the court here frames the questions it's going to answer. But just after the table, out of the labyrinth of arguments advanced, the following broad issues and sub-issues emanate for adjudication in the present case.
Page?
Not page 220, page 440, 440. But there's a chart over there. Second last paragraph, just before the heading, just below the chart. Out of the labyrinth of arguments advanced, the following broad issues and sub-issues emanate for adjudication in the present case. Number 1, powers of the probate court under 247 of the Succession Act. Not 2 points over here, question of title, and 2, third-party injunction. Before the discussion, I'll just give your lordship the answers. But the answer to the first question is probate court can't decide any question of title, and that's held by the trial court also. And it could not have decided anything with regard to tier 3 and 4 companies. And Lord, it clearly disapproved of the decision of the trial court. Then Lord, third-party injunction. The answer is rarely. One can pass injunctions against third parties, rarely, almost never with regard to internal disputes of companies. And they held that the trial court had correctly held that no order can be passed against third parties. Then Lord, number 2, extent of estate. Number 1, Lord, only shares or controlling interest. Not held, only shares directly held by her. Personal influence, other things, they are not hereditary things, Lord, they die on death. So only shares directly held by the deceased. That's the answer given to 1. Then Lord, 2, controlling interest. They say it is by virtue of shareholding held. Influence and other things will not die on death. Then Lord, 3, extent of whether the issue of extent of estate is barred by res judicata and barred by estoppel against HUL, and the answer was no. Then, my lord, APL administrator litis powers. How far APL can interfere in the company affairs? It goes on to, my lord, I'll take your lordship into that. And whether the decisions have to be unanimous or majority view prevails, they held majority view will prevail. So now, my lord, if I can just show your lordship the findings, if your lordship can come, lord, to comes to para 105, which is at page. Or give it to me, 442.
Yes.
Lord, it notes converging thing, Dillon's case, not the sentence after that. It was therefore not competent for the probate court to determine whether the person had or had not the authority to dispose of suit properties which he purported to have bequeathed by the will. The probate court is also not competent to determine the question of title to suit properties, nor will it go into the question of whether the suit properties bequeathed by the will were joint, etc., etc. Then, my lord, if your lordship goes down, Lord, it holds Succession Act is a self-contained code, and if your lordship, Lord, comes to the last two sentences, last two lines of that page, thus it does no more than establish the factum of the will and the legal character of the executors. The probate court does not decide any question of title or existence of the property itself. And Lord goes on to say that has to be done by the civil court. Then, Lord, if your lordship comes to the bottom of Lord page 443, last 7 lines, Lord, whether not starting with whether the testatrix had title to the property or not, basically is a question to be decided by the civil court, since after proceedings relating to adjudication of a civil dispute between two sets of adverse parties. Further, it was held that grant of probate by itself does not confer any right or title upon any person in respect of any property, since all such questions are subject to adjudication by the appropriate civil court. Now, my lord, in light of the above settled position, we cannot approve the findings rendered by the learned single judge. Having ventured to go into entitlement of the estate to the excise control of tier 3 and 4. So, my lord, the trial court could not have done it.
Yes.
Clear finding, lord. And then they look at the judgments, then, Lord, 106 is the second issue. So, first issue is answered that way. Second issue, third-party injunctions can be granted in exceptional cases by the probate court for the limited purpose of protecting the estate. However, internal affairs of third-party companies cannot, under normal circumstances, be interdicted by the probate court. But then they look at the law and they say, look, we don't need to decide it because the trial court has already said it can't pass orders against third parties. So that your lordship will find, Lord, at para 108, which is, Lord, page 246. Lord,
yes.
Para 108, page 446.
Yes.
Lord, if I may just read the last 4 lines, or Lord, 5 lines. Just after Atula Bala, Lord. Thus, having taken note of the above legal position, the next issue to be considered under the head is whether the probate court can pass orders against third parties. We need not labor much on this issue, as the learned single judge has rightly noted the proposition of law in this regard and held that the companies not being parties, they are not amenable to the jurisdiction of the probate court. So, Lord, please now translate this to trust. We were also not parties. In fact, we were not given notice at all. So, there was no question of Justice Munshi's order, Lord, affecting us. While considering whether the companies can be joined as party defendant, the court held that notice companies can neither be joined as a party defendant, nor can an order of restraint be passed against such companies who is not a party to the proceedings. But this is Justice Munshi.
Yes.
Further, the court held it cannot extend its jurisdiction to a person who is not a party to the present proceeding. So, Lord, jurisdiction does not extend to the societies. Further, the probate court cannot extend jurisdiction over a person or entity who is not a party to the proceedings. Further, it was held, since the noticee companies being not a party to the proceedings, no order can be passed against it. Respondents have filed cross-objection against these findings recorded by the learned single judge, which needs to be rejected. So, Lord, their cross-objection against Justice Munshi's findings that no order can be passed against third parties, their cross-objection is also dismissed. In the decision reported in so-and-so, Honorable court observed that the court has no hesitation to hold that the probate court cannot pass any injunction order against the third parties, as third parties who have no caveatable interest in the probate proceeding cannot be allowed to be added to the party in the probate proceeding, and also for the reason that no order can be passed affecting the right of stranger without adjudication of his rights in the probate proceeding is impossible, as the probate court cannot decide any foreign issue unconnected with the probate proceedings. So, my lord, that's the clear finding. Then, my lord, issue number 2 is at para 109, which is, my lord, page 448.
Yes.
To decide the extent of estate of the deceased, the court has to ascertain, para 109, has to ascertain the powers which could be exercised by the deceased testatrix herself. Powers of the probate court while appointing an administrative pendant liability are coextensive with the powers of the testator or testatrix. As a necessary corollary, the powers of an APL formed by the probate court cannot exceed such limits. So, my lord, your lordship has first seen no power over third parties. Therefore, APL also can't go beyond that. Then, Lord, 110. Lord, this says that the rights of the estate are limited to what is mentioned in the affidavit of assets over there. 110. That's 110. And trusts are not part of that affidavit of assets. With regard to the shares in several companies, PDB's powers were restricted to ownership of the particular shares in different companies as mentioned in the affidavit of assets. So, my lord, limited, cut down, narrowed. No scope for any dispute now, my lord. 2 shares held by her personally in her name. In such context, the expression controlling interest should not be confused with personal influence of the testatrix. Whatever might have been the personal influence of the deceased testatrix, the same was intangible and restricted to herself. The charisma or personal influence of the deceased might have helped her in carrying out her will in the affairs of the companies, but did not comprise of tangible incidents of her property or estate. Thus, it cannot be said that a personal influence is in any way or manner a part of the estate. Now, coming to the issue of controlling interest, it has been argued extensively that PDB had control over the affairs of the second, third, and even fourth tier companies by virtue of a shareholding in tier 1 companies. However, at the ground level, such influence is only theoretical as an incident of her actual shareholdings in tier 1. The mathematical advantage which PDB might have had by virtue of majority shareholding of tier 1 companies could only be translated in assertion of influence of tier 2, 3, and 4 companies of actual presence of PDB in their shareholders meeting and other exercises for PDB participated by virtue of her actual shareholding. So, if she was an actual shareholder, yes, definitely, as it was open to PDB as majority shareholders in tier 1 companies to attend shareholder meetings and assert her influence by virtue of voting rights, otherwise part of incidental rights of a shareholder. However, without actual participation in voting and other decision-making process, such advantage would be merely inchoate. Then, 115. As a natural corollary, the APL to be appointed by the probate court for looking after and managing the estate of the deceased steps into the shoes of the deceased and does not have an iota or right of power more than the deceased herself would have had. So, could not have stepped beyond. Then, 116. Hence, at best, Hence, at best, the probate court can direct the APL personally or through its appointees to register itself or its agents as members of the companies in the capacity of owners of the shares actually owned by PDB in such companies. That is all. Please see, it sets a limit. At best, the probate court could have directed this much and nothing more. Upon such registration, the APL or its nominees would function as shareholders and have all incidental rights and controlling power which PDB would have had by virtue of such shareholding, including voting right, participation right in decision-making process and meetings, etc. However, the probate court cannot go an inch further than that in interfering with the business of the companies. So, number 1, restricted to actual shareholding. Number 2, your lordship has said seen that at best it could have directed APL to do this, but it could not go even an inch further in interfering with the business of the companies, and blood where there are no blood shares at all, as in the trust, it can do nothing at all.
Yes.
Then, my lord, if your lordship would come to, not we can skip quite a few paras from here, otherwise, not I'll not be able to finish with this judgment. So, your lordship then comes to page 251. Not the next chapter is to do with not judgments, not in other proceedings between parties, though those are being considered and distinguished. And if your lordship would then come to follow up. The next one. Page 400 page 251. But 464, page 464, which is in the next volume. But that is a part of para 127, which is a very long para.
Yes.
Your lordship would come to 464. Not about 6 lines from the bottom. Thus, in several places, the Honorable Division Bench has emphasized that the rights and privileges exercisable are incidental to ownership of shares and stocks, and therefore a different meaning cannot be given, nor the decision can be understood to mean that DO's ownership rights in shares and stocks APL will be entitled to exercise rights, powers, and privileges. So, not made very clear, only right is through shares, no other way.
Yes.
APL will be not different meaning cannot be given, nor decision can be understood to mean that DO's ownership rights in shares and stocks APL will be entitled to exercise rights. So it is only qua shareholding that it can exercise any right at all. Otherwise, not no other right. Then, my lord, if your lordship then not jumps a page and comes to page 466, which is a part of that same para, my lord. It's a very long para. Not if I may read, not from halfway down the page, not sentence beginning with thus. A careful and cumulative reading of all the findings.
Yes.
Your lordship has found it. Thus, a careful and cumulative reading of all the findings / observations, the correct interpretation would be that controlling power is the proprietary rights of ownership of stocks and shares. Further, the court also specifically held that APL has to apply to the company as required under law to record their names in the register of members, and the company will have to consider such an application in accordance with the articles and the provisions of the law which govern the same. Now, Lord, here, not one of the arguments made on behalf of the companies had been, look, APL can't just come and say, look, appoint him as a director. You have to go and follow all the requirements of the articles and the Companies Act, which says you have to give a meeting, a nomination has to be made, shareholders will vote. If they decide to reject the nominee of the APL, end of the matter. But you can't simply say, I appoint ABC as director. Now, this is what is being dealt with over here. Court is saying, look, you have to comply with articles, Companies Act, all of these are binding.
Yes.
They said, look, all this doesn't matter. Now, the learned single judge had said that I don't need to decide any of this because no order can be passed. Now, if I may read on from here. Therefore, no extraordinary power was granted to the APL, and they were to abide by which the dictates of the Companies Act. Therefore, it would be an incorrect way of interpreting the judgment to pick up a few words and sentences to hold that the controlling block of shares would mean rights over shares which were not standing in the name of deceased. So, very clearly, this submission rejected. Shares holding held in the name of the deceased only.
Yes.
But if I can take your lordship then to page 468. It forms a part of para 128, which is again a very long para, but I won't place all of it.
Yes.
255. Last 2 lines of that page, that the court in a probate proceeding cannot pass any directions encroaching upon the jurisdiction of the board of directors or takeover of manufacturing units by purchasing shares. Further, court categorically held that APL should be made to agree so that APL can exercise its power of control over management of BCL by following provisions under Companies Act, and in case APL fails to discharge its duties, probate court can pass necessary directions upon APL for No. Further, the probate court can at best pass necessary directions on the APL to initiate appropriate proceedings before appropriate forum for seeking appropriate relief and in accordance with law. And it is only that appropriate forum which can pass appropriate orders for adjudicating rights of parties. Thus, it is clear that it is extent of shareholding which enables the shareholders to control the company, and any other interpretation will fall foul of the definition of control under 227. So, that answers what is control. That restricted to shares. And the court is very clear, look, APL, if it gives directions, no one is obliged to follow it. If they don't follow it, go file a civil suit and obtain relief. That's what it's saying here. Then, issue 2. Issue 2 starts at para 130, which is not on the next page. Not page 470.
Yes. Yes.
Issue 2.2. Controlling interest in the present context can only mean the incidental rights, including voting rights, rights of participation in shareholders' meeting and other decision-making process, which PDB would have had by virtue of her shareholding in the respective companies. In other words, not through the chain of companies that they talk about. Then, the court looks into Vodafone. There's a long discussion on that, and if your lordship would then come straight away to page 473. Uh, 260. Now, this para is important now. Now, 132, on going through the order impugned in this appeal, we find that the learned bench had held that no order can be passed against the companies. It has also been held that the court is not deciding any of the points urged by the companies. Further, the companies could exercise voting rights flowing from the investment in the companies controlled by PDB in the manner to be guided by the APL committee. I've showed your lordship that manner to be guided by the APL. Now this is being considered. Further, the learned judge, a single judge, was of the clear view that it is not deciding any of the points urged by the companies, and also recording a finding that no order can be passed against the companies. In our view, the observation that the companies controlled by PDB in the manner to be guided by APL is contrary to the other findings in the impugned order. So this guidance could not have been there at all. It's contrary to the finding of the learned judge himself. Once you say I can't pass an order and I'm not deciding any other point, you could not have passed a direction. Therefore, this finding appears to be clearly inconsistent with the findings recorded by the learned single judge in more than one place in the impugned order.
Yes.
Lord, your lordship will remember now what has happened in these cases. All those letters are the guidance by the APL saying appoint so and so, or do so and so, or vote in a particular manner. All this said couldn't have been done. But please see this, the single bench also said that it had no jurisdiction at all. So, in any event, the APL could not have done what it did after Justice Munshi's order. But not giving them benefit of doubt because of that one line, APL's guidance, that also could not have been a mandate. Guidance. Not that APL orders will be followed by the whole world. There can't be such an order, against the whole world. Now, given that situation, and having held that no order is passed, this is an inconsistent finding. Then, when such inconsistent findings were tested by the Honorable Supreme Court, they've been interfered with and orders have been set aside. One such being in the case of Narayan Das Agarwal. At this juncture, we note that in the impugned order, the learned judge has accepted the proposition. Now, please note this.
Yes.
Learned single judge accepted the proposition that since there was no dispute that a company can only recognize the shareholders whose name is in the register of members and cannot recognize any other person. Such argument was made on behalf of BCL was accepted by the learned single judge. There appears to be no serious challenge to the proposition which was accepted by the learned single judge in the cross objections which have been filed. So, my lord, in the cross objection, this is not challenged. As pointed out earlier, the learned single judge has held that it was not deciding any of the points urged by the companies. If that be so, the court, without deciding on its jurisdiction over the companies and recording a specific finding, in our view, could not have issued the directions as to how and in what manner the companies had to function, and they had to be guided by the APL. On a reading of the impugned order, we find that the objection raised with regard to jurisdiction of the powers of the joint APL to pass direction had not been decided. Further, the direction had been issued to implement the directions of two joint APLs. The effect of the directions issued by the learned single judge have been demonstrated before us. But these were the kind of instructions: appoint X, appoint Y. If the directions of the two APLs dated 19 July and 30th July are to be implemented, it would give power to the two joint APLs to directly appoint directors in the company and compel the companies to implement all decisions of the two joint APLs with regard to the manner in which listed companies could exercise voting right. So, this is what they were doing. It says can't be done. In the earlier portion of the judgment, we have noted the decision of the Supreme Court in AR 55 Supreme Court to the effect that its company and its shareholders are separate and distinct, and the assets of the company don't belong to the shareholder, and even 100% shareholder is not the owner of the company, etc. So, they've seen that the effect of APL giving direction would be complete, throwing out the articles, Companies Act, etc. That is noted. Then, if your lordship comes to page 2, inner page 264, which will be page 477 of that volume, Lord.
Yes.
Now, this was another proceeding, relating to a challenge made by some of them to the holding of another Birla company, Birla corporation, and in that context, that is being discussed here. If I may read, from the second line, after rendering the above finding with regard to jurisdiction of the court, probate court, the court held that it has no hesitation to hold that the probate court can't pass any injunction against third party, as third party who has no caveatable interest in the probate proceeding can't be allowed to be added as a party to the proceedings, and also for the reason that no order can be passed affecting the right of director without adjudicating the right, and adjudication of the rights in probate proceedings is impossible, and the probate court cannot decide any foreign issue unconnected with the probate proceedings. So these can't be decided. Then, para 133, last 3 lines at the bottom of the page, the court reasoned out by observing that HUL is not a party in his capacity as chairman of the board of directors of BCL. No directions can be passed against HUL in the capacity of being chairman of the board of directors of the company.
Yes.
So, then 134. Ultimately, the court concluded that the decision of the board of directors has no subject. But this is, I'm sorry, but page 479, 479, 134.
Yes.
Ultimately, the court concluded that the decision of the board of directors has no subject to the control of the promoter's controlling power over the management of the company, since the probate court can't pass any direction or injunction against any person who is not a party to the probate proceeding. Further, since no adjudication of foreign issues was possible before the probate court, in the absence of any party who has no caveatable interest in the probate proceeding, the relief claimed by the applicant therein was not granted. Then, I can't. Then, 135. At this juncture, it will be worth reiterating the finding recorded in the Honorable Division Bench, in ILR 2007 to Calcutta 377. The Honorable Division Bench, after considering, that was also not a inter-party, Birla Lodha proceeding. Birla Lodha proceeding. The Honorable Division Bench, after considering the material on record, materials which were placed before it, and also pleadings after perusing the order of the learned single judge, held that the implication of taking over the voting rights and right of 38 companies has nothing to do with control of the companies. In other words, to take over management of the companies. Now, Millard, please see this. Therefore, the division bench held that the effect of the order to dislodge the board of management without considering the provisions of the Companies Act is not sustainable. And this, Millard, the court had held in these very proceedings, Millard, in 2007. Further, the Honorable Division Bench noted the specific provisions of the Companies Act setting up out the methods of rectification of the share register and to dissolve board of directors, which has to be done as laid down under so-and-so section of the Companies Act. Therefore, the court held that the learned single judge, by appointing the administrator, directing to rectify the share register and appointing them as directors, superseding board of directors, are not in accordance with law. However, the probate court has no jurisdiction to pass such order, and accordingly, the order of appointment of APL over MP Gibilla group of companies and directions given by the learned single judge was set aside. So this was in an earlier stage. But when Mr. R.S. Lodha, the executor of the will, was perhaps alive. Then, at the bottom of that page, the issue in the probate proceedings relates to adjudication over and due execution of the will, and the court itself has no duty to determine title. The court of probate, with a copy of will annex, establishes conclusively as to the appointment of execution and valid execution of the will. It does no more than establish factum of the will. Millard, I don't need to go into that. Then, Millard, if your lordship comes straight away to page. Millard, here, Millard, the judgments are being discussed. Millard, if your lordship comes straight away to issue 3.1, which is at para 166. At page 494.
Yes.
A short answer to the question as to how far APL can interfere in the company's affair has to be answered in a conservative manner. The APL stepped into the shoes of the deceased and cannot exercise powers which the testatrix herself did not have. PDB, being the owner of certain particular shares in certain companies, could only function as the shareholder of such companies. The shares and incidental right thereto, such as voting rights, were definitely the property of PDB, but her personal charisma, authority, influence asserted over shareholders and companies definitely do not come within purview of her property. Then, para 167, thus the APL can merely step into her shoes and register itself for its nominees as owners of the said particular shares, including consequential registration as members. However, even if one proceeds on the premise of PDB's estate regarding companies were limited to a shareholding of 1260 shares, it is open to debate as to how far such shareholding can empower the shareholders thereof, since the said shares confer on PDB estate majority shareholding in tier 1 companies. The decision making of such companies as shareholders in other lower tier companies would definitely be influenced substantially by the majority shareholding alone. However, a delicate balance has to be struck with the said position and the cardinal company law doctrine that shareholders are not owners of a company and do not have any interest in its assets. This proposition has been well settled from Gazdar's case. Not two more judgments cited there. I'll skip that. If your lordship not straight away comes to 171 and 172. There's nothing to show. I'm sorry, I'm rushing your lordship through it, but not. There's nothing to show that the estate of PDB is a beneficial owner of the companies or that its significant beneficial ownership with a depository was ever recorded. Hence, Balkrishna's case are squarely applicable. Then, 172. Hence, the testamentary court cannot pass orders directly in respect of the management and affairs of corporate contractual rights of other entities, including companies, trusts, etc. Trust covers us fully. Testamentary court could not have passed any orders. APL, your lordship has seen, can't go an inch further.
That has been decided.
Then, para 178, which is at page 497. 178. It cannot be in doubt. APL's powers cannot go beyond those of the testamentary court itself. Testamentary court's zone of operation in turn is coextensive with the estate of the testatrix. So, trust societies don't form a part and clearly held that they can't touch them. Then, if your lordship sees para 180 at page 498. The restriction which is to be exercised by the testamentary court is to limit itself to asserting such powers associated with voting rights and other essential rights by virtue of shareholding through democratic process of participating in shareholders meeting, actual voting, decision making, and not by issuing whips from court. This is so because the deceased testatrix herself during her lifetime could not have done so. So, my lord, issuing these letters saying appoint so and so, remove so and so, X has seized, I am the court's officer, I am the court's representative, you must do what I say. All that, my lord, said to be not permissible. Then, my lord, 181. Here, we must be careful to distinguish personal influence, charisma, and authority PDB may have enjoyed over companies, their directors and shareholders during her lifetime from her rights as shareholder in the concerned companies. Personal influence, control, and sway do not translate into bequeathable rights and get extinguished with the concerned person. Rights as promoters or directors are also not heritable and thus cannot be the subject matter of a will. Now, my lord, similarly, trusteeships are also not heritable, directorships are not heritable. So, my lord, same thing will apply, my lord, to this trust or a society. Then, my lord, para 184. Supreme Court in Chandrabhan's case held that testimony in court does not have jurisdiction to pass orders against individuals / entities acting in a different capacity. Now, here, my lord, your lordship will remember what the distinction made between companies and entities. Entities belonging to the MP Birla group, that is how they try to bring it in. So, my lord, entities also covered over here, can't pass orders against entities. Hence, the testamentary court can only have control over shareholding and ancillary rights. So, my lord, only shareholding. Trusts and societies, no rights, including voting rights in companies. Of course, the court cannot participate in the day-to-day affairs of companies, and precisely for this reason has appointed APL to represent the estate. The testamentary court is not a company court and is not sitting in judgment over allegations of mismanagement, fraudulent transaction, thus need not lift the corporate veil in the current context. Then, my lord, para 187. It notes that, my lord, APL does not have any adjudicatory rights. Para 187, by placing reliance on AI at 2000 so and so, it has been argued court can't delegate functions to any authority. Although true, the theory is not applicable if the testamentary court appoints an APL under section 247. What is delegated is not the adjudicatory function or the supervisory power of the testamentary court, but only the day-to-day ground level operation to protect and preserve the interest of the estate. Now, my lord, what they had been doing, my lord, the APL committee were giving notices, holding hearings, and adjudicating. Now, it's held here that, no, you can't. 188. Hence, the testamentary court in the present case can and should clothe the APL with powers to enlist themselves as members of companies where testatrix held shares in the capacity of shareholder and also to exercise, powers related to, my lord, the shareholding. Then, my lord, 189. My lord, this is issue 3.2, which I think, my lord, I can skip entirely. This was the question of, my lord, whether the majority is to act or all three. So that is not required, my lord. They hold that majority. Then, my lord, 199. Lord, we are almost done with this judgment. Lord, in any event, I'm sorry, Lord, page 503.
Yes.
In any event, since the APL is not an adjudicatory authority and cannot act so, there does not arise any question of the testamentary court delegating its powers to it. APL shall strictly act in accordance with the observations above, limited to its role as a shareholder with ancillary functions, including voting rights, which are to be used judiciously to protect and preserve the interest of the estate during the pendency of the administration of the estate. Pendency of the letters of administration suit. Then, my lord, the findings on para 201 onwards, those findings are summarized, which I've given your lordship. That's the finding. It's summarized. 202, my lord, issue number. Each of the issues now, my lord, summarize the answer. Issue 1, testamentary court can't decide issues of title conclusively. Then issue 2, third party injunctions can be granted by testamentary courts in exceptional cases. However, under normal circumstances, it can't interfere with third party companies. Then 2.1, estate is only those held specifically in a name. This is just summarizing the findings made above. Then controlling interest and so on and so forth. So this summarizes it, and then page para 210, page 296. Sorry, page 509.
Yes.
Issue 3.1, answer to the issue lies embedded in the previous issues. We cannot but be a bit conservative. APL steps into the shoes of the deceased testatrix, nothing more, nothing less. Thus, it can't exercise powers which the testatrix herself didn't have during the lifetime. She was the owner of specific shares in some companies. In such capacity, she had all incidental rights like voting rights, decision-making powers, etc. Ownership of shares and rights directly incidental thereto are heritable rights which devolved on her estate on her demise, but her personal charisma, authority, influence asserted over shareholders and management of other companies, if any, were not heritable and are not property which can be subject matter of her estate and consequently under the adjudicatory court or authority of the testamentary court. So, the same thing with other offices held by her, including trusteeship, directors. Then, 211, we are required to distinguish between rights directly flowing from incidental to such ownership of shares and those which are remotely derivative from ownership of from such ownership and not proximate. The former are the subject matters of the estate, and APL can exercise those, but the latter, i.e., remotely derivative rights, cannot be thrust by the testamentary court or the APL on the respective companies, which are independent juristic entities. So, you cannot exercise control of other entities. Then, 212. The APL cannot interfere with all the internal affairs of companies and all the ties with the blessings of the testamentary court. There cannot be any universal or dynamic injunction or direction affecting future course of action of the companies from the testamentary court, simply because the testamentary court, testatrix herself, could not have taken any such decision in law. The same thing applies for the trusts. Then 213, steps taken by the APL in registering nominees as members of companies where the deceased held shares in consonance with the ratio of the shareholding in each of the companies perfectly justified in law. APL, through its nominees, may well decide which way the votes of the testatrix shares should go. So, based on her own shares, yes, and how they should exercise their voting rights in the election of directors, nominees of such shareholders may participate in shareholders' meeting and decision making in the process of Tier 1 companies, and thus the course of action and business decision of such companies. So, limits it to Tier 1, and that's the end of it. Then 214, even there, however, such process can only be done in above board and legal manner and in due process of law. APL, for example, can't jump steps to directly take or preempt business decisions in respect of tertiary tier companies without going through the process of first taking decision in first tier company, getting its decision approved through representation in Tier 2, then Tier 3, then Tier 4. Then, as and when any major decision is required to be taken regarding transaction of shares, APL mandatorily has to approach testamentary court for direction. Can't do anything itself, can't take any major decision. Then 216. Also, the APL itself, being the repository of interest of the estate as the representative of the testamentary court, shall have to take appropriate directions and orders from the testamentary court prior to initiating or contesting any litigation. Now, here what they had been doing was, they had initiated proceedings before NCLT. They had filed appeals against orders where they were not parties before the Supreme Court. Our day-to-day decision at every stage of litigation need not be brought to the notice of court, etc. I won't trouble your lordship with the rest, but after showing this judgment, there are very small, two other judgments which I'll show your lordship, and then get to the meat of the matter on the next day. And one thing I add, SLP filed against this, no stay granted. Stay refused. Interim order, no interim order granted.
Yes.
I'll place that on the next day.
How much time you will take further?
But your lordship gives me about roughly not 2 hours. But
2
I'll
hours.
try and not bring. Your lordship has seen that they are long judgments. But we made very good progress that way. 300 pages of this and not 60 pages of the other. 360 pages done. But this is what is taking up my time. Otherwise, it will be said that I have not showed the judgments. They mean something else.
Who is it? कल भी fix है. कल अच्छे, कल नहीं है.
2 hours I'll finish definitely.
Suffering for the printed sense because नाम लिखा है. Leonard Mr. Bachawat, Leonard Senior Advocate, argued the matter at length, but due to paucity of time, argument could not be completed. Give the date. Give 2 dates. Then you will take up further.
I'm told, my lord, Mr. Mitro is going to argue also. My lord, let my lord all who are my lord in one cart.
They
My lord,
complete.
yes. So that they give
But
us
I'll
more
tell you,
points.
lordship, why I asked for 2 hours. Maybe it wouldn't have required.
No,
But I also have a.
I'm not on.
No, I have a order 7 rule 11.
Mr. Mitra is also there.
We are a defendant in the suit, but I'm led by Mr. Mitra.
He will also argue the matter.
You will also argue.
Supporting the plaintiffs. I mean, unless he says he's not, my lord, then my lord, I'll start.
No, I'm
7 rule
assuming
11.
Mr. Mukherjee will also support me after I finish my arguments.
It is better than first you decide whether support or not, then you come. कब होगा? 29:30. Then यार complete करो इसको. Matter होता नहीं है. Official matter रुक. 26, 29, 30. 2 p.m. 3 p.m. 29, 26, 29 and 30.
Could we get an earlier date? Because by then, Lord, your lordship would have forgotten.
That
So
will
it,
I wanted to.
again, I'll have to
At
submit.
one stage it can
Lord,
go.
Lord, if your lordship can.
Already the matter is fixed.
Your lordship can give me a shorter stretch on 2 days. I don't mind. Lord, I can do it in 1 day in 2 hours or 2 days in 1 hour. Whenever your lordship can fit it in, Lord.
4 पे ना? The non-commercial. Okay, fix कर दो. 10 खाली. 12 noon. 10, 11 and 17. 10, 11th and 17th at 12 noon.
But, 10th, 11th, 17th and 12th.
Yeah.
My lord, 17, my lord, there might be, my lord,
Holiday.
holiday.
17th and 18th. Instead of 17, it literally on 18. 8. 10, 11.
Lord, at 12 noon, my lord.
12 noon.
Obliged.
But is it possible to also, because lordship, times get filled up fast, fix some more dates for thereafter?
Thereafter, let it be complete first.
So should we come back at 2 o'clock? 1 o'clock matter fixed.
1 o'clock. Which matter?
So that's Shebayat matter, if your lordship recollects.
Yes.
That lease.
Who is there?
We are all there, madam.
What is it?
Only the order needs to be passed. Your lordship had directed that the letter resolution be passed by the Shebayats. So the Shebayats have served us with a supplementary affidavit appended to the supplementary affidavit.
Pursuant to your lordship's order, my lord, I am filing this affidavit. By filing my affidavit, my lord, containing the original resolution adopted in the meeting of all the Shebayats, 2 to 10.
Page 10, my lord, page 10.
Page 10. My lord, they have agreed to the proposal given by the respondent number 1, the lessee.
Yes.
And the original resolution is annexed to this affidavit, my lord. I have served the copies.
So what will happen to the earlier agreement?
It is modified until it expires, but that can be modified or altered.
Only a supplementary modification deed will be executed, my lord.
Correct.
Incorporating this particular term.
Basically, a supplemental deed incorporating the changes, that also has to be registered.
That will be executed and registered also.
And in fact, he is recorded in your lordship previous order. Everything is recorded.
Kindly grants leave to the official trustee and the parties also to execute the deed.
No, in that case, so many clauses has to be amended.
Yes,
Yes,
clause will
yes,
be amended.
yes.
Added. For that, a supplementary deed will be amended.
My lord, your
Yes,
lordship
yes.
needs to direct me to ascertain, my lord, which bank is giving the highest interest on the fixed deposit of 1 crore. My lord, I have ascertained, my lord, HDFC Bank for fixed deposit for 10 years, it gives 7%. And Bandhan Bank, my lord, for 10 years fixed deposit gives 5.85%.
HDFC is good.
And that is your lordship.
That was my personal knowledge so far as HDFC.
HDFC is good.
Yes, presently they're giving the best rate.
5 years,
Fixed
1 day.
deposit should be a
5 years.
long-term fixed deposit, my lord, with auto renewal facility.
7%.
7%.
The present market 7% is very good.
My lord, if it is, my lord, my respectful submission that, my lord, that let it be under the monthly interest scheme. Because the monthly interest scheme, the fixed deposit may be opened by the official trustee, my lord, under the monthly interest scheme, so that the interest accrued month by month may be reimbursed to the Shebayas.
So they get benefit of the interest and they can use it for the benefit of the DT. Shiva Puja. And
That is the submission, my lord, on behalf of the Shebayas.
And how this agreement be executed now? Amended. It is to be registered.
Yes. My lord, has to be.
Because
Because this is
the existing lease agreement sought to be modified
Correct.
as per the terms
Correct.
parties have agreed.
Correct.
My lord, it can be modified by a supplementary lease deed or modified lease deed, and to be registered, to be executed by both the parties.
So you do one thing. You have taken the resolution. In terms of the resolution, sit together, go with the administrator and prepare the draft date, come with that, and totally the order can be passed. This draft, this
or subject to what falls from your lordship. If the order is passed, based on your lordship's order, the supplementary deed can be incorporated and
that also can
registered.
be done.
Your lordship will incorporate that a supplemental deed or a modification deed will be executed to the existing lease deed, incorporating these terms and conditions, and the same should also be registered in accordance with law.
Within 2 weeks or as your lordship directs on.
And the report will be filed by the.
The parties
That's
who
also
signed that original lease deed and the existing lease deed, my lord, they should also execute this new lease deed by modification.
Subject to their availability, of course.
Subject to the
That's whether they are available.
Subject to their availability, because
they are
Shebai,
available.
the official trustees, they are new.
Yeah, whoever is available will sign.
Lordship. The Shebais, well, they should take a resolution and somebody should represent the Shebais and can sign. And
They've
so the
already
official
taken a
trustee, the person in chair, will sign.
Okay.
If your lordship direct the concerned registration office, my lord, or registrar, as to sign, to register it as per
Why?
your lordship's order, that can be.
Not required.
Not required. Only this court can direct the parties to make
absolutely.
in terms of the settlement.
Lordship.
They will get registration fees, a revenue for the government.
Whatever the amount, this will be deposited. It will be month by month interest. You will take.
Minor.
And this resolution, the condition may be incorporated in the.
Minor.
That's
Naturally. Yeah.
133.
Very well.
What can be done?
Very well. Your lordship will pass the order and then we
Yes,
will
kindly direct
follow the
so we
directions given in your lordship's order. It's as simple as
In
that.
terms of my lord's order, we can execute the lease.
Very well. Very well.
I will
Great.
pass the order.
Great. হ্যাঁ তাই তো বলছি লর্ডশিপই তো বলছি correct
petitioner
he will pass the
consensus suffering for the respondents and Mr. Boss, you are appearing for the.
My lord, I am appearing for the lessee, the existing lessee to whom lease has been granted by the Shebaites.
Not the party.
Yes.
Of course, my lord, I am the party.
Respond number?
One.
1 minute.
Consistency appearing for the respond number. Okay. Good. In compliance of the order passed by this court, comma, the Chibayats have filed the resolution, original resolution, by way of supplementary affidavit. Let the same be cut with the record. Hearing concluded. I will pass on. I'll pass on.
Very well. My lord, the only thing is that there's a clause which says that from the date of passing of the order, the enhanced rent will be paid.
That's
Very
good.
particular suit and move an injunction application. This is a defamation suit in respect of a university. My lord, presently in the university, the admission process is going on. The particular defendant is an ex-employee. She has tendered her resignation and thereafter making allegations on the internet through Google review, Facebook, LinkedIn, everywhere. And now she's making YouTube videos and circulating. My lord, this is the reason for my urgency. May I seek leave to file the plaint and the
All persons are not mentioning it during the morning hours.
My lord, I tried to have the documents ready, my lord. It has
come tomorrow.
My lord, the request is, my lord, if the matter can be filed today, I can move it tomorrow around 2
There
o'clock.
is no chance. Tomorrow is the commercial day.
My lord, because the reason is my tomorrow 2 p.m. fixed matter is not going to be taken up.
No,
I was praying if
you
my lord,
cannot choose which matter will be taken.
I was requesting, my lord, because
Sorry.
my lord, the reason being the admission process is going on.
Maybe
It is affecting us.
the administration is there. Why the court? Administration is there. Administration will take care of it.
No, my lord, I am on behalf of the university.
If a person is yes, university take appropriate
My lord,
action.
we have been reporting the actions, but my lord, she's continuously posting now. Her mother is posting.
Publication, defamation, injunction. It has become a fashion now.
My lord, the person and her mother, they are continuously posting on Google and YouTube.
Newspaper now in the Calcutta. Come with the file it. Come on Tuesday, Wednesday, or Thursday, whatever it is.
Yeah, have your lordships kind leave. I know your lordship does not allow mentioning 47 and 48 of your lordship's today's list. My lord, the interim we are waiting. Even my lord, today we will be waiting. My lord, in case it is not reached, in case my lord, then, my lord,
47
and 48. The 48, the interim order is expiring today. Tomorrow, my lord. So we'll be waiting today also. If in case it does not reach, can it be placed tomorrow?
No, if it is by the rising of the court, you mentioned it, I will take. If it is going tomorrow, it is going to be expired.
Tomorrow, my lord, it's going to expire.
If it is not reached. Yes, next.
Well, I had spoken to Mr. Drolia, Millard, he has accommodated. Millard. Well, the plaint was presented last Thursday.
Yes.
Well, this is a suit for injunction, Millard, and Millard, suit for partition. I'm so sorry. Millard kindly takes the cause title. Millard, the petitioner is the Millard, the elder brother. Millard, the respondent number 1 is the Millard younger brother. Then Millard, there are 2 sisters. Now, Millard, the corpus of Millard, this family is Millard boils down from Millard Nam Narayan Gupta, the father. Millard, the father Millard in 1960. Millard, I pleaded everything. By a court auction by this honorable court had purchased the property Millard within the jurisdiction of this honorable court. Millard, that is the residential property. All the Millard family, Millard the Gupta family used to reside there. Now, Millard, since Millard after the death of the father and recently Millard the death of the mother in 2019, Millard the dispute and differences had cropped up. Millard, I had been Millard out of Millard of the property. Now, Millard, the urgency before your lordship is that Millard there is a Millard chance of Millard dissipating the Millard property which Millard belongs to the family. And Millard, this is admitted case because why I can show Millard the KMC records. If Millard kindly takes Millard, it stands Millard after the demise of the father. It stands in the name of the mother who had also expired. Kindly takes Millard page 20. 20 of Millard GA1.
20?
20.
Yes.
Kindly see the KMC records. Gyan Devi Gupta is the recorded owner. Now, Millard, I have been giving letters to Millard, my brothers and sisters, especially to Millard, the defendant number 1, because the sisters are already married. Millard, kindly takes Millard page 18. For getting the property mutated, Millard, in the name of all the Millard.
How many legal years?
Millard, all are parties, Millard. 2 sons, 2 daughters.
Correct.
Now, Millard, I have given letter, Millard, 22nd of March 2024. Millard, requesting Millard the parties, especially Millard to the respondent number 1 who has been objecting to. Man, and Millard residing in the Millard property is only sole respondent. The others are married, Millard, married daughters. Millard, kindly takes Millard page 19. It is approximate. It will take I have made necessary inquiries and be given to understand that the following steps need to be taken. Outstanding tax to be paid, legal heirs, declaration should be made in form of an affidavit to be affirmed before the first class magistrate, death certificate of mother need to be furnished, photocopies of Aadhaar card, such and such. It will take approximately 1 month to get the mutation done after furnishing the above particulars and documents. I await your confirmation and cooperation to proceed with the matter. You are requested to comply with the requisition within 15 days from the date of the receipt of this, such and the estimate cost is such and such. Now, thereafter, I pleaded in paragraph 30 page 8. Milad paragraph, there is no reply to this letter. Totally stoic silence. Milad kindly
When you
takes
submitted the report and this letter,
Milad 22nd of March 2024.
to whom? All
Milad to all the parties.
three.
All three.
Whether they have received.
They have Milad. They have, because thereafter Milad.
Where is the receipt?
Receipt আছে?
Receipt of this letter, 22nd March. Where is the receipt of this letter to the other parties?
Milad, that is,
Then,
even if Milad, even if that,
yes.
even if Milad kindly takes page 8. Milad, I have pleaded Milad, only Milad, this property is the Milad household property of the parties and Milad corpus of the family, no dispute. Number 2, Milad, there is a Milad farm which was run in the name of my grandfather, A.K. Gupta and Company. Milad, that Milad farm is also Milad being run, the business is being run by the respondent number 1. Milad, I have no difficulty. Let him run. Milad, only thing I am Milad suspecting that let him Milad, there is a leasehold property. If he surrenders the property, Milad, the family business will go. It's Milad deals with wrought iron and Milad the Milad iron rods. TMT rods. Milad, it's all Milad are within jurisdiction. And Milad, I pleaded at page 8, paragraph 33, 34, and 35, Milad the urgency. And also Milad paragraph 38, with regard to Milad the business.
So who is in possession of the property?
Respondent number 1.
In all property?
All property. All property.
How many? 3 properties?
Milad 2 properties. Milad, one is business and another is the residential property.
Where is
Milad,
the details?
Yes, details my will find Milad the immovable property. I have given the schedule at page 15. This is the immovable property. Residential property purchased by the father from court auction, that Milad I pleaded at page 3, paragraph 8 in the year 19 February 1960. Now, Milad, with regard to the business, I have pleaded at Milad page 2, paragraph 5 and page 3, paragraph 6. And also at page 4, paragraph 16. Business is a Milad leasehold property.
No, this paragraph 5.
Paragraph 5, 6, and 16.
No, paragraph 5 is you have taken the on lease.
Yes, on lease. That lease is the business. Then Milad paragraph 6, my will find.
Yes.
Then Milad kindly comes to Milad paragraph 16. And my will find the backstory of the business Milad from paragraph 12. It's an old business, family business. 1968, the lease is continuing. These are the only 2 assets, the business and Milad the household property. Ramnarayan Gupta is Milad my grandfather. It was started by him. My father, Ashok Gupta, Mr. A.K. Gupta is my grandfather. I'm so sorry. In whose name Milad the farm is named. It was initially 77 Koilasbo Street. After Milad apportionment, Milad, that also I pleaded. Paragraph 16. Milad 2 pages at the top of paragraph.
Now who is looking after the business?
Respondent number 1. I am only Milad, let him look after, let him enjoy. Milad, status quo to be maintained in the meantime. Milad, I know Milad in a partition suit, Milad parties are interchangeable. Milad, only Milad to assist your lordship, Milad. This has also been Milad observed by our Honorable High Court, Milad, by a division bench. It's a very short, I had the occasion to appear. It was also from an ex parte interim order which was refused by the Alipur court. I had preferred appeal. Now, my lord will kindly see first paragraph is for direction for service. Kindly see the last paragraph, considering. Considering the prima facie case balance of convenience, the fact that the respondents have not lodged any caveat and that an order of status quo of the property or properties which are subject matter of the partition and administration suit is usual, with that they direct the parties to maintain status quo regarding the ownership and possession of the subject property till such and such. So, in a partition suit, status quo usual because it's benefit for all. Kindly Milad grant Milad prayer in terms of prayer A and B, Milad.
The plaintiff has filed a suit for partition of the suit property left behind by his father. plaintiff and the defendants are brothers and sisters. Full stop. Full stop. During the lifetime, the father of the plaintiff has started the business under the name of his style of carried on his business. No? What is the
K. Gupta and Co.
K. Gupta and
Yes.
Company? It was a grandfather?
No, by the
Father.
It was done by the grandfather. Business take. Acha, business was started by Millard by the father.
And that's why.
Well, we will find at paragraph 12. Millard, it is in the name of Ram Narayan Ashok Kumar. Subsequently, it was changed to Acha, two businesses, Ram Narayan Ashok Kumar in same property. Messrs. Ram Narayan Ashok Kumar and A.K. Gupta and Co. in the same property. Paragraph 12.
Style of A.K. Gupta and Co.
Co and Ram Narayan Ashok Kumar.
As well as Ram Narayan
And Ashok Kumar, my father and grandfather.
Narayan Ashok Kumar. With respect of
Ram Narayan and Ashok Kumar is myself and my father. Yes.
With respect of what is the business?
Miller wrought iron. Miller the iron rods.
Iron and steel rods.
Iron.
With respect of iron and production. Production?
No, selling.
For selling of
Selling,
iron and steel rods. Full stop. For selling of iron and steel rods. Full stop. During the lifetime, the father of the plaintiff has also purchased a property
from court auction, Millard, in February 1960.
Under court auction, sometimes in the year
February 1960.
1960, having 2 kothas of land at 26A, Mahendra Sarini Street, Srimani Street.
Srimani Street.
Mahendra Srimani Street, Kolkata. Full stop. Counsel for the plaintiff submits that the defendant number 1. Counsel for the plaintiff submits that during the lifetime, the plaintiff was assisting his father in the business, and subsequently the plaintiff has started his own business, and after the death of the father, the defendant number 1 is looking after the said business, and till date the business is being looked after by the defendant. What about the landed property?
Miller, landed property is the Miller page 15 Miller. That's the house.
Who is in occupation?
Miller, defendant number 1.
The landed property
was purchased in the name of my mother by the father, Miller.
The landed property was purchased by the father of the plaintiff in the name of the mother, but the property is in possession of the defendant. The landed property is also in occupation, is in possession of,
excepting one room which is under lock and key
of the defendant number 1, except one room
which is under lock and
key. Full stop. Also, the plaintiff submitted that the father of the plaintiff died in the year 2000 on 28th of March 2008, and the mother of the plaintiff
14th March 2019.
14th March 2019, leaving behind the plaintiff and the defendants as their legal heirs. The plaintiff submitted the during the after the death of the mother, the plaintiff has sent a request to the defendants calling upon
mutating
calling upon the defendant for mutation of the property left behind by their father in the joint name of all the legal heirs, but in spite of receipt of the notice, none of the defendant has come forward. Full stop. So, the plaintiff says that the plaintiff came to know that the defendant number 1, who is running the business, who is taking care of the business, is trying to alienate the property in the name of third party. And as such, he prayed for an ad interim order restraining the defendants, particularly the defendant number 1, for disposing of or encumbering the suit property. Full stop. But the learned counsel for the plaintiff peruse the application and the materials on record. Admittedly, the property was acquired by their father as well as the mother, and both have expired. After the death of mother and father, all the legal heirs, that is the plaintiff and the defendants, are entitled to get their respective share in the property. Full stop. It is also admitted that the business which the father of the plaintiff was carried out is now carried out by the defendant number one, and the other property is also in possession of the defendant number one, except the one property, except one room which is under lock and key. Police sir. It is the apprehension of the defendant, of the plaintiff, that the defendant number one will alienate. Where is the averment?
Miller, page Miller, paragraph 31, Miller, that I showed to your lordship. 33, page 8, 33, 34, 35, 36, and the property is worth more than 4 crores.
Give the last line. Will alienate the property which has been alienate the property in which the plaintiff is also having the share. Considering the submission made by the counsel for the plaintiff, this court find that considering the submission made by the counsel for the plaintiff and perusing the document, this court find that the plaintiff has made out a prima facie case and balance a convenience inconvenience in favor of the plaintiff. As the property in question, as the plaintiff has filed the suit for partition of the property, and the property belongs to is the ancestor property, which is required to be partitioned amongst all the legal heirs of the deceased, namely, what is the name of the father?
Miller Ramnarayan Gupta.
Ramnarayan Gupta.
Late Miller Ramnarayan Gupta.
Ramnarayan Gupta, and the deceased
mother is Gyan Devi.
Gyan Devi, and as such, the defendants from a particular the defendant number one is restrained from alienating
prayers A and B, Miller, if Miller sees once. Composite prayer, Miller, I prayed.
or dealing with the said property to any third party till.
And also, Miller, not to Miller the business, Miller, prayer B. Kindly see prayer A and B for the time being.
Property with respect of prayer A and B of the injunction application till 8th of August 2024.
Miller, only one prayer, Miller.
No receiver at this.
No. Yes, kindly reserve that right that I have not praised Miller, so that Miller I can pray for. Kindly recollect that.
The plaintiff is directed to serve the copy of the application, serve the copy of the print application in the documents to the defendants, and to file affidavit service on the returnable date. It is made clear that only for the urgent relief this court has taken into consideration of prayer A and B. And
yes, Miller, I am carrying that order.
Prayer A and B, and this court has not and the plaintiff has at present has not argued with regard to the other prayer.
Miller is keeping it on, Miller.
8.
Obliged.
Next.
I was Miller carrying that order.
Sometimes this happens.
No, the law is such, Miller, there. Section 11 is such, Miller, they can always say.
Yes.
And Miller, I also referred to a Supreme Court judgment. Miller has dealt with that judgment in that, so I'm carrying that. Obliged, Miller, greatly obliged.
No, I appear for the defendant number 2 and 3.
Yes.
My witness is here.
আমাদের 8 August. Your name, sir?
My name is Arpit Reta.
My lord, 8 is perhaps Monday. So my lord kindly keeps it on a Wednesday.
8 August.
8th August, Monday.
Nah, Thursday,
August.
Thursday.
Oh, so
Thursday.
sorry.
Yes.
Good. Mr. Kudeta, I am showing you a letter dated 11th October 2011 from defendant number 3 to the plaintiff number 1. Kindly tell my lord what is this letter about?
Gives me a little.
My lord, this letter is about uh, the instructions that the defendant number 3 and defendant number 2 had given earlier to start the work at other wells simultaneously. Even after passing of nearly 1 month, no work had been started at other wells. And still till date 11th October 2011, no detailed modified program of work was submitted by the plaintiff, and the laboratory at near field site was still not set up.
Who has signed this letter?
My lord, this letter has been signed by Deputy Chief Engineer, defendant number 3, who at that time was one Mr. M.V. Satyanarayana. M.V.
Can you identify his signature?
Since I have not worked with him personally, I have not seen him his signature personally, but we'll have to check of that.
Can somebody in railway who was working at the time of this officer can identify this signature?
I think so, yes.
Let this be marked for identification.
What was the last exhibit? X7. X7 for identification.
Mr. Kuteta, I am showing you another letter dated 21st October 2011 of the defendant number 3 to the plaintiff number 1. Kindly tell my lord what is this letter about? A page. This is a page. 426.
My lord, this letter is in continuation of previous letters, where it has been highlighted that work at other wells have not been started even till 21st of October 2011.
Mr. Dhulia, how many documents are there? Like this only, he cannot identify the signature.
My lord, maybe 6, 7 documents, my lord.
Only 6, 7.
My lord.
Yes, yes.
Yes.
Further, again, it has been highlighted that modified detailed work program has not been submitted for the work to be done.
Mr. Koteta, can you identify the signature of the author of this letter?
This has been signed by the same deputy chief engineer. I cannot at this point identify his signature.
Can you get identified by some officer?
How it is?
How can you get identified?
How he can say?
My lord.
It is your duty.
My lord.
Or the defendants may take appropriate
Well,
steps. How he can say?
Very well. My lord. Let it be marked for identification, lord.
X8 for identification.
Document. Mr. Koteta, I am showing you letter dated 30th of November 2011. Kindly tell my lord what is this letter about. And this is mentioned in DD 19 at page 428.
My lord, this letter from the defendant number 3 to plaintiff number 1 highlights that while the work program now has been submitted on 24th of October 2011, the work progressing at site was running way behind the submitted work program. Was running way behind the submitted work program. And it is highlighting the unsatisfactory progress, and it also mentions about non-arrangement of cement, which is a critical item, basic item for construction of a well foundation, as the requirement order has not been placed in advance by the plaintiffs. So it has been asked by the defendant number 3 to increase, to put up adequate resources for the work so that work progress can be expedited and could be brought as per the submitted work program by plaintiffs.
Yes, next.
Yes. Who has signed this letter?
This has been signed by the then Deputy Chief Engineer Construction.
Do you know his signature?
No.
Let it mark for identification.
X9.
X9.
Mr. Koteta, I am showing you letter dated 20th December 2011 being the document in DD 22. Kindly tell my lord what is this letter about?
My lord, this letter has been addressed to defendant number 3 from the plaintiff. In response to defendant number 3's letter of 30th November 2011, here they have mentioned that their progress has been slower than as per their planned program, and they are assuring defendant number 3 that they will deploy and augment their resources to expedite progress of work. My lord, nowhere in this letter are they raising any concern about any lacuna in the subsoil exploration report provided by railways.
Who has signed this letter?
Mr. Drolia, this is not exhibiting, it is expert identification.
Milord.
Anyhow, I don't know what you will take this step further.
Milord.
What purpose would be served for taking all this evidence if the document is how they, because he is not the person at the time of execution of the work.
Milord.
Whatever the evidence is on the basis of the document, and the document is not getting exhibited. So what?
Milord, here, Milord, the officer, this officer has retired or may transfer. So it will be located whether he is still in somewhere working, he will be requested to come here, or Milord, any officer who was working during his time, he will be brought here to identify his signature.
That's why. So why you getting the time wasted from this witness?
Milord, this is for identification so that one step is complete. Then another step.
If you wanted to exhibit the document through the person concerned or any of the officer who work together who can identify, he can give the same evidence. Otherwise, his evidence will nothing. Waste of paper. Because he is whatever his
the additional Milord witness apart from Mr. Koteta, some other additional witness who has seen the signature of this author, Milord, he will identify that yes, the signature has been seen during my time. I have seen his signature. I say it is his signature. So that, Milord, I am arranging, Milord, for and in some documents, Milord, wherein the deputy chief engineer later on, that deputy chief engineer, under him he has worked. So he will identify his signature.
You take that which
Yes.
he can identify, which can be done.
Yes.
Subject to.
Yes.
But with regard to this,
Milord, now few documents
okay,
are
okay,
remain,
continue. That's
My lord, this has been signed by authorized signatory of Rahi GPT JV.
Which letter?
Letter dated 25.
This is which document? Yes, 20th December. So this is the plaintiff's document. Is it the plaintiff's document?
Yes.
It's a leading question. Last one is a leading question. Every question there is a leading question. He is getting understand. He is an IITian.
No, Milord.
Every question there is a leading question.
No, Milord.
It's becoming difficult.
Now, what answer he has given last?
Has been signed by authorized signatory of right.
Yes. Next.
Milord. Milord, this is the common document, Milord. PD 11 and DD 22.
It may exhibit. It is your document.
Yes, let it be exhibited, Milord.
What is exhibit 4, 5? The original one. Xerox. The admitted details your document. What can be done?
Mr. Koteta, I am showing you letter dated 10th March 2012, being DD 24 at page 436. Kindly tell my lord, what is this letter about?
My lord, this is a letter from defendant number 3 to plaintiff number 1. And in this letter, it has been specifically highlighted about the slow progress of the work being executed by the plaintiff. It also mentions reasons like unavailability of cement and reinforcement. Unavailability of cement and reinforcement.
Reinforcement.
Which was causing delays in work. It has been time and again provided, as mentioned in the references of this letter also, that the plaintiff needed to deploy additional resources and expedite work progress.
Who has signed this letter?
It has been signed by the then Deputy Chief Engineer, Construction.
Well, let it be marked for identification.
X9.
10.
It's 10.
Mr. Koteta, I am showing you letter dated 1/5/12 from the plaintiff number 1 to the defendant number 3. Kindly tell my lord what is this letter. This is the DD21. DD21.
My lord, this is a letter dated of 4th of May 2012, in which the plaintiff have requested to permit use of explosives for purpose of sinking the well in hard strata. This has been asked first time during the course of this agreement.
Mr. Koteta, by this letter, the plaintiff number 1 has sought permission for use of explosive.
Yes.
To carry out the project. Why not the plaintiff number 1 sought permission earlier?
How we can give the answer?
My lord, while I cannot say why.
Yeah, how he can give the answer? Why? You could have been asked from the plaintiff. How this witness can say? He was not at the site, and he's
Milord.
He's not the representative of the plaintiff.
No, I will.
My lord, while I cannot say why they had
mention
not
the
asked, but in my opinion, this permission should have been sought much earlier, because
Opinion will not
witness
go.
cannot give his opinion.
Opinion will
He
not
can keep
go.
his opinion with himself.
Opinion will not go.
I change the question. Did the plaintiff number 1 sought permission earlier?
That
No.
you can put the question.
No.
Okay. Lord, I let it be marked exhibit.
Exhibit 5.
Exhibit 5.
Mr. Koteta, I am showing you the letter dated 5/5/12 from.
One thing, Milad, though it's my letter, but this is not the original. They should have the original.
But you have admitted that.
Yeah, but this is not the original.
What can?
I have admitted it.
That secondary admission.
Government Milord, railway is this side. Milord, I am showing, Mr. Koteta, I am showing the letter dated 5th May 2012 from the Deputy Chief Engineer to the plaintiff number 1. Kindly tell my lord what is this letter.
My lord, this is in response to the plaintiff's application for permission to use explosive, wherein it has been permitted by the defendant number 3 to use necessary controlled blasting for sinking of wells as per relevant guidelines and IS codes. IS codes.
Mr. Kotita, who has signed this letter?
My lord, this has been signed by the then Deputy Chief Engineer, Construction.
Well, let it be marked for identification.
X 10 11.
Mr. Kotita, I am showing you a document being in DD 20 from the plaintiff number 1 to the defendant number 3. Kindly tell my lord what is this document?
My lord, this is an application for extension of completion period of the instant contact agreement, as at this point it was evident that work would not be completed in the original completion period. In this period. In this letter, they have mentioned various reasons for the delay, but nowhere have they mentioned that there was any lacuna in subsoil exploration report provided by railways. Further, they have asked for extension of completion period with assurance that they'll expedite the work and complete the work as per revised work program, which they have attached with this letter.
Let this be document marked exhibit, my lord. Mr. Kotita, I am showing you letter dated 27/5/13.
One thing, the questions are not being put before getting the matter, it's exhibited. So
Since yesterday I'm telling what can
the
be.
questions are not being put, Milad, which Milad I am getting, Milad, bound to stand up, Milad, time and again. That questions has to go. Relevant questions has to go. How have you received it? How have you got it?
Very well.
Then you yesterday also I told you. First you put the question, then let the witness say, then you put the document, then you identify the document, then it will go on evidence. That is the procedure.
Mr. Kotita, I am showing you letter dated 27/5/13. Why was this letter issued by the defendant number 3 to plaintiff number 1?
My lord, this letter.
The last, Milad, he has not put the question with regard to the last letter.
Yes, the extension of time is given answer. This is a letter you submitted to the authority for extension of time for complete the work.
The questions, Milad, which Milad getting it exhibited are not being asked.
No, you not ask?
No, he has not asked.
What is the last question?
I may be wrong, but
Yes.
Yes, answer is there.
No, no, no.
The question is, what is this?
No, 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 no. These are not the questions
Milord.
for getting it
For
executed.
getting the exhibit, there are something other provisions. He stated that he, they, who, but you have to explain this thing.
Milord.
Ronia sitting this chair, I cannot explain all.
No, Milord, very well, Milord. Milord, here this is the letter from the plaintiff number 1.
What is that?
Maybe.
Where is that?
What are the questions?
Where is the
What are the
question?
answers?
Where is the question?
Okay.
This can't go in like this.
So I can make a additional question, Milord, but
No, 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 no. There are some
You have
questions.
not conducted any evidence earlier, sir.
Milord, I should matter. I really.
So you could engage some other. It is not the way. Though I am leniency I am taking. Otherwise, it is not the procedure.
Milord, here, Milord, my documents
what
are
is-
exhibited.
No, your document has been, that is different thing. If you wanted to put any document to, first you have to say what is the document, what is the date of document.
Yes. Yes. Yes.
So you're not
Milord,
putting.
yes, I got it. Got it, Milord.
There are many other questions
There are
prior
so
to
many
getting it
questions are
exhibited.
there. It is the evidence, and that to a civil case, civil suit,
Commercial suit.
or that to commercial suit.
That time it was civil suit. Now it has
Now
become
it's
commercial.
Commercial suit.
Milord.
It is very strict
Yes.
to prove the document.
Yes. Milord, I can again ask the question on that document, but it already, Milord, that.
No, 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 no.
That will not go
Not
because
go.
see, to prove the document.
Milord, very well. I will ask. Go back to that document, Milord. I will ask.
Question.
Yes. That is the.
You take the help of any of the experienced person who are conducting these trials in the civil cases.
আমাকে একটা দিন তো এটা যে ডকুমেন্ট ছিল প্লেন্টিভস ডকুমেন্ট What? 29. Yes. Yes. Mr. Koteta, kindly look at this document and tell my lord who has issued this letter.
My lord, this letter has been issued by plaintiff number 1.
What is the date of this letter?
The date of this letter is 1st of October 2012.
Who has signed on behalf of the plaintiff number 1?
How can you say that? My client, how can you say that?
If all these documents with you,
Milord,
who has cross-examined the witness? Of the plaintiff's witness? You are cross-examined.
Milord.
So why you have not brought all the document during the cross-examination of the plaintiff witness or the plaintiff document? How the defendant can prove, how will prove the document of the plaintiff?
Milord, moreover, I say, Milord, I was not allowed there at all. That the process which was conducted,
appeared before the lodging court number 40.
It was very adamant. And
no, before me, I don't think I.
Two witnesses. No, this is going some other way now. Mr. Mukherjee and Mr. Singh, 2 and 3 appeared before the lodging court number 41. Well, he could have put very well before them also. They are the part of plaintiff's organization.
For the documents, it is depends upon parties. It might be they are not disclosed. Their document they are not disclosed, and the document benefit to you. You have to why what for the cross examination? What for the cross examination? And exam how he can prove their document? Though this court is taking because they have admitted the document in the PD. But how you can prove the document of the plaintiff during the cross examination, examination chief of the defendant?
No, that time the documents were not even compiled. When this before the advocate commissioner was going on, that time the railway documents were not compiled at all. So that whatever the evidence was given.
So without when the examination of the plaintiff started, you are not ready for the document. So how the examination was conducted?
On the basis of the evidence which were already recorded, on the basis of that cross examination.
They have served us their compilation on us on 14th of December 2021. They're saying that is not compiled. This is, well, I can show the letter here.
That is the way, but because I don't want to open the mouth.
Milord, here, Milord, let me, Milord, in my way, Milord.
No, it can go like that.
Certain documents are there, and the documents which are for identification, other document, Milord officer as a witness will come and prove those documents, Milord. And Milord, here, Milord, the old matter, and it's all Bilaspur at Bilaspur. And there is a Raigad, Bilaspur, and 2-3 changes made. And now the jurisdiction here. So the officers, they are staying here for 4 or 5 days here. They came several times. Several applications made here. At least 5-6 GA made. And those GA...
I have a good experience from the government side also.
Milord.
I know.
Milord.
Whenever the advocate will call the records, either they will not bring the records, they will say the officer was maintaining, he transferred. Or they will bring the record like this bundle
and
advocate
put it
and take all this.
Yes.
I had a good experience that side also, this side also.
So this problem is with me, Milord.
But the person, if you have taken the responsibility of the state, then you have to take the responsibility. It is not that.
My level best, I am trying to.
But this is not the way.
Milord.
It will be getting damaged. You are damaging.
Here, Milord, this is the plaintiff's document. And plaintiff's document, I have asked that what is document about. The contents have been said by the witness.
Maybe, but how you can... my question is that, see, merely putting the document on record, exhibiting it does not mean it is proved. It is proved. Have you gone through the Evidence Act? It has to be proved by each and every contents of the document. Then only you can argue the matter. Mere exhibiting the document, it cannot be said the document is proved. Either in the criminal or in the civil. It is the document has to be proved. And how it is to be proved, you have to go to the Evidence Act.
Very well, Milord. I am asking some additional question on this, Milord. Mr. Khoteta, kindly tell my lord how this letter was sent to the plaintiff number 1.
How you can say? He was not there.
There.
The main problem of your witness is very intelligent, but the problem is that he was not at
that relevant time. He was not at the relevant time.
Your administration has sent this person go and give the evidence. So what he will give the evidence? He's giving the evidence. How his evidence is will be proved, or how you can get the benefit of this witness evidence? There is no doubt about your witness credibility, but problem is that
he is IIT Mumbai, Milord.
Correct. But he is not the person who was present at the time of execution of the work. So how he can say only by putting the document? Neither. That's why initially I told how this is a waste of time. You send any person sit with the department, say how the document can be proved.
Lord, there are few documents now, my lord. More of the documents already, my lord, for identification and for exhibit. And this letter, my lord, this is the plaintiff's document, and this is the plaintiff's document, and they're seeking the use of explosive, and that has been, my lord, already, my lord, the witness has said, and regarding the date has been, my lord, stated here, that the person, the signed by the authorized signatory of the plaintiff number 1, and my lord, if anything is required, my lord, so that, my lord, it can be marked exhibit, my lord.
Yes, what is the submission? Where is Mr. Dasgupta?
How that can be, my lord?
So you do one thing,
My lord.
come on the next day,
My lord.
come ready, prepared,
My lord.
sit with the your officers, come on the next day, 3 p.m. 3 p.m. matrix ache ki? 3 p.m. is there.
My lord.
Sit. Your witness understand what I wanted to explain to you.
My lord.
Sit and see how you can do it.
As your lordship.
Adjourn. No, matlab, he will sit. उसको दे दीजिए, next time he will bring that.
দুটো দিয়েছি না, একটা ওইটা আর পরে একটা দিয়েছি, দুটো দিয়ে
delete করে Census and suffering for the plaintiff, census and suffering for the defendant. Full list of defendant witnesses present. Examination chief resumed, but due to paucity of time, chief could not be completed. During his examination, how many documents exhibited today? 2 documents being exhibit 4 and 5 have been marked, and some document being X7 to X11 is marked as for X for identification. Full stop. Examination chief is deferred. It is not fixed tomorrow, na? List the matter on. How much time you will take, sir? Then he will cross-examine. One day it will be over. 1 hour it will be over. How many documents? Yes, from your side.
My lord. Yes, my lord. That I will take 1 hour, my lord.
1 hour.
1 hour. But it can be fixed, my lord, after some.
Give the time, date. See, date. Report that nahi hai. 3 p.m. there. 26 July at 3 p.m. 26 is Friday.
26 July.
My
At 3
lord,
p.m.
my lord, two dates, if your lordship kindly gives. And 1st of August.
Then you come to August, then I will give 2 dates.
My lord, in August, let it be in August, my lord. My lord, my lord, witness, my lord, that is
August will be available. 1st and 2nd August, 2 p.m.
I'm grateful.
Yes, next.
Fix at 3 p.m. Item number 39 of non-commercial.
This is my application, my lord.
Yeah, my lord, I appear, my lord, for the plaintiff.
This is for the restitution, my
I
lord.
believe my learned friend had concluded his submissions in respect of the restitution.
Item number?
39 fixed at 3 p.m.
Lord, after enjoying an order of injunction for 7-8 years, my lord, the suit was withdrawn. That matter.
Clear.
So we have made our submissions. Mr. Mitra was supposed to.
144.
Yes, my lord.
My lord, I'm told, my lord, Mr. Mitra is on legs in court 16, but I can start, my lord, because it's fixed at 3 p.m. And once he comes, my lord, your lordship kindly permit him to take over.
Will he come?
Sure. My instructions are he will come. But yes.
Or otherwise, I will have to adjourn.
Yes, because I believe he'll be only making the substantial submission.
That's why.
Yes. Let me just call up and find out. In the meantime, my lord, till the time I'm 100% sure whether he's coming, may I just, we have prepared a list of dates. May I just place the list of dates before your lordship, my lord? Firstly, my lord, Firstly, sincere apologies on our part. If your lordship sees the list of dates, there has been a typographical mistake. Like whenever it happens, copy pasting from one thing to the other. So that had to be like struck off by hand. So my lord will kindly.
Yes, no problem.
Well, the suit was instituted by the plaintiff in respect of an MOU of 30th October 2013.
Yeah.
This was an MOU in respect of transfer of shares. Now, there was an earlier MOU between of 17th March 2013 in respect of between Ram Gopal Maheshwari and his two sons, Maruti Maheshwari and Anuj Maheshwari, and MBLA Capital Limited, that the plaintiff herein, along with Mr. Anjani Kumar Lakhotia, who at that point of time was the director of MBLA Capital. Now, the disputes which form the subject matter of the May 2013 MOU, that is a subject matter of a pending Section 9 and a Section 11 application, which is before a coordinate bench of this honorable court. Now, 30th October 2013 is the MOU in respect of which the plaintiff, that is MBLA Capital Limited, had sought for specific performance of. That is the second entry in the list of dates. That MOU was between the plaintiff and the defendant for transfer of 17 lakh shares as held by the defendant in MBL Infrastructure Limited in favor of the price of rupees 63.75 per share within 18 months from the date of execution. So therefore, the total sale consideration, it was a price mentioned in the agreement, was rupees 10 crores 83 lakhs 76,000. One of the terms of the MOU, just list of the second entry. Terms of the MOU is to get the personal guarantees of the directors of the defendant in respect of banks, that those are to be released. In fact, the defendant was under an obligation to sell the shares to the plaintiff only upon the release of the personal guarantees within the validity period of the MOU. Those are the terms. I have the clauses, relevant clauses in the list of dates. It has been mentioned, Mala. I'll show Mala those clauses once I take your lordship, Mala, through the facts in the form of list of dates. Next, Malad may kindly grant leave to Mr. Mitra.
Lordship, my submission is like this. I will show the list of dates is very important because much has happened. 2013 is the agreement. They by which they are to sell certain shares to us for 62 rupees per share, and we are to buy it within a certain time span. That time span is still 2000, and after extension, it expired in the year 2016, April 16. We filed the suit. We filed this suit sometime in 2015, in February 2015, for enforcement of the agreement. Enforcement of the agreement. In this suit, when we filed interlocutory applications for injunction, they came and contested that the suit is not maintainable. That the agreement is a void agreement because it is barred by Securities Contract Regulation Act, it is barred by Stamp Act, etc. Courts did not hold in their favor. The court granted injunction twice over, once on the original shares, thereafter on the bonus shares. And this suit was pending. The share price, this is a company which is closely held company. The share price of this company at that time was hovered well over 62 rupees, 100 rupees, 500 rupees, 400 rupees, and they will not sell it. So happens that in 2017, this company goes into corporate insolvency resolution process, fell into bad times, 2017. And thereafter, the share prices plummeted. 2017, they performed the agreement after the share prices plummeted. But they never came forward to claim any either specific performance or damages or nothing, no claim, not even a counterclaim. It goes on after the share price fell. And we also did not perform the agreement. They thereafter in 2022 or in 23, they filed an application which I will show, essentially for specific performance of the agreement.
New suit. Amendment.
After I withdrew the suit, after I expressed my intention not to comply, to withdraw because the share prices have come down, I do not want specific performance anymore, to withdraw the suit. In March 2023, they make an application in this suit being GA number 3 for specific performance of the agreement. I withdraw the suit in March 2023. Now, since I have withdrawn the suit, they have, by way of restitution, they really seek performance. Just a few background facts. We were to buy the shares, they were to sell the shares to us at 62 rupees. We had to pay the price. There was another obligation from our side to have their personal guarantees given to the bank for MBL, for MBL's loans released, because this company came under my control. I got all the personal guarantees released. That's worth several hundred crores because that was the liability of the company. I had them all released. I returned all their title deeds. That was within time. They did not perform it. Now the issue that will arise is whether you can seek restitution in the garb of restitution. Can you ask? This is an equitable doctrine for specific performance of an agreement, in which from 13 to 23, 10 years, you have in writing been not ready and willing to perform the agreement. You've been denying the agreement. Your claim is time-barred. Agreement expired in 16. By way of restitution, can you seek these reliefs just because the share prices have gone down? Correspondingly, how have I benefited? A restitution is an equitable doctrine. If I had got those shares when I came to court in 2015, or within the time specified in the agreement, let's take it 16, I would have got shares. At that time, I was running the company. The share prices were 3 times, 4 times. I would have got those 62 shares, 60 rupee shares, for which I filed the suit. They never came forward to say, yes, I'm willing, and made a double profit on it. Because after all, I've discharged my personal guarantee, his personal guarantees also. So there was a hidden cost in that, which is worth much more. I would have got a huge profit out of those shares. Is it in a court of equity? Can someone come and say thereafter, when the share prices have fallen, 7, 8 years thereafter, now the share prices have fallen, you will have to specifically enforce. There is no law which requires a plaintiff who files specific performance of an agreement to go on chasing that suit, come what may, circumstances change. I have to, since I filed a suit, I cannot withdraw just because it's a specific performance suit, number one. Number two, if a person who has not sought specific performance in specie or through cash, like since you're not buying it, this is the loss I have suffered, can he thereafter, just because there's the other side suit is pending, 10 years, 15 years later, come and say, you specifically enforce the agreement? This is the long and short of the case. This is a grossly inequitable approach of the defendant, which first I will show from the list of dates because it's very important, and I will show the documents also corresponding. Lordship kindly comes firstly to the first date, that is Lordship as Mr. Bhattacharya has shown, 30th October 2013. I want to show one agreement, the clause of the agreement regarding release of personal guarantee. Lordship kindly takes, because this is the Bible, this is the crux of the matter. Page 22 of the petition is the MOU, which is the subject matter of, which is the subject to me, which is the subject matter of the present suit. Kindly see page 22. Lordship kindly comes to the consideration 3.1. Seller agrees to sell and buyer agrees to purchase the sale shares at rupees at the prevailing market price as on the date of signing of this MOU, is 63 rupees. Lordship also sees, kindly comes to page, next clause also 3.2. The consideration for the deal is the price as per para 3.1 and release of personal guarantees of the directors of Prabhu for the fund-based and non-fund-based working capital facilities of MBL infrastructure, which the seller considers very essential for smooth running of its business. There's an admission from them. I will show 14 or so personal guarantees. We had them. Corresponding, what is their obligation? Apart from selling the shares, is clause 2.1. Seller hereby offers to sell, 2.1, and the buyer hereby agrees to purchase the sale shares, including the pledge shares after release from pledge. I will show from pleadings, even today, they have not released the shares from pledge, and they have categorically refused to have the shares released from pledge. 2.1, read with 2.2, buyer shall require and seller shall give to the buyer proof of satisfaction of the pledge of pledge shares. These are the clauses relevant for this particular MOU, and I also read with clause 6.2.1. The seller shall sell the sale shares, including the pledge shares, upon release from pledge.
6.2.1.
6.2.1, page 27, Mala. Page 27. Page 27, does it? 6.2.1. The seller shall sell the sale shares, including the pledge shares, upon release from pledge to the buyer only within the validity period of this MOU as provided in clause 4 above. Now, what is the validity period? Page 25, clause 4.1.
18 months.
18 months. Read this kindly with clause 6.1.1, page 26. It is reiterated. Buyer shall purchase the sale shares as and when offered by the seller within the validity period of the MOU. This was this. Now, this MOU normal course comes to an end in early 2015, but there has been extension. Lordship, coming back to my list of dates. Now, the next serial number 3 serial number 3, February 2015, in view of refusal on the part of the defendant to perform the said MOU within the time period as mentioned therein, the plaintiff was compelled to file. I'll note at the bottom, MBL share price as per BSE record as on this date was of 438 rupees. I've got the BSE quotation, 438 rupees. Page 2 of my list of dates, of my list of dates. Page 2 or 3. Serial number 3, page 3. Serial number 3, page 3 of my list of dates. February 15, when I filed the refusal of the party defendant.
MBL serial, yes, good. MBL price as per BSC record 438. Okay.
Now, Lordship, kindly see the next date, 23rd March 15, in plaintiff's GA. Upon hearing the respective parties, this honorable court had passed an order in terms of prayer B of such application. Prayer B said the injunction restraining them from dealing with the shares. Share price as on that in March 15 was 621 rupees per share. Then next 5, 2nd April 15, by way of an amendment to the MOU, the validity thereof was extended till 31st March 16. Share price in April 15 was 569 rupees. And 6th April 15, this Honorable Court extended the order dated 23rd March until further orders. Now, still a 7, 6th May 15, 6th May 15, this Honorable Court was pleased to dispose the interlocutory application by varying the order of status quo to the extent that the parties were to discharge their reciprocal obligation in terms of the MOU as well as the amended MOU. I have discharged, got all the guarantees released. Then 30th July 15, 1:1 bonus shares was issued by the companies. So the shares become double, 34 lakhs. Even then it holds the price of 283 rupees. Then 14th March 16, another application was moved by the plaintiff in connection with the said suit, inter alia praying for protective orders for 17 lakh shares. This Honorable Court, by an order, recorded the assurance given by the defendant that the said shares will not be transferred. Then 31st March 16, extension of assurance. Now kindly see 1st April 16. The validity of the MOU after the extension stood expired. By this date, the personal guarantees of Sri Ram Gopal, Maheshwari and Maruti in respect of MBL infrastructure had been duly discharged. What you see the right-hand side, details have been given in para 8 of the affidavit. No, I will place that. Even then, 141 rupees, and shares are double, not performing. Then comes 22nd April 16, continuation of the interim. Now see 13th May, page 161. 13th May. This Honorable Court by an order has been inter alia pleased to direct maintenance with the bonus shares. Now I want to just show this order to your Lordship. Now whether they are allowed to take this kind of an about turn. Oh, Lordship, very well. I will just place this now. Maintainability was challenged by defendant. In other words, the defendant, even during the pendency of the suit, had not only refused to discharge the MOU, but also contend the suit is misconceived. Share price is still holding, well, it is 4 times, 62 rupees, become double. So then 14th June, Honorable Court, based on the joint submission, extended order status quo till transfer date, MBL price is holding. Kindly come to 29th August 16. 29th August 16, Honorable Court disposed of the interlocutory application filed by the plaintiff respect of the said bonus share by extending the order of injunction till disposal after rejecting the issue of maintainability raised by the defendant. It is pertinent to note that by way of this order, this Honorable Court had granted liberty to the defendant for seeking variation or vacating of all the subsisting orders in the suit. Such opportunity, however, was not availed. Kindly see this order at page 169. Now, can they, after all, we have not lacked candor at least. We have said we do not want to perform the agreement. Kindly see this page 169 of the petition of the petition GA4. Yes. This was the stand taken by my learned friend at the hearing for Justice Banerjee. See the second paragraph. The defendant seeks to raise several grounds, including that the suit is not maintained. Relevant agreement is unstamped. And the transaction pertaining to 70 hit by Security Court Regulation Act. Plaintiff has honored his part. So now they want this agreement to be performed. On the previous, and then this order is continued. I'm not placing the reasons in the order. And I should see 171, third page of the order, second paragraph, last 3 lines. It will be open to the defendant to apply for vacating the subsisting interim order and the order proposed to be passed herein, whereupon such grounds can be looked into. So even then, the share price was prevailing higher. Now, Lordship, kindly come back to my list of dates. Serial number 17, page 7. Kindly note one thing from April 16, time expired. If they felt I was not performing, their right to come to court has become time barred in 19. Page 7, serial number 17, page 7, 30th March. But order by the National Company Law Tribunal, MBA was admitted to CIR in terms of provisions of insolvency. Naturally, share prices have came down 46. Now, 1st April 17 and 14th April 17. Only after the company MBL was admitted to CIRP and consequent drastic reduction of share price of MBL, the defendant offered to complete the transaction. Lordship, may I just show this letter at page 179 and page 179 of the petition.
Yes.
Yes. Kindly note page 179, that second last paragraph. Even though the order of 29th August 16 has allowed us to seek a variation or vacating of the subsisting orders, we have, based upon your assurance, waited till date for the execution of the transaction as per the order. Suddenly, an invalid transaction, unstamped, barred by, without prejudice deposit, conditions to settle the matter, once again request you to complete the transaction immediately. This is also in April 17. Kindly turn the page, 14th April 17, page 180. They have repeated that once again. Even then, why did it not come to court for variation of that? When we were not willing to.
No, this letter was given to you.
Yes, they wanted us to perform the agreement in April 17 when the price had come down.
Correct.
We said no to it. We were not agreeable to it.
Where is your reply?
Page 181.
It's the shares. Without pledging the
So even then, Lordship, kindly see page 181. Please refer to the MO and its amendment on our application for performance. It is denied that there has been any delay from our side in completing the transaction. Kindly depledge the shares and inform us that we are able to know that you are able to complete the transaction.
That is 6.2.
That is 6.2.1. Kindly see their response on 10th May, page 182. Second paragraph. You are very well aware that 5 lakh shares were pledged. Of course, I am aware. That's why the clause is there in the MOU. Pledged by us as collateral to avail certain banking facilities by our group company. It's not possible for us to depledge those shares at present. We are also not able to replace the said pledged shares by way of pledging any other asset. However, if you could include the transaction for 24 lakh shares, so they double it, 17 lakh, which are free, the proceeds thereof will be expeditiously used for depledging the pledged shares of 10 lakh, and the same will be offered to MBL. What is surprising that you at least bothered, that you're least bothered to purchase more than 24 lakh shares that are lying with us, so that we can complete a major portion of our agreement. We apprehend that you are not serious in completing the transaction. You once again requested to. Well, may I pause here for a moment and ask myself, they have themselves said that, as Lordship has seen page 179, second last paragraph.
Yes.
Even though the order of 20, the second last paragraph, 179, even though the 29th August has allowed us to seek a variation of vacation of the order, we have been upon your assurance, waited till date for the execution of transaction. Now, we have then categorically said that unless you comply with the terms in toto, we are not willing to at that time. Why did they not come to court for vacating the order? They never came to court. And also, Lordship notes that they want us to buy all the, 34 lakh shares minus 5 lakhs multiplied by 2 because it become double bonus shares. So 5 lakh pledged shares become 10 lakh pledged shares. Now, they all were also wanting us to buy all the shares at 62 rupees per share. When the bonus shares were very clearly, that was that for that they're not supposed to get. They're supposed to get 62 rupees for the 17 lakh shares, which if after all they have to be pinned down to their agreement obligations. If they had transferred in 13, 14, 15, I would have got those shares for 62 rupees. Bonus shares would have been mine, and I would have reaped the benefit of it. They did not give the shares. Bonus shares, they took the bonus shares. They denied the agreement. All the while when the price was high, the price dropped. That to them the audacity to say you perform the agreement, but in my own way. I will not pledge or depledge the shares. You buy part, then you pay separately for the bonus shares. So what you see is now serial number 20 to 21, there is a huge gap of 4 years. 4 years. 4 years, there is a huge gap between 20 and 21. 21 is the next date. The remaining one bank, one personal guarantees they had, I got released even then. 21, 7th April 21. Pursuant to an order of the Debt Recovery Tribunal, Delhi, in a proceeding being OA so-and-so, Maruti Maheshwari's personal guarantee given to Bank of India for loans of ARP was released against full payment by ARP. ARP infrastructure is deduced. So that last guarantee of debt, I got it released in April 21. And August 21, he got back his title deeds. And then 18 June, the resolution plan has been approved. I have got back my company. I have settled with all the banks. I've got back the company.
Yes.
Now, Lordship will see 2024. 17th September 2022 and 20th December 2022. Lordship kindly takes a look at these letters. 183, it starts. 5 years from 2017.
Yes.
Lordship kindly takes a look. Kindly come to page 185.
183.
183 it starts. Kindly come to 185. Paragraph 7.
Yes.
Once again, even 22. You are very well aware that 5 lakh equity shares were pledged by us as collateral to avail the banking facility. Not possible for us to depledge those shares at present. That is, we are also not able to replace the said pledged share. Now, see, last time, as the circumstances thus stand, the company once again calls upon you to purchase the 34 lakh shares held at such price as agreed under the terms of the MOU. So they seek specific performance in the year 2022 of an agreement which is expired in 16, which I refused to perform it in their way. They wanted it in 17, and they seek specific performance in 22. Had I not withdrawn, my Lord should take it like, had I not withdrawn the suit, what would have happened? Could they have and simply not proceeded with the suit? Had I wanted to play sharp with the court, I did not proceed, but I let it remain. It would get dismissed for default one day. Could they have in that suit asked for specific performance in the year 23? No. At the most, they could have.
Yes.
What could they? Instead of playing straight and asking for withdrawal, if I had indulged in sharp practice and not just withdrawn my advocate, what could they have done? So can they take advantage of the fact that I simplicity came to court and asked for withdrawal of the suit? Their claim is wholly time barred. Any ways you look at it, they have played fast and loose, approbate, reprobate agreement. They even 22, they were not willing to perform the agreement in its terms, pledge shares, they had difficulty. That's their bad luck. But then if you the agreement says first you depledge, then you offer. If you can't depledge for whatever reasons, you can't ask the other side to perform. So well, this is the position in and now Lordship kindly comes to page 192 of this. Page 191, the prayer starts. This is the application they filed in March 2023. An order directing transfer of 12 lakh shares without a counterclaim, without any claim in the suit. Can 12 lakh shares?
This is an interlocutory application.
Yes, interlocutory application filed by defendant, asking for substantive relief for payment without making a counterclaim. For paying 15%, so I have to pay them 15.30 crores. That's double the what is the agreed consideration, because multiplied by 2 shares. 24 lakh shares also. So not all the 34 lakh shares. Then Lordship can see spread B. Alternatively, registrar be directed to execute necessary documents for having the decree in terms of prairie.
Yes.
Without any counterclaim or substantive relief by an interlocutory application. Counterclaim would have been barred. If counterclaim is barred, then an interlocutory order in aid of counterclaim will be more than barred. This is the application. They, for the first time, they seek vacating of the order. Press C, page 192. Then thereafter, we withdraw the suit on 28th of March. Page 245 is my lord's order.
So this application was served upon you?
Yes, this application was served upon us sometime in first week of March.
Now, when the suit was withdrawn?
Suit was withdrawn on 28th of March. Before that. Page 245. As I'm saying, if instead of withdrawing it, making it clear I'm not willing to perform the agreement anymore, had I left it as it is, I would have resisted the application by saying that there's no counterclaim. How can you get this order? Application would have gone matter of course. And then what would have happened? My suit would have been dismissed. Page 245. Your Lordship's order. 246. How can he raise this? Counsel for the defendant raised objection and submit the plaintiff with open interim order due to which defendant is not in a position to sell the shares, due to which the defendant has suffered loss. As such simplicity, this court cannot pass an order for withdrawal. This court finds that the plaintiff is not interested to proceed with the suit, and as such, this court has no option but 12.
Yes.
16, the agreement comes to an end. 17, I refuse to perform it the way they want to, that is without depledging the shares, etc. 17 to 23, they don't seek performance, and then how can you force me to proceed with the suit so that you can file a time-barred counterclaim? My pendency of my suit, would it have, just because suit is pending, could they file the time-barred? So, because counterclaim is as good as a suit. So, if a counterclaim is barred, suit will also be barred, or vice versa. So, this is the factual position. And then in July 23, they really, restitution is once again similar to that GA which they had filed for specific performance of the my lord, this is the factual background of the case. Now, my lord, I'll have to go into the legal part. So today or any day, Lordship, because I know Lordship list is heavy, I'll need one more day to do with the judgment, because I have some judgments to cite, and 1 or 2 more days I shall need for the. But this factual part was very important for your Lordship to know the facts. Otherwise, in my humble submission, Lordship, just being told that that I got the order and then withdrew the suit, that is not the case here. Within 2016, number of time while the agreement was valid, I kept on asking him, perform the agreement, and they fight for tooth and nail. It's an invalid contract, barred by security contract regulation, barred by Stamp Act. And now this, now they want the same agreement to be performed after it's become time barred. Well, Lordship, now or whenever Lordship says we can do it one more day, Lordship, I give for the law, because Lordship.
Yes. Concession suffering for the plaintiff, concession suffering for the defendant. Defendant has filed an application being GA4 of 2023.
Yes,
2023. Praying for recalling of the order dated 28 March 2023. 28. 2023. Counsel for the defendant, counsel for the plaintiff has argued at length, and the defendant. Counsel for the plaintiff has argued at length, but due to paucity of time, hearing could not be completed. He will chief. So who has filed an application? First, defendant GA4. This is the matter. Give the date. Next Thursday. What is 11 July? 11 July, 3 p.m.
12th is possible by any chance? 12 or
12th is
we
Friday.
just now had one matter fixed before the division bench at
19th at 19th Friday. The commercial 19th.
Great.
But can two dates be fixed, my lord, so that we can also on the next day reply and close it?
Give the other date, another date is there.
3 p.m.
19th and 25th
at 3 p.m. Very well.
Call the next.
Lordship, I am for the plaintiff. Sole defendant has died in this matter. On the last occasion, they have handed over the legal names of the legal heirs of the deceased defendant. We are taking steps for the substitution. We need 2 more weeks to complete the process, Lordship.
2023 died.
No, Lordship, it was intimated on the last occasion.
Yes.
On 19th June, Lordship, they have intimated us.
June. So what do you want?
2 more weeks, Lordship, to complete the process of substitution.
Concession suffering for the plaintiff. Counsel for the plaintiff prays for 2 weeks time to take appropriate steps for the interest of justice. Case is adjourned. Release the matter on 25th of July 2020.
I'm great.
Item number 11.
Mr. Ghosh. He stated something, na? Manju Agrawal. What's he said? She will not be available. Not this.
I for a defendant, my lord. For the petitioner, my lord. On the last occasion, my lord, I said we got a news that the plaintiff has expired.
Plaintiff?
Yes, my lord. We are for the plaintiff.
So
now we have got a certificate.
When she died?
11th of May.
May, June. This year?
Yes.
May, June, July. Today we are on? Time is going to expire. Like otherwise, it will be abated.
90 days.
Counsel for the plaintiff submits that the sole plaintiff died on 11th May 2024. Full stop. And prays for time for taking appropriate steps. Let the matter go out of the list. Liberty to mention.
Grateful, madam.
Item number 13. Item number 13.
Passing in a computer. Nobody is there. Not today. Next.
Item number 14.
Lord, I am for Lord, respond number 2 and the Lord, the legal layers of respond number 3, Lord.
Your Lordship, I am appearing for the petitioner. On the last occasion, we were given a letter saying the legal layers of respondent number 3. So, Your Lordship, I filed a substitution, but the service is still not complete since the
You are
addresses are
appearing for
for the petitioners.
plaintiff,
Yes, Your Lordship.
petitioner.
Yes, Your Lordship.
Lord, this is an application, Lord, under Official Trustees Act, Lord. Lord. Certain,
You
Lord,
filed an
applications.
application
Yes, Your Lordship, for substitution.
of the respond number 3.
3.
Legal
But-
layers.
Yes, Your Lordship.
So copy not served.
Yes, Your Lordship,
We
the
have not
service
been
is
served.
not yet been completed. Meanwhile, Your Lordship, yesterday I was served by an application GA2 by a third party. So, Your Lordship, that is also listed today.
Lord, this is an application, Lord. I think, Lord, purporting to be, Lord, filed by the Lord Sebaits of Lord the trust, Lord.
So, Your Lordship, I want to file an affidavit in opposition
Who
to
has
that.
filed the
as well.
J2?
Lord, some of the Sebaits, Lord, for Lord.
Lordship, it's a
You are
third
appearing.
party.
You are appearing.
No, Lord. I have also been
I
served,
have
Lord.
also been served yesterday only.
Who is appearing?
Lordship, I think nobody is appearing today, but
What is their objection?
they also want to be added as parties.
They are also the Sebayats.
That is what they are claiming, but I want to file an affidavit in opposition to that.
Nobody is here.
Nobody is, Lord, appearing for the Sebaits, Lord.
Sense appearing for the petitioner. You are appearing for?
Lord, I am for, Lord, the respond number 2 and legal layers of respond number 3.
So you are appearing for the respond number 3.
Legal is, Lord.
Sense
Isn't it?
appearing for the respond number 2 and the
Legal
legal
layers
layers of the
respond number
respond
3.
number 3. Full stop. Counsel for the plaintiff petitioner submitted. The petitioner has also already filed an application for recording of the death of the respondent number 3 and to substitute the legal layers of the respondent number 3, but that is not listed today. And she has also not served the copy to the other side. Full stop. It is fine from the record. When another application has been filed by one Govindo Mullik, Mullik. Govinda Mullik, but none appears on behalf of the petitioner in connection with J2 of 2024. Full stop. Counsel for the petition prays for time to file affidavit in opposition. You will also file.
Lord, leave may be given.
Counsel for the petition, the counsel for the respondent number 2 and the legal layers of the respondent number 3. Prays for time to file affidavit in opposition in connection with J2 of 2024. Let affidavit in opposition be filed within 2 weeks. Reply, if any, there to be filed within a week. This is the matter on.
You asked for service.
On 7th of August 2024.
Grateful, Your Lordship.
Next.
My lord, 13, my lord. Lord, item number 13. And I was missing the another footnote.
13.
13. Item number OD 13.
What has done?
My lord, pursuant to my lord's direction.
Yes. Not today, not today.
Item number 15.
Lord, I appear for the plaintiff, my lord. On the last occasion, my lord, your lordship has directed me to file an affidavit, my lord. There was some issue with regard to, my lord, confusion with regard to, and that has, my lord, I have filed the affidavit, my lord.
Your Lordship, I am
served-
appearing on behalf of the defendant. I am being led by Mr. Rohit Banerjee.
Yes, my lord. If your lordship see, my lord, your lordship's order dated 13 June 2024, my lord.
Yes. You are for the?
I am for the plaintiff, my lord.
Yes. Then
my lord, pursuant to your lordship's direction, my lord, I have filed the affidavit, my lord, indicating, my lord, the grounds are at page 4, paragraph 4, 5, my lord, and my lord 6. My lord, some confusion happens with regard to, my lord, the word admitted. My lord, we have the plaintiff, my lord, the communicated, my lord, the order on 22nd of March, which by UEFA email. On 6th, my lord, page number 6 is the affidavit, that is the email. And my lord, that my lord, the communication which my lord caused, my lord, was subsequently done, my lord. But however, in all those communications, my lord, the either my lord the server copy or my lord the certified copy or lordship's order was annexed, my lord. My lord, there is your lordship's order on my lord 21st of March says, my lord, the suit is admitted. So, my lord, it was, my lord, since, my lord, this is a different country and, my lord, the client was not able to, my lord, understand that, my lord, there is an order of has been passed. My lord, after, my lord, understanding, my lord, we have also taken out, my lord, has taken out an application, my lord, on 18th of June, my lord, before the Superior Court in California, my lord, stating the correct fact that the suit has been admitted, but, my lord, no order of injunction has been passed. That is at page 7, my lord. This was taken out on 18th of June. Page 7, my lord. This is the application we have taken out after, my lord, all this has happened. My lord, you'll see, my lord, in that applications, we have indicated paragraph 7, 8, and 9, my lord, at page 8. At page 8 of the affidavit, my lord. If I may read, my lord, this was a mistake due to the misunderstanding. Paragraph 7, my lord. My lord, the earlier communications, my lord, first.
Your Lordship,
Lord,
the
I have
affidavit
also,
has been served to us yesterday, and my client stays in USA, so we need to take instructions
Do
from
you think
her.
the client is proceeding with the suit?
yes, my lord.
Lordship. Your
That is
Lordship, however, on the last, order dated, your Lordship's last order, 13 June 2024, the last pair of your Lordship's order wanted to comply with the order dated March 21st, 2024, where you asked the plaintiff to serve the summons and the applications to us. But till date, we have not been served the plaint to comply with the order dated 21st.
My lord, there was no direction to serve applications. We were, my lord, they were not on caveat. We were trying to move this application expert. They appeared, my lord, this communication was given. My lord, I have now, my lord, pursuant to your lordships, my lord, I have, my lord, made this affidavit, my lord, indicating, my lord, what was happened, my lord, and in this application also, I have prayed for, my lord, unconditional apology. Now, my lord, the difficulty is, my lord, her client, my lord, is proceeding with the suit.
Whether you have taken this.
My lord, I am taking the steps. It takes certain time, my lord. But however, my lord, may I just humbly submit, my lord, my lord, writ of summons, issuance of writ of summons, my lord, and an application of hearing, my lord, doesn't stand in the way, my lord. My lord has seen, my lord, after, my lord, the suit being admitted, my lord, we move an application. Had there been a caveat, my lord, I could have understood, my lord. There is no caveat. Today,
That is
But
yes, my
Lordship,
lord, I
your
am.
orders, but Lordship, your order clearly
Yes,
states
that-
that the
Yes,
plaintiff was
yes.
Admitting the court has
Summons has to be issued, my lord. For that, my lord, there are certain procedure in the department. The suit, the plaint has to be scrutinized, my lord, and then only the writ of summons would be issued. But since in the interim period, my lord, they were proceeding in the, my lord, the suit. Whereas, my lord, I have filed the suit in West Bengal in a earlier way. We are taking steps in the affidavit also, my lord. We have stated, my lord, that I, pursuant to your lordship's order, I am taking steps so far as, my lord, the writ of summons. Now, today, my lord, I was seeking, my lord, I have, my lord, complied with your lordship's order, super as it. And second part, we are taking steps. Let them, there be at least a statement that they will not proceed, my lord. If they proceed, because I cannot participate in USA because there is already a restraint order against me.
Yes, madam.
Your Lordship, I am being led by Mr. Rohit Banerjee. I am kindly asking for the day as he is not available. But Your Lordship's last order
You are
states.
proceeding the matter before the California court.
Yes, Lordship.
Can be India suit, first India suit, then the California, whether the California suit can continue.
But
on the last occasion, they have made some mistake. This court has not passed any order.
Yes,
Now they
Lordship.
filed the affidavit. The affidavit has been served to you.
Yes, Lordship.
So
But Lordship, your orders also direct them to serve the summons also.
that's correct. That the court will
But-
see. That the court will see with regard to the other part.
As per court directions, we will take appropriate steps there also.
Who?
In the California court, before the California
What
court.
is the stage in the California court?
Your Lordship, I will
Not
have
aware.
to take instructions from the client. We have just received the.
If the California court will issue notice for appearance, what can be done?
It has been issued.
Then. And you know that this is the first suit of the Indian court.
Yes, Lordship.
Well, they in the California, they have filed two suits, one for the child custody, one for divorce. In both the suits, the notice have been issued.
Lordship, we will take the instructions immediately, and kindly you can keep the matter tomorrow or in the next week as per your Lordship wishes. Meanwhile, Lordship, kindly allow us to file Wakalatnama also because they have not served us the summons.
So appearing for the plaintiff, so appearing for the defendant. In compliance of the order passed by this court dated 13th June 2024, the plaintiff has filed the affidavit. After serving the copy to the learned counsel for the defendant, let the same be kept with the record. Counsel for the plaintiff prays for time, and counsel for the defendant submit that the arguing counsel is not present today and prays for time. Accordingly, the case adjourned. Let the matter appear on 11th July.
11th July.
Next.
16.
Dada.
My lord, before your lordship calls up 16, my lord, may I seek one small indulgence, my lord? In respect of item 13, my lord, your lordship, on the last occasion has directed for a paper publication in respect of a property which is to be sold, my lord. My lord, I have seen the paper and I am the prospective buyer, my lord. I have come, they were not there at the time, my lord. That's why, my lord, I am ready to match the price which here they have, which is there in the paper publication, my lord.
Who are you?
My lord, I am a willing purchaser of the property, my lord.
Proposed purchaser?
Yes, my lord.
Who is the petitioner?
They were not there. That's why, my lord, I could not appear because they were not there at the time of call, my lord. If your lordship kindly takes up 13 once, my lord.
Okay, let's come on to Wednesday. Come on Wednesday.
Very good.
It will be taken on Wednesday.
Very good.
Come on Wednesday. Yes.
Item 16. I have filed the suit, my lord, for some lent and advanced and thereafter not repaid. Your lordship had directed me to serve once upon the respondents. I have served them. This is the affidavit of service.
Nobody is appearing.
Nobody is appearing, my lord. Either, my lord, directions be given or
sole defendant.
Sole defendant.
This is J1.
J1, yes.
What about the suit?
The suit is
Not writ of summons was served? No.
It's been served.
What is the status of the suit?
This has just been filed, my lord. Writ of summons have been served. They are not appearing. They have not entered appearance. They have not entered appearance, my lord.
Have you obtained report? Because otherwise I will take the suit and both things. If they are not appearing, then I will take the.
Possibly, my lord, unless the time period from writ of summons.
That's why I wanted to see. When the writ of summons was lodged, when it was served.
17/5/2024, my lord.
So time is within the court. Within the jurisdiction, outside the jurisdiction.
My lord, they are in
AGC
AGC Bose Road. So they're within outside the jurisdiction. It's on the other side of
20
the.
days.
Should I serve them once and come
You
back?
do one thing, you obtain the report. I am fixing after a week. You take and I will fix suit as well as the both application. If they are not appearing in the suit also, in this you already filed the affidavit. So this matter will be taken either judgment on admission or whatever it may be.
I'm so grateful.
So appearing for the plaintiff, none appears on behalf of the defendant. Plaintiff has filed the affidavit of service showing that the copy of the application being J1 of 2024 was served upon the defendant, but none appears on behalf of the defendant. Let the affidavit of service be kept with the record. Full stop. It is fine from the record. Today only the interrogatory application is appearing, but the suit is not appearing. Let the office is directed to place CS record of CS1 number 137 of 2024 along with J1 of 2024 before this court on 17 July.
17th, my lord, maybe it's Muharram, so I don't know whether it's going to be
18th.
Great.
The ghost was mentioning with regard to stay.
Item 18, I have an injunction application. It's a very short application.
Come, Wednesday. Now the appellate side.
Lordship, only difficulty, I'm not there from the next week. Only difficulty that I'm not there from the next week. I have some personal difficulty. I'll not be there for 2 weeks.
Send any junior. Send any junior, I will. Yes, call. Appellate.
Your Lordship, before your Lordship takes up the list, may I be permitted to mention a matter? I mentioned it yesterday. It's Gurbakh Singh versus.
Please wait. Please wait.
Okay, your Lordship.
Yes. No. This is mentioning. Yes.
Yes, your Lordship. It's in the matter of Gurbakh Singh. It's a WPA 1219 of 2023. The matter was heard at length and the next date of hearing was set at 11th of July. But the conducting counsel has some personal difficulty, so if your Lordship may fix another date for the hearing.
11 July it is fixed.
Yes, your Lordship. Actually, the conducting counsel has some difficulty on that day. If your Lordship may direct on some other day or not, Lordship.
So come on 18.
18 July. Grateful, your Lordship. Yes.
My lord, in regard to item number 36, my lord, there are, my lord, two.
Just a minute. AC Babu, that matter na Gurbakh Singh. Instead.
Lordship, it's 1219 of 2023.
That may fix on 18, not 11. Yes.
My lord, in regard to item number 36, my lord, there are.
Which one?
My lord, item number 36 of this, my lord.
36?
Yes, my lord.
This
My lord, there are two GA application, my lord.
This is the appellate side.
My lord, that.
Original side is over.
My lord, that's why I'm mentioning, my lord.
Yes.
My lord, there are two applications, my lord. But however, my lord, only GA2 is appearing on the list, my lord. My lord, GA1 is not appearing, my lord. My lord, I'm humbly praying so that the GA1 will also appear at the same time, my lord.
But I cannot take note because my all officers are original side. See on Wednesday if it is not listed. Yes, call the list.
For the Howrah Municipal Corporation.
I am for the petitioner in this matter, my lord. My lord, in this matter, my lord, petitioner complaints of unauthorized construction of.
You are for the petitioner?
I am for the petitioner.
Yes.
The petitioner complains of unauthorized construction of two buildings in Howrah area.
Correct.
Both the buildings are constructed without sanction plan. Petitioner made representation. Since the representation was not considered, I moved an application, writ application before this Honorable Court. Honorable Court disposed of this application with a direction to the city architect, Howrah Municipal Corporation, to consider my representation, and after giving an opportunity of hearing all concerned. Hearing was given, and final order was passed by the chief architect. In the order of the chief architect, the chief architect unambiguously ordered that both the building are constructed without sanction plan. Therefore, my lord, I draw your lordship's kind attention to page, my lord, 29 of my writ application.
Page 29.
Operative part, 29 of my writ application, my lord, operating part. It appears. It starts from it appears from record. Page 29.
Yes.
It appears from the record that an alleged unauthorized construction of a 4-storied building is constructed by respondent number so and so, admitted by the respondent during the hearing.
No. Which page 29 of the writ petition?
Yes, my lord.
There is a writ petition.
Your lordship may take up my amended application.
Amended application. There is a difference.
On the last occasion, I have filed this.
Yes. Page 29.
29, my lord.
Your pagination is so.
Inner page 4.
Yes.
It appears from a record that an alleged unauthorized construction of 4-storied building is constructed by respondent number so and so. It is admitted by the respondent during hearing. Hence, it is admitted fact that the alleged unauthorized construction is made without sanction plan and violating notices issued by Borough Office and Building Department of Howrah Municipal Corporation. So, the alleged unauthorized construction cannot be retained.
Correct.
Hence, it is ordered that the private respondents are directed to demolish the impugned structure within 15 days from the date of receiving this order, and if fail to comply the order in stipulated time, otherwise building department will take all steps to demolish the impugned structure at the risk and cost of the private respondent. This is the clear order of the Howrah Municipal Corporation. My lord, similar order was passed in respect of another building. My lord, page 33. It is in respect of another building. 2 buildings were constructed without sanction plan and it is unauthorized. Both are unauthorized.
Yes.
And chief city architect direct the parties to comply with the order to demolish the self-demolition, and if fails, and the chief architect, the building department will take steps to demolish the building is still standing there. Both the buildings are standing there. No.
Whether this respondent 5, 6, 7 are the parties?
Yes.
In the writ petition?
Yes.
Who are they?
My earlier occasion they appeared. My lord, as per direction of this honorable court, my lord, I have served.
Nazir Ahmed.
Yes.
Rafiq Ahmed, Nazir Ahmed. Nizar
There are
Ahmed.
so many.
5, 6, 7, 3 persons. Then
thereafter, my lord, I have communicated the order, but order was not complied.
When
So
the order was passed, what is the date of the order?
city architect.
Ah.
My lord, city architect 2000 in the year 24/7/2000.
2000.
2000.
Correct.
And then, my lord, I have
What has
communicated the order.
Then what has happened?
Yeah, my lord, nothing has been, no steps have been taken by the Howrah Municipal Corporation to demolish the building.
Have you filed the, what is your prayer in the writ petition?
Writ petition, my lord, very writ petition that a writ in the nature of mandamus commanding the respondent authorities, the Howrah Municipal Corporation to demolish the impugned unauthorized construction at premises number 19 and 29 Roson Goldar Lane 24 in terms of the direction of city architect, chief architect, Howrah Municipal Corporation contained in order dated 27/2000.
So till date it has not been passed. Howrah Municipal Council, and what is the 2002?
2002.
This court has also passed an order.
Yes.
Where is that?
For implementation of the order.
Where is that?
My lord, this is the order. My lord, kindly have a look to my lord. Page, my lord,
40.
40. I direct the Howrah Municipal Corporation to implement the said order, unless in the meantime the private respondent brings any stay order from the competent court of.
Yes, who is appearing? You.
But I'm for the Howrah Municipal Corporation.
What
my
is
lord, no, till date, my lord, no instruction we have received. Also, my lord, here it is of the notice is of 2000 and 2003. Maybe it's a very old matter, and that's why my submission is that let a fresh direction be passed by this honorable court, and after that, the
First direction, I am passing an order.
Yes.
Who is the authority? Mayor, chief architect officer, assistant engineer,
Yes,
councillor.
ma'am.
Who is the authority for demolition?
But here,
Chief architect officer, architect. He has passed the order.
assist under the
Chief architect has passed the order.
then
Chief architect has passed the order, and
copy of the order will be communicated to the petitioner. Hence, the order to private respondent or director to demolish. How you can say they are the private respondent? Where is the name of this private respondent? They are the same persons.
Same person.
How you can say?
My lord, this is in the cost title.
No, not cost title, in the order.
the order
which you-
Or yes, my lord, chief architect's order, my lord.
Acha.
Respondent number 5, 6, and 7.
5, 6, and 7.
Uh-huh.
But kindly come to your 5, 6. Who are the 5, 6, and 7?
5, 6, 7, my lord.
5 is the officer in charge. As per your writ petition.
Alleged unauthorized construction.
Kindly come to your writ petition cost title, sir.
Yes, my lord.
5 is the officer in charge.
5 is the officer in charge.
5 is the officer in charge.
6 is the Samim Khatun.
Yes. When a private respondent is my lord. It is
7,
their
8.
order, my lord. This is the order of the chief architect.
So these are the 7, 6, 7, and 8.
Yes, my lord.
6, 7, 8.
6, 7, 8. And 7, my lord, 7 died. In adverse, my lord, I have
6 died.
6 died. 6 died, my lord. In his place, my lord, I have.
Correct. So as per your submission, in this 5, 6, 7 or is the 6, 7, 8.
Yes.
They are the
my lord, my lord.
Yes, madam, I am calling for the report whether it has been not been demolished within 1 month and to submit the report.
My lord.
Demolition report is to be submitted.
My lord.
Who is the authority? Chief architect officer?
Right now, all this demolition order are being carried out of the assistant engineer, but
Assistant engineer will carry it out.
yes,
the
but last order was of the chief architect.
officer.
Yes.
3. Respondent number 3.
So and so appearing for the petitioner. So and so appearing for the Howrah Municipal Corporation. None appears on behalf of the private respondent. Full stop. The petitioner has filed the present application for a direction upon the Howrah Municipal Corporation to demolition of the unauthorized construction in premises number 19 and 29, Rosan Golder Lane, Ward number 20, PS Howrah, District Howrah, for complying the order passed by the Chief Architect Officer, Chief Architect, Howrah Municipal Corporation, dated 24th July 2000. Full stop. It is fine from the record After the order passed by the Chief Architect Officer, Chief Architect of Howrah Municipal Corporation, the municipal authorities, the municipal corporation, Howrah Municipal Corporation has not complied with the said order. Accordingly, the petitioner has filed a writ application before this court, being WP number 4299 within bracket W of 2002, and the said writ application was disposed of by this court on 8th of May 2002 by directing the Howrah Municipal Corporation to implement the said order, unless in the meantime the private respondent bring any stay order from the competent court prohibiting such demolition. It was further directed that such demolition must be effected within 1 month from the date of communication of the order. Full stop. By a communication dated 23rd of December 2003, the petitioner has communicated the said order to the municipal corporation, but in spite of the order passed by this court dated 8th May 2002, the Howrah Municipal Corporation has not complied with has not demolished the unauthorized construction by implementing the order passed by the Chief Architect Officer and by complying the order passed by this court dated 8 May 2002. And as such, the petitioner has filed the present application. Full stop. Consider the submission made by the counsel for the respective parties. Peruse the materials on record. This court find that consider the submission made by the counsel for the respective parties and peruse the materials on record. Full stop. The respondent number 2, the Chief Architect, Howrah Municipal Corporation is directed to execute the order dated 24th July 2000 by demolishing the unauthorized construction of the private respondents within a period of 1 month.
But kindly little bit longer period
Within a period of 1 month from the date of receipt of this order, and to file the report before this court on or before before this court on 8th of August 2024. List the matter on 8th August 2024. The petition is directed to communicate this order to the Chief Architect Officer as well as the Mayor. Mayor, Howrah Municipal Corporation for compliance.
I am grateful to Lordship.
Full stop. Record and order. It is fine from the record. The matter was taken up for hearing on 20th June 2024, but in the order dated 20th June 2024, the number of the case has been inadvertently recorded as WPA 16640 of 2023 instead of 16640 of 2003. Accordingly, in the order dated 20th June 2024, the case number shall be read as WPA 16640 of 2003. Next.
Number 2.
Yes. Complied.
Good. long back it was complied partially. Subsequent thereafter, my lord, the two part of the order is there. First is.
What is the order? Where is the order? Against which you have filed the contempt application?
Page 20.
Page 21.
21, last.
In my view, the impinging order passed by the chairman Malda Primary School Council is not sustainable and what is set aside. Authority directed to take back the petitioner and the petitioner will release all service benefits including all areas forthwith. So he has been reinstated.
Reinstated, arrears, salary has been.
Salary has been given. What about the areas?
Areas has been given.
So
now, my lord, only thing is this: the service benefit includes the continuation of service. That has not been done.
My lord, I appear for the state, my lord. My lord, the answering respondent is the chairman of the Malda District Primary School Council, my lord, who is the alleged contemptor, my lord. No one is appearing, my lord, for the past 1, 2, 3 occasions, my lord, for the Malda District Primary School Council.
Pursuant to your lordship direction, I have served.
no, the affidavit of compliance they have filed.
Yes.
Affidavit chairman.
Subsequently, they stated the rest part will be complied.
Where it is stated.
They were granted time.
According they were compliant with the order passed by this court, though there is some delay in complying the solemn order, which is absolutely unintentional. The prate for considering the above may kindly not to proceed against the defendant. If others say no reluctance on the part of censor, where it is mentioned, it has not been. Has prepared the instant compliance report. No such statement in the affidavit of compliance, sir.
No, in the affidavit of compliance, they have said I have complied.
Complied with.
But in so far the order.
So you are agreed with that, you file a fresh writ application. Yeah, and what is the order?
Benefit.
Area. No, kindly see. The directed to take back the petitioner, he has been reinstated. Correct. Petitioner be release all the service benefits, including all areas forthwith.
Areas have been paid.
Paid.
Service benefit, which includes the continuation of my service. That has to be, my lord.
So that if they have not given the continuation, then you have to file a fresh case.
No, this is violation of this order.
Take back the petition and release all the service benefits, including all areas. That's all. Where is the continuity of the service stated in the order?
Service benefit, which includes the
service benefit, including all release all service benefit. What is the service benefits? Areas, salary and areas. With regard to the whether they are not given the continuity service.
No.
How you can say?
My appointment subsequent to
when you were appointed and which post?
Primary.
Primary school teacher.
Assistant primary teacher.
Assistant primary school teacher.
Yes.
Yes. Then.
And
which year?
2012.
2012.
2014, I was terminated.
2014, you have been terminated.
My lord.
And this order was passed on?
2000.
Automatically it is. If it is, the court has.
2015 order was passed.
2015.
Complied in 2000.
So how you can say that has not been given?
The service book has to be modified. Nothing has been done. For that reason, this contempt is alive. Your lordship asked the last several occasions, Mr. Bari was appearing for the contemptor, alleged contemptor. Now he is no more in the panel. Somebody have been engaged. He on repeated occasion assured your lordship that next part also will be complied with.
So appearing for the petitioner.
Stated.
So appearing for the state. None appears on behalf of the alleged contemptor. Police law. On 21st of March 2024, the alleged contemptor has filed the affidavit of compliance stating that the contemptors have complied with the order passed by this court. The counsel for the petitioner submitted by an order dated 28 April 28, April 2015, this court, while setting aside the impugn order, directed the authorities to take back the petitioner and the petitioner be released and release all her service benefits, including all areas forthwith. Counsel for the petitioner submit that the petitioner has been reinstated in the service and all areas have been released and salary and all areas have been released, but the alleged contemptor has not granted the continuity of the service to the petitioner. This is your case.
Yes. And the service book has to be modified.
And the service book has not been corrected by showing the continuity of the service of the petitioner. Considering the submission made by the counsel for the petitioner as none appears on behalf of the alleged contemptors, considering the submission made by the counsel for the petitioner as none appears on behalf of the alleged contemptor, the contemptors are directed to explain whether the petitioner has been given the continuity of the service and the service book has been modified or not. Let the said report be filed before this court within 3 weeks. List the matter on 25th of July 2024.
Insofar my learned friend's appearance is concerned.
Recorded.
Well, he is not required because he is not a party.
The counsel for the petitioner is directed to communicate this order upon the alleged contemptor for compliance. Yes, next.
Your Lordship, in this matter, I beg to appear on behalf of the petitioner applicant. On the earlier occasion, Your Lordship was pleased to direct to the contemptor to pay the area salary to the petitioner, and they have paid certain amount to him. And Your Lordship also pleased to direct
What is the
hand
order?
over.
What is the order? Where is the order?
To keep the service very strict retrospectively and
The
pay the
petition is disposed of with the direction upon the respondent authorities, particularly the respondent number 4 and 7, to release the approved salary of the petitioner as assistant teacher from 7th September 94 to 14.
Yes, right.
Within a period of 8 weeks on the date of then
They have paid a certain amount, and Your Lordship on further occasion, Your Lordship was pleased to direct them to hand over calculation sheet, and they have also hand over. Kindly look at the calculation sheet also. Your Lordship,
7 September.
kindly check the last column. It is the actual claim. It is amounting of rupees 47 lakhs 12,369, and later on it is written that the past for the total amount is for 47 lakhs 35,149. So this amount should be paid to the petitioner.
47, 12 lakh, 3,000.
Yes. But unfortunately,
salary areas with effect on 7 September as per the order of the Honorable High Court were
But
calculated itna relation to itna. Yes, then
but unfortunately, the petitioner has received on 28th March 2024 32 lakhs 90,144. So it is being paid after deducting the TDS. So Your Lordship, I believe that the TDS cannot be deducted from the area's salary.
in every
That's my
claim,
social point.
this is our usual procedure. In every claim,
It cannot be
release
deducted,
the
Your
salary
Lordship.
after deducting the TDS, because
Cannot be
TDS will
deducted.
automatically deducted, my lord.
From the area's salary, I
It's
believe it
not
cannot.
deducted from on my part, my lord. It is deducted what automatically deducted.
but how? Service benefit, how the TDS will go?
But if they claim by filing respective form in terms of the IT Act, they will return it back. It will automatically return to its credit, my lord.
It's not that easy.
This is the procedure, my lord.
They might not, if they will not, they are not filing the return, what can be done?
But every government employee is supposed to file the return.
You apply for.
Yes, every government
But
employee.
you give the TDS that certificate to them.
We will get it online, Mala TDS. His TDS deduction, you will
Kindly
get
hand
it
over,
online.
kindly hand over on our
That I shall
further
produce. That I
occasion.
shall produce.
Kindly
Produce
hand
it.
over on further occasion.
So what can be done?
But I have submitted all the
kindly-
documents. How many amount are deducted as TDS amount? Every documents I have submitted.
So you apply for.
Kindly keep it pending. Means
Not
if
take as a substance
further
compliance,
when
Mala.
it's
If
being
he has
paid,
any-
when it's being paid, when the petitioner receive the entire amount, your lordship may please.
That documents has been given to him, my lord.
Of the service benefit.
Yes. That cannot be deducted. I believe they have certain
But
judgment also.
every such claim, my lord,
See,
the
see,
government.
See, Mr. Bari, with regard to the service benefit, there is some head.
Yes.
Account head. If it the same go to the account head, that cannot be said to be a TDS. You can deduct the this income tax,
right?
But TDS can't be.
But it is deducted, but not by the authority itself. It automatically deduction.
That's why the might be your authority has given the payment to some other head. Not
No,
to the
but
salary head.
that what is the usual procedure that has been followed?
Not in the salary head.
But what
Salary head might be some other.
Yes, but
Salary
your salary.
Salary head. No, the head, where you have sanctioned the amount on from which account it has been deducted, that might not be in the salary head. If it is a salary head, it cannot be deducted as a TDS.
Yes, man. Our specific government there, it is the TDS after deduction of TDS.
Okay.
It
Cannot
was
be
paid
deducted,
after
yes.
deduction of TDS.
The lordship, it cannot be deducted.
So whatever it is, but they have complied with. If
But the TDS part, your lordship,
that I
kindly
am
keep it.
disposing of, it is your new cause of action you challenge.
It's not your lordship. It's not the new cause of action. Your lordship is allied with this.
Sense appearing for the petitioner, sense appearing for the defendant, respondent, alleged contemptor, full stop. By an order dated, by a judgment dated, this court by an order
6 January 2022.
6 January
2022.
2022, this court directed the respondent authorities, particularly the respondent number 4 and 7, to release the approved salary of the petitioner as assistant teacher from 7 September 1994 till 27th March 2024 within a period of 8 weeks from the date of communication of the order. As full stop. The contemptors have not complied with the order passed by this court dated 6 January 2022, the petitioner has filed the present application. Full stop. During the pendency of the writ application, the present contempt application, the contemptors have released the amount of rupees, have sanctioned the amount of rupees 47,12,369 and given the details of the same to the learned counsel for the petitioner. Counsel for the petitioner submit that though the authorities have sanctioned the amount of rupees 47,12,369, but the petitioner has received only
32,90,144. 32,90,144 after deducting the TDS.
Counsel for the alleged contemptor submits that the contemptors have sanctioned the total amount, but at the time of payment, the TDS has been deducted. It deducted, and after deducting the TDS, the said amount was paid to the petitioner. Considering the submission made by the counsel for the respective parties, this court finds that the alleged contemptors have complied with the order passed by this court by releasing the salary, as the alleged contemptors have complied with the order passed by this court dated 6th January 2022 by releasing the salary and releasing the amount as per the direction passed by this court. As regard the deduction of TDS is a new cause of action. If the petitioner is aggrieved, the petitioner is liberty to take appropriate action and steps in accordance with law. In view of the above, WPRC WPCRC 184 of 2023 in WPA 6798 of 2015 is disposed of. However, disposal of the present present contempt proceeding will not debar the petitioner for taking appropriate steps for claiming the TDS deducted by the authorities.
Deeply.
My lord,
Yes.
this is the original side matter which we have mentioned at
When this is going to expire?
tomorrow.
Huh?
Tomorrow, my lord.
Yeah, give the take the number. Mr. Ghosh is also one of them, same.
Yes, same. I
Yeah.
am appearing with him. I appear for the bank. That matter.
Tomorrow it is going, na? Only one matter. Ghosh is
There were two matters, but the interim order is in the 48, item number 48.
Well, the bank is suffering interim order since long, my lord.
My lord,
Kindly
we
fix
have
that date.
done extensive hearing, my lord, on the last occasion.
कल तो है कल ना commercial है लेकिन इसका extension tomorrow it will be listed as to be mentioned and mention the matter in the morning hours first hour, then I will see. Yes, then I will fix the matter. Pleadings have been completed.
Yes, my lord.
Then I will fix the matter for hearing. But interim order is to be extended whatever.
Short date, kindly fix it short.
Come tomorrow morning.
Much obliged.